Good evening, Senate Committee on State Affairs will come to order. Before we resume our posted business, we are going to take up some pending business. So the chair lays out as a matter of pending business, Senate Bill 38, for reminding me of that. Senator Betancourt, you had explained to us a committee substitute. Has that already been laid out to the committee? Okay, very well. We do have the substitute. Senator Betancourt has previously explained the substitute. It's already before us, but we'll have Senator Betancourt send it up to make sure that's clear. Senator Betancourt moves adoption of the committee substitute, Senate Bill 38, explained to us at the last hearing. Is there objection to adoption of the substitute? Hearing none, substitute's adopted.
Here comes Angela. Right here. Oh, he's over here. Burwell's over here.
Okay. We're good. We got 6.
We actually have 7 now.
And Senator Betancourt moves that the committee substitute, Senate Bill 38, be reported favorably to the full Senate with the recommendation that it do pass and be printed. Senate Bill 38, will the clerk call the roll?
Betancourt.
Aye.
Birdwell. Hall. Hinojosa. Middleton. Parker. Perry. Shortner. Zaffarini. Paxton. Hughes.
Aye. There being 7 ayes and no nays, committee substitute Senate Bill 38 will be reported favorably to the full Senate.
Just
The chair lays out as a matter of pending business Senate Bill 30. It's our intent to resume invited testimony and then move immediately into public testimony. And so we'll call up our next panel of invited witnesses on Senate Bill 30. Where's that? Oh, no problem. Thank you very much. Okay. Hey, Senator. And the chair calls Melissa Casey, Honorable Craig Island, Jennifer Aker, Laura Tamez. Welcome to each one. The author has made sure that we have invited testimony both for and against the bill. So we're going to go for, against. So we won't go quite in order, Ms. Thomas. We're going to skip over you, but we'll start here. Welcome. Introduce yourself and give us your testimony.
Thank you so much, Senators. My name is Melissa Casey, and I am an attorney who has practiced on both sides of the bar for over 30 years. I don't know how that happened, but somehow I must have started very young. I am here to testify in favor of SB 30 because what I see day in and day out is nothing short of fraud. And I know that's a very strong word, and I don't use it lightly. But from someone who practiced for a very large plaintiff's firm here in the state of Texas, I know exactly how this works. I see it every day now on the defense side, and I fight against it. And it's a travesty. It's putting my clients out of business. It's costing, it's raising insurance rates for everyone, not just commercial trucking, but for everyone. And it's increasing the cost of goods and services for the people of the state of Texas. More importantly, the plaintiffs themselves. You've already heard a lot of pontification from the prior panel, and the plaintiff's attorney that was up here telling you about these catastrophic injuries, and they've brought people here who've been catastrophically injured. You know, the chemical burns throughout their body, the leg off amputation case, the death case. I can tell you with absolute certainty that that is the very, very rare case on my docket. And usually those cases absolutely get settled by the insurance company. The insurance companies are not the bad guy. If there's liability and there's damages, they really do want to take care of it. That's what they contracted to do, and that's what they're doing. That's what I've seen. What is on my docket is, and let me tell you, I do all commercial trucking, okay? That's all that I see, is that the value of a case to a plaintiff's attorney is not what the injury is, and in most cases there really isn't an injury, but it's how much insurance money there is. That's the first thing they want to know, and that's what they ask, and that is what they will work up the client's medicals to be, to ask you, to ask a mediator, to ask the jury ultimately. And that is what's driving up the cost of all of this. One quote I would like you to really, really think about and have resonate with you is something that I was told by a former large plaintiff's attorney's office for whom I worked. And that is, they will not let their clients use their own insurance because we can't control those docs. We can't control those docs. And I ask you, why should an attorney be controlling anybody's medical treatment? That is between a person and their doctor, and the doctor who has taken a Hippocratic oath and is there to treat a patient should be doing that completely separate from the litigation process and completely separate from input from a Juris Doctorate who does not have a medical degree. And yet, these plaintiffs' attorneys are being forced to ensure that their clients go see doctors, even when they have insurance. They see doctors that really only see plaintiffs, people who've been involved in some sort of injury. They then require that these treaters continue to treat so that there's no gaps in treatment, even if the treatment is simply an evaluation via teledoc, although we will get a $600 bill for it, I promise you. These plaintiffs have no injury on the scene. The crash report says N when you're asking about an injury. Oftentimes, they don't seek any medical treatment for days, even weeks, sometimes months. Before then, their lawyer sends them to their network of cronies. And I have to tell you, we call it the usual suspects because I have cases all around this state, and yet there are, honestly, 90% of my cases, the films, the MRIs are read by 2 radiologists, 2 of them, all across the state, little suspect, right? I know my time is limited, so I'd like to just hone in on a couple of points, and that is, I'd just like to address a couple of things that were mentioned earlier, that honestly, what we're seeing is treatment that is not needed, right? And the amount that the bills that they're presented to us, they are literally 10 times the usual customary and reasonable rate that I will get from a billing and coding expert to give me separate. And there are things that just common sense can tell you, right? There's a line item where they charge $600 for ibuprofen, $2,400 for a simple neck brace that you can buy at Walgreens for 20 bucks. Okay, it doesn't take a rocket scientist. I know my time is up, but I just wanted you to see this case in particular, I'm supposed to try in May. This was a commercial motor vehicle that was in front of my commercial motor vehicle. And see this dent here? This little teeny dent in the back of a trailer? That case is now being worked up the meds. They're telling me that it is $112,000 in past meds, which my billing and coding expert says is 23, and future meds is $410,000 for 2 surgeries. This is what I deal with every day. It has to stop.
Thanks for your testimony. Senator Perry.
Did you used to work for a trial lawyers group, or
I'm sorry, sir?
who were you employed by when you were working on trial lawyer stuff?
Well, interestingly enough, I was not going to name names, but I actually received a very threatening email when my name came on the witness list today from my former employer, telling me that there was some confidentiality agreement that I was not allowed to testify today or face repercussions. And my point is, why am I being threatened to tell you what's going on if it isn't fraud? If it isn't something that they don't want you to know about and that they are just doing everything right to help these poor injured plaintiffs, then why am I being threatened to testify today?
It's a good question. I won't ask you who because I don't want to get you into another legal mess that's probably one that will protract and take a lot of money out of your pocket, but that's an interesting story. Thank you.
Representative Allen, introduce yourself, give us your testimony.
Craig Allen on behalf of Texas Trial Lawyers Association. Thank you, Mr. Chairman. I'm going to go brief. I'm going to go fast because I have a lot to say in a very short time. I want to talk about a couple of general things and then talk about specific portions of the bill beginning on page 17. First, this bill, its whole purpose is to cap damages in jury trials. It says so by the proponents in the flyers that they sent out last week about the bill. That's its purpose. We knew this at Texas Trial Lawyers, so we conducted a survey in January. We hired a Republican pollster to poll Republican voters and 3R primary voters. And we had focus groups in Dallas, Houston, and Tyler. And the result of that poll, which I think all of your offices have received, but the result of that poll was overwhelmingly that Republican primary voters do not want the government to cap damages in civil trials. They trust the juries more than they trust the government. The second thing that we learned is what we already knew, and that is from the focus group, and that is Trump voters are very good jurors because they don't trust the government and they know the value of life. They know the value of life without pain. They know the value of life without suffering. They know the value of life without impairment and disfigurement. So now let's talk about specifically on the bill on page 17. We hit on it this morning, but it says the government, the legislature, the government is going to punish you if in a civil case if you do not use your health insurance for your treatment. Think about that. The government's telling you that you have to use your health insurance. But you may have a very good reason. Maybe you have a lifetime cap on some of your treatment under your policy. Maybe you have a MedShare Christian health insurance plan and you don't want to have that group of people suffer and pay big bills over the next couple of years while you litigate this case. And maybe your health insurance doesn't pay the doctor that you want to go to, so you got to go somewhere else. There are valid reasons a person doesn't want to use their health insurance in cases like this, and the government shouldn't tell them that they have to. Next, what is pretty remarkable is you have to give access to your entire medical history from the facilities that are involved in your medical treatment on the case. I went to UTM, living in Galveston, I went to UTMB for all of my health care for the last 30 years, including when Dr. Schwartner was there training. All of my medical records there. If I'm in Galveston, I'm walking across the street and get hit by a car like my friend Danielle did on Friday, and I go to UTMB, and then I bring a lawsuit because of that car wreck, you know what comes into evidence? Everything that I've ever been treated for at UTMB in the last 30 years, including my vasectomy in 2000. Now, what does that have to do with the car wreck where I have head and back injuries? Think about it from a woman's perspective. Same thing, if you have all your health and treatment at Scott and White or in some other healthcare system like Memorial Hermann, and you had vaginal personal issues, you had terrible menopause and have all kind of things in your medical records that not even your husband knows, and then you have a back injury or a car wreck, all of that evidence is going to come in, whether it's relevant or not. This bill gets rid of Texas Rule of Evidence 401, 402, and 403 because hysterectomies are not relevant in most personal injury cases, but it's coming into evidence. 30 years of medical records coming into evidence if you go to that same healthcare provider. And since we all have big healthcare systems, all of your records are there, and they're all coming into evidence whether they're relevant or not. we are going to tie, so the bill says that the workers' comp system is going to be evidence and admitted into evidence to show what is reasonable and necessary for treatment. Think about that. Not public data, but government data from the workers' compensation system is going to determine what your treatment plan, whether it's reasonable and necessary. And I don't think that that's appropriate. Finally, this bill tries to, it codifies in the law that says we can't, when we're talking about non-economic damages, that we can't talk about the value of life. That's what we know that jurors, and especially like I said earlier, Trump jurors know the value of life. This bill says you cannot talk about the value of life whenever you're talking about non-economic damages. I have a few other things to say, but maybe we'll get to them.
And we're going to skip over to Ms. Aker, and then we'll come back. So introduce yourself and go ahead, please. We get close to the microphone since you're on the end.
No one's ever accused me of being quiet, so I think I'll be okay. My name is Jennifer Aker. I'm the managing partner of 3 Texas offices for Tyson and Mendez. I've been a trial lawyer for 17 years. 12 of those I've practiced insurance defense in the state of Texas. I'm here today in support of Bill 30 because I believe this bill provides critical processes and amendments that will promote fair trials and therefore fair judgments in the state of Texas. I'm going to first address a couple of things that were just discussed. This bill is not a cap. You've heard it a couple of times today, but nobody's pointed to the line. There is no cap. It does not limit. It gives judges opportunities and requirements, honestly, to be able to explain why non-economic damages should go over certain limits, but it does not give that trial judge any more authority than they've ever had to change the jury's findings. So it is not a cap, and it isn't. Also, several times have been conflated today the role of discovery versus the role of evidence in a trial. Just because something is discoverable, and it states right in our rules of evidence that Texas discovery is broad. Just because something is discoverable does not make it evidence at trial or relevant evidence at trial. That stays within the purview of the judge. This bill does not change that. What this does is it turns on a light to make sure that all of the parties in a lawsuit go into trial with all of the same information, which is the purpose of our system. If you read the Civil Practice Remedies Code, the Civil Code, the Texas Rules of Evidence, what it says is that when you guys get in front of a jury, you both know what the other person's going to say already. You might not know how well they're going to say it or how they're going to make the argument, but you already know what they're going to say. That is the way that our system works. What I'm about to tell you is a bit of a war story. Lawyers love war stories, to try to explain what I'm talking about. So I've got a plaintiff, okay, and this plaintiff is low delta V accident, minor injuries that we're aware of initially, no substantive treatment. Months later, goes and gets treated by this provider that everybody knows. We've all seen this provider over and over. This provider I've seen dozens and dozens of times, and treats the same kind of plaintiff over and over. Low delta V, very little workup, and all of a sudden needs scans, very specific scans, DTI scans, and then has a mild to moderate brain injury. This comes with a life care plan. It also comes with $100,000 to $300,000 in bills, just depending on the workup. I believe that this provider overbills. I believe that this particular provider overbills. I believe that they overdiagnose. I believe that they say they treat, but they're not actually a treater, really serves as more of an expert role, which should change the amount of discovery I'm allowed to do. But I have a hard time proving it. There's no mechanism for it. There's no discovery process in place that requires this information to be provided to me. So what happens is I have a set of 4 or 5 motions that I file in almost every single case. So if, let's say, I have 10 of these at a time, and I file all 5 of these motions in 10 cases, I run down to the courthouse 10 times, or 5 times on each of these 10 cases. I have utilized 50 hours of the court's time to argue about discovery issues just to try to find out the billing practices of this particular provider. That is a week of judicial use every year for every 10 cases. And I have way more than 10. So one day I find out their former office manager is no longer their office manager, and I ask if he would mind testifying, and he agrees. So with sworn testimony, I have confirmed that the invoices were inflated, that the doctor never expected to receive full payment, the doctor never intended to seek full payment. The treating physician relationship ends when the lawsuit settles. That's when the treatment is concluded. It's when the lawsuit settles. It's not when any sort of physical resolution for the patient occurs. I learned that this particular witness under oath told me that on every single case, it is part of his job at the end to negotiate the bill with the lawyer for the plaintiff. He has the ability to accept 40% without even checking with anybody. He has accepted 0% in cases where they either lost or there just wasn't enough settlement money. And there are cases, there are other options all over the board, but 40% was what he was allowed to accept. This is all information that I discovered that doesn't make it admissible. We'll find out if I can find a judge that lets a jury find this out. But this goes to bias. This is the reason that we should be allowed to get this information. This goes to the credibility of the witnesses. And when you become a part of a lawsuit, you put your credibility in issue, and then the jury gets to decide if you're a credible witness or not. That's the purview of the jury, and we're just asking to put that back. Thank you for your time.
Ms. Ager, thanks for your testimony. Ms. Thomas, welcome. Introduce yourself and give us your testimony.
Yes, Mr. Chairman, members of the committee. My name is Laura Tamez, and I am a past president of the Texas Trial Lawyers Association. I've practiced for 29 years as a trial lawyer, and I am here on its behalf and individually testifying in opposition to the bill. So I want to start by thanking Senator Schwartner for visiting with our president, Jack Walker, and I about some of our concerns with the bill, but I want to focus our attention to on Section 8, Subchapter D, the non-economic damages that start at page 20, and our issues in terms of Constitution violation. So Article 1, Section 15 of the Texas Constitution commands that the right to a civil jury trial shall remain inviolate. The U.S. Constitution provides the 7th Amendment, which says that a right to a civil jury trial should be preserved. There are components of this bill that invade the province of the jury, which we find are unconstitutional. I want to turn your attention to the remittitor portion. And remittitor is just a Latin term for to be sent back. And it's essentially a reduction in an award that maybe is not supported by the evidence. There was a case in 2023 where the Texas Supreme Court had to review what it was said to be an excessive award. And that Supreme Court, it ended up being reversed and rendered. So the case was reversed. Rendered means you don't get to go back and get a do-over. But I want to quote what Justice Devine said. But even as we must acknowledge that damage awards may occasionally exceed the bounds of our reasonable expectations, we ought to have faith in the jury system. As part of that system, judges at every step of the way have an opportunity to grade the jury's papers and offer a remedy for excessive awards. And that's key because there is a framework in place that works. The defense lawyers at this table, very capable, are using those tools and those remedies in their courts of appeals. So let's look at the facts and the evidence in the bill, where on page 22, it starts with subsection A, except in an action in which another law limits recovery of non-economic damages. The word limits recovery in non-economic damages means there's a restriction of that amount, which is by definition a cap. And the framework of this bill is telling the judge that if the jury award exceeds an amount, for example, it's got some arbitrary numbers set by, I guess, the supporters of the bill. For example, $1 million in a wrongful death for pain and suffering and emotional anguish. If the award is $1,000,001, then that is subjected to reduction, to remittitor. There's other numbers in here, $250,000 for personal injury. If it's $250,001, that is subject to reduction. These are arbitrary amounts, not rationally connected to any evidence, that are set in statute where a judge is mandated to then be a substitute of the finder of fact, invading the province of the jury by substituting that judge's opinion as to factual and legal sufficiency of evidence. And that is one of the major problems of this bill, is you are setting guidelines and substituting the province of the jury. The remediator that we have in place today is working and is utilized. Any party, a defense or plaintiff, can suggest a remediator and reduce the amount of damages. It just happened in 2025 in the 14th Court of Appeals. There was a reduction of economic damages, both past and future. The trial judge can suggest a reduction of the amount. The Court of Appeals can suggest a remitted amount. The Texas Supreme Court, the ultimate guardrail in excessive award cases, can suggest a remediator and a reduction of the amount without requiring the judge to substitute its opinion. Every jury is told at the instruction, you are the sole judges of the credibility of the witnesses and the weight of the testimony of those witnesses. That is in an instruction. The Texas Supreme Court has said we shall not substitute our fact-finding for that of the jury. So I will end on the last part, which, well, the arbitrary awards that are set out here. If the trial court is to give a statement, right, the trial court can still remit, but this is to give a statement to say that that is an excess jury award on its face without looking at the sufficiency of evidence, and that is the cap on the damages.
Thank you for your testimony. Senator Perry, you have the...
Yeah, I don't know, Representative, or can I still call you Representative? Yes. You sat in front of me. We had some interesting conversation regarding a contract at Tech for a while. So.
And you have to admit, I was ahead of my time, and Tech finally caught up.
Yeah, you can, but I have to admit I won those, so it was good. Now, here's the question. So, and then I'll come back to the insurance. But I don't know, and let me just use a hypothetical, but I don't think it's truly a hypothetical. I think it happens. So, having the background of the medical history gives jury a perspective and more information. Just here's a conversation. I ski, hurt my back 5 years ago, got back problems, have a car wreck, and now I have back problems. Is that not relevant to a juror to be more informed to make that claim? So tell me what your opposition is to having a historical perspective that can either shore up or undermine a conversation with a jury, because I think that's relevant, and that's what we're trying to get to the bottom of. Can jurors, with the information presented, make an unbiased and fair assessment of damage?
That's absolutely relevant, absolutely. And it happens all the time today. The weird part about this bill is that it says all of your records, relevant and irrelevant, are coming
So
in.
who's the determiner of relevance in that conversation I presented? Who did determine what's relevant?
The judge.
Who?
The judge.
The judge. But does it prevent it from being discoverable? Does the judge get to see what's discoverable, all accounts, and then make that decision, or is it prohibited from being discoverable without this bill? Does that make sense?
No, absolutely. Today, the judge can determine what is relevant and what is discoverable, and everything related to the physical, if you're complaining of a back injury, everything related to your back is game for your entire life, because you may have been born with scoliosis. You may have had injuries in high school. You may have all kind of historical problems with your back, right? But all these other medical conditions that you may have had are not relevant and not discussed.
And I appreciate that, but I want to make sure that as a layman looking in, that I get it, that all of that information is made available through discovery. There's nothing to prohibit that information from coming in.
Correct.
And at that point, a decision can make what is relevant. There's nothing blocking that information today.
Correct. Rules 401, 402, and 403 of the Rules of Evidence say evidence that is relevant is admissible, and evidence that is relevant but unfairly prejudicial, the judge can weigh its probative value, whether it's admissible or not. The problem with this bill is the legislature right now is determining that everything is admissible. Everything. Unrelated to your back. Everything else you have.
I get that. So to the insurance attorney, is there a difference of opinion as to what is discoverable and what's not?
Yes, so in practice, if I request, right now, I would have to request medical records. And if I said, I would like to request all of your medical records for your entire life, I would be met with objections. I might be able to call that plaintiff's lawyer and negotiate, let me have all of your records for 5 years or for 10 years or some other thing. Or maybe I'm not able to reach an agreement, and then we have to run down to the courthouse and we have to ask the judge. And the judge is going to say, why do you want to look there? And I'm like, because maybe there's something that's relevant, and I should be the one that decides what's relevant to the defense of my case and how I want to present the defense of this medical case. Because when a plaintiff files a lawsuit, for better or worse, they are putting their medical condition into controversy. They are putting themselves out there. This all becomes open, it all opens up, and it's within the lawsuit. So it's not like this is all being splashed on social media. It's being used in the courtroom, and it's only being used if the judge determines that it's relevant to the case. That's the only time they would actually be published to the jury. So just because I get the chance to look at it, all that means is that I now have the exact same information that the plaintiff's lawyer has. And that's the whole point of all this. Let me just have everything that they have.
Is it fair to say that if you ask for what you perceive to be relevant, you have no oversight or no ability to effectively know that that request was honored? I know when you send up discovery, you're supposed to turn it over, but if you said, I want everything that's relevant to X, the back, and the doctor responds, there's nothing in here for the back, at that point, you have to just move on?
Senator, that is absolutely correct. If I ask a plaintiff in interrogatories, and if I say, have you ever had a back injury before? Have you ever complained to a doctor about back pain? And the answer is no, I have no recourse.
Okay.
Unless I find something accidentally through some other deposition or medical record that mentions the word back, and then I can go, aha. But I have to do that. I have to get lucky that way, or I have to rely on the statement of that plaintiff that no, the answer is no, as opposed to reviewing the records my own.
Okay, thank you. Sorry.
Could I just add something?
Sorry, Mr. Chairman, I'm just
Thank you.
lay guy here listening to all this.
No, Senator, if I may follow up, and it's been 20 years since I've worked on a case like this, but, and I'll ask all the lawyers, y'all practice in this area. So there are discovery requests that the plaintiffs and defendants send back and forth, but don't we also seek records directly from the medical providers? And I'm asking, I don't refresh my memory on how this works.
Sure. So in the rules of disclosure, the 193.7 disclosures, plaintiffs have to list all of their treating providers that they are currently receiving treatment from or have received treatment from because of this accident, or damages at least that they're claiming in the lawsuit. And then we will ask for a medical release or authorization, and we will subpoena those records directly from those providers. But usually, those providers are only providers from the day of the accident moving forward. We will often ask for records from your general practitioner or something along those lines if we know about them, but that's the if part, is we have to find out about them first through other means.
Could I add something?
Please.
So the other thing that's interesting is that it's very judge dependent, right? You're going to go and you're going to seek these records and they're going to fight us. But they often will say you can only get records prior to the occurrence, limited to the areas of the body at issue, right? Which is usually neck and back. That's what we're dealing with. But I had a case where the plaintiff had foot surgery the week before my occurrence, and he was off work, but he was trying to claim the lost wages and even a subsequent foot surgery from my accident. Other times, a plaintiff may have something more chronic, right? Like they may have even something horrible like cancer, but they have a shortened life expectancy. They were going through chemo that caused different other conditions that they're now claiming pain and, loss of a normal life, right? We're also getting $2 million life care plans, even on a simple herniated disc case. So they're trying to tell us that for the rest of their lives, they're going to need extra care. They're going to need more, housekeeping when they turn 70. There's a $200 a week housekeeper charge in these life care plans. If I don't know what their entire medical condition was at the time of the accident, then all of that is super unfair, right? I can't determine that this person who was super healthy and robust has now been life altered by this occurrence versus they were already, very infirm or injured or broken foot or whatever else is going on. And they're talking about this all as stuff that's instantly admissible in court. It's not, right? There's a very big distinction between discoverable evidence. So we get to go looking at when they've put their health at issue. That's what they're claiming from us. The nuts and bolts of these cases is the medical, right? They are trying to claim that they've been injured. Well, now HIPAA's out the window because we get to find out what their medical condition is. And so in order to find out the whole big picture, I do need those records. And it shouldn't be limited if a judge decides to just give me anything that says back in it. And then who's going to determine that anyway when I send a DWQ to that provider? They're not trained to go through records and redact. And it's just not going to work that way. I should be able to discover their medical condition, right? And then if it's not relevant, it's not going to come into the lawsuit. Nobody wants to spend time on somebody's. It was used to just sort of shock and awe, like a vaginal condition and menopause and a vasectomy. No, I don't want that in the courtroom any more than they do. But I can't let them be the gatekeepers of that information, or even a judge, or even some clerk at the healthcare provider's office, right? I should be able to take a look at those medical records and get them to my expert. If that's what we're talking about here, right? The truth of their medicine, of how they were injured in this accident, we just want the truth. And it seems like there's a lot of smoke and mirrors trying to keep us from that.
Mr. Chairman,
Oh,
if I can answer your
Representative Allen, go ahead.
Page 20, line 1, 2, 3, and 4 says, the following matters are admissible into evidence by any party. Then it says, a document or information provided, disclosed, or obtained under section 4105B, that's all medical records from that provider. What happens right now, Chairman Perry, is I would have the opportunity to go to the judge and say, hey, judge, they have subpoenaed this lady's records from UTMB. When she was in college, she got a sexually transmitted disease. And she's now 35 years old. She has 2 kids. Her husband doesn't know. Nobody knows. They get to get the records. I'm talking about what's in the bill, not what they're talking about. I'm talking about this. And it says it's admissible by either party into evidence, relevant or not, right? And as it is today, they can discover all this stuff they're talking about, but I get the chance to try to go to the judge and let the judge review in camera, which means in the judge's chamber, he looks at it before anybody else looks at it, so I can point out to him the things that are in the records which are not relevant or their relevancy is outweighed by the prejudicial effect. And that, under this bill, is gone.
Dean Zaffarini has questions, and then we'll go to the author. Dean?
Thank you, Mr. Chairman. Mr. Island, what would you say to those who argue that this bill does not preclude a plaintiff from recovering the full measure of compensatory damages or punitive damages for any injury caused by the gross negligence of an employer or an employee?
This bill doesn't impact punitive damages at all. So I would agree that this bill doesn't impact punitive damages.
And what about the compensatory damages?
It impacts compensatory damages in multiple ways. And one which hasn't been talked about is there is a requirement today that a jury verdict on all issues has to be supported by a 10-2 verdict, okay? This bill says some of it can be supported by 10-2, but non-economic pain and suffering has to be unanimous, right? So that means if you get a 10-2 verdict on the rest of your case, on your On liability, 10 to 2. On lost wages, 10 to 2. On future lost wages, 10 to 2. Past medical, 10 to 2. Pain and suffering, 10 to 2. You get 0 pain and suffering. 0 under this bill. That's one place where it caps damages, because it changes the requirement of what the jury has to find.
And yet there are those who say that this bill does not cap any damages and would not set any medical billing rates. What would you say to them?
I would say the whole purpose of this bill, as shown by the materials that the proponents of the bill sent out last week, is to cap and limit damages in civil cases.
Are there more than one section of this bill that you believe raises constitutionality questions?
Yes, and we've talked about it, but the remediature section definitely raises constitutionality questions.
Any other part?
Not that comes to mind.
Okay, thank you.
Well, I can tell you this. You know, if you want to cap non-economic damages, we did it in 2003, and we went to the people of the state of Texas and let them vote on it. But in order to do that, you got to get 2/3 in the Senate and 2/3 of the House. And I think the proponents of this bill know that they can't get 2/3 of the Senate and 2/3 of the House to take it to the people to let them vote. That bill in 2003 also said, if you want to cap any other damages other than doctors, med mal, you got to get 3/5 in the House and the Senate. And I think the proponents of this bill know they can't get 3/5 of the House and the Senate to cap damages. And so they've come up with this other scheme to try to wiggle around and cap damages in a non-straightforward method, which is like all the stuff that we've talked about today. They change it here, they change it there, and then it all comes together to cap your damages.
Thank you so
Or
much.
eliminate them in
Thank
a
you
10 to
so much.
2 verdict.
Ma'am, you support the bill?
I do.
Is there any part of this bill that you believe needs improvement, or do you support the bill as is?
Well, I think there's always room for improvement, Senator. I think that the remediator section could provide additional clarity because it keeps being said over and over that this is some sort of new issue. But remediator has been on the books since the signing of the Constitution in Texas. It is, as my colleagues here to my right have stated today, it is used already in Texas on a regular basis. And if that's not clear, that this is just another remedy that's being put in place when a judge who has sat through the entire jury trial and also heard all of the evidence and is a member of the bar believes that the evidence is not in, that the jury verdict for damages is not in line with the evidence that was heard. It's just a remedy to be able to make sure that that judge looks at it, signs off on it, sends it back if he wants to send it back or she wants to send it back. And so I think that because of the amount of confusion on this very clear topic, that maybe that section could use some work.
Thank you. Thank you very much. Do any of you believe that there are provisions of this bill that would impact a court's backlog?
Absolutely.
In what way?
I think that it's going to reduce the number of times I run to the courthouse on discovery motions having to do with medical billing. It should, if it's used properly and applied properly, it should reduce the number of witnesses at trial. If I will tell you in practice that when a plaintiff uses their health insurance, the amount of damages that was billed, it's reasonable. I can't go get a witness to say that that's an unreasonable amount, that amount wasn't paid or incurred, which is the Haygood v. Escobedo standard. We accept that as true. That provider doesn't have to show up, and I'm not going to argue it, and I'm not going to ask the jury to consider whether that was a reasonable amount of damages. That was a reasonable amount of damages for the treatment. So it absolutely reduces jury time. It absolutely reduces my discovery motion practice.
Is there any possibility it could have, any provisions of this bill could have a negative impact on the backlog?
Yes.
In
Yeah,
what
and I
way?
know that we have a former judge who's going to come and give you specific examples for that. So I'll punt to let him testify anew.
All right, thank you. Yes, ma'am?
I would just add that it will also facilitate more settlements. I do believe that the insurance industry is fair and reasonable, and the cases that go all the way to trial are only because we can't get to a fair and reasonable, middle ground here as to what is going to compensate that plaintiff, right? Not, make this a windfall for them or, create generational wealth, but just compensate them. So yes, if we have reasonable medical bills, then we are looking at mediations that will settle cases and get them off the docket left and right.
I disagree with that completely. Because what's going to happen if you pass this bill the way it is, every small town and hometown lawyer and small firms are going to send all their cases to the big boys in Houston, Dallas, San Antonio, because they're not going to be able to meet all the provisions of this bill and all the new requirements they're going to have. So if you want to hurt the Walmartization, of of lawyers and small firm lawyers, this bill is going to send everything to the big boys.
So, Mr. Island, if this bill passes, who are the winners and who are the losers?
Well, the losers are your constituents that are injured Texas. We're talking about every single personal injury case from now on, right? Catastrophically injured people, SORNAT car wrecks. All of this is going to change the practice of law completely.
Who are the winners?
The winners are going to be insurance companies. And I think she's right. A lot of people will settle for a whole lot less because they're not going to be able to jump through all the hoops and meet all the conditions in this bill. And people are going to say, I don't want all of my medical records from my history at this hospital system to be put into evidence. So I'll take whatever you can get me.
May I respond? So in the example that I was speaking about during my testimony, I was talking about this particular medical provider who charges a very large amount and then always takes significantly less. Well, let's just say that the bill says $100,000, just for easy numbers. The bill is $100,000, but she will accept $40,000. What if the plaintiff had just used their medical insurance? If the plaintiff had just used their medical insurance and the medical insurance had paid for that treatment, then the medical insurance would have paid for that treatment and they would be out what? A copay and maybe their out-of-pocket expenses for the year, which is obviously, it varies. If they don't use their medical insurance, then after the jury awards makes their award or we've settled the case, they now subtract $40,000 to pay back that doctor. They have effectively paid significantly more for that treatment, that it came right out of their damage award, right out of their settlement, than they would have had they used their health insurance. So that may not be the fact in absolutely every case, but it will be the fact in every case where this particular provider is involved, because the treatment is overbilled every single time.
Thank you all. Thank you, Mr. Chairman.
Thank you, Dina. Senator Schwartz, you're recognized.
Yes, just two questions, and I appreciate the discussion and the questions of my fellow colleagues. This question is to Ms. Aker or Ms. Casey. There was a contention made that there was a constitutional violation in Section 8 of the bill regarding the right to a jury trial being preserved. Would one of y'all like to opine on that contention made by Ms. Temez?
I'm glad you asked that because I actually made a note that the right to a jury trial is the one thing that my opponents and I completely agree upon. And what we're seeking here is truth, that the whole jury system is meant to get to the truth of the matter, right? And they should be the arbiters of truth and award a fair and reasonable amount to compensate a plaintiff. What's happening is anything but. And what the plaintiff's bar is trying to do here, and why I use the term fraud, even though it's a strong word, is because they are presenting to the jury 10 times inflated meds, right? Even assuming that the care was necessary, which is a whole nother issue, right? But just the amount of those bills is not the reasonable customary amount. It's not what that provider is expecting to be paid. There are literally bills submitted to plaintiffs' attorneys that are called on the record and off the record. And when I saw that, if that's not fraud, I don't know what is. Because the on the record is what they're supposed to send to the defense attorney and show to the jury and get compensated for by that jury. The off the record is what they'll really take. And it's as disparate as 180 grand on the one hand and 37,000 on the other. That's a big difference. And that's what the jury is now, and this is why we're having these runaway verdicts, because it's not a fair amount to compensate that plaintiff. It is an artificially inflated number that now becomes a windfall, right? And Senator Zaffirini, you asked who suffers from, the plaintiffs themselves suffer. They are literally forced into getting a lot of treatment that they do not want. They really don't want these back surgeries, but they are told that the value of their case is incumbent upon them getting at least, it's worth X without a surgical recommendation. It's worth Y with the surgical recommendation, and it's worth Z if you go get that surgery. And these plaintiffs' attorneys are graded on how frequently their clients go to the doctor. Clients will call basically in tears, like, I don't really want this surgery and I know you're gonna be mad at me. They are then forced to sign a document from the plaintiff's attorney that says, I know my case is worth less, but I just really don't want this surgery. That is shameful. They don't want the surgeries, they don't need them. And the doctors who should be making these decisions with their patients as to what's best for them should have the sole purview of what's going on in that treatment, right? It shouldn't be a matter for the lawyers to determine, yes, this client needs surgery, go get surgery, because it'll up the value of the case. We'll get more money in the case. And that's what's happening. And I think that hurts every Texas consumer, including the ones who are injured. And when they want to parade before you all the catastrophically injured ones, those are not the ones that are going to be affected by what we're trying to do here. They'll probably have more money to settle their cases if the docket wasn't, absolutely congested with this, 90% of the cases that are back and neck injuries that were probably pre-existing, and they get overtreated in both the amount and substance of that treatment. That's what this bill is looking to curtail.
Thank you. This evening, I guess now, and this morning, I heard lawyers disparaged and terms such as cheating lawyers. And my question is, do the witnesses like you who use terms like that have data to that effect, or is this anecdotal or opinion? Is this something that's a widespread problem or something that perhaps has happened?
Yes.
But how do we justify using those terms or disparaging plaintiff lawyers?
Well, it's not just a few. I think there were a couple of the big boys, right, who sort of started this, and it became the playbook for every other plaintiff attorney out there. And now every single plaintiff's attorney follows that playbook, and they send their clients out to the usual suspect treaters. These docs are not the ones who are treating, the general population. They pretty much only work for the plaintiff's attorneys. And I made a list here because I know it. I said, why is this fraud? And I can tell you all of the reasons.
But my question, ma'am, is where's the evidence? You just said every single plaintiff's attorney. How can you back that up? Is there evidence to that effect, or is that what you think? Is that your opinion?
Well, I have cases where there are plaintiffs who weren't on the crash report as even being in the vehicle, and minors, including, that then go get the same identical treatment. The same providers, they have the same injuries, they go on the same dates, the write-up is the exact same, right? And half of it is teledoc. And one of the cases that I have like that, where the plaintiffs weren't in the vehicle, according to the crash report, it was a piece of road debris that the plaintiff couldn't avoid and kicked up and caused a little small dent in the running board of the passenger side of an SUV. And crash report, she's the only one in the car. But now, lo and behold, I have 4 plaintiffs, like I say, with identical treatment at the same providers. And if you just saw the prevalence of this in my docket, I mean, I can only testify to what I've seen, right? And I've seen it from both sides. But right now, having been a defense attorney for 4 years, it is extraordinarily prevalent, is what I see. And if it were only a few one-offs, and we could deal with it, but it's every case because it has become the norm. It is the playbook for how these cases are handled.
Thank you. But I still want to know if there's evidence or data or if it's just opinion or example. But I'll ask another witness. Thank you. Thank you, Mr. Chair.
Mr.
Dean, may I respond,
Go
Mr.
ahead.
Chairman?
No, no.
So, first of all, what counsel has just stated is exactly why there's jury trials. And good, competent defense lawyers are going to bring up their defenses. But that is why the jury is the sole fact finder of the credibility of the witness, to include doctors, to include any witness to the incident, to include the plaintiff, to include the defendant. And because they are the sole fact finders, and they want to bring up all kinds of evidence that maybe the bill is too high, too low, that, again, remains with the province of the jury, and the judge will answer the questions of fact. But that is exactly why we have jury trials.
Except you're not letting me tell the jury all of the facts. I'm not able to tell them that the treatment was done at the direction of the lawyer. That doesn't come into evidence, and that's one of the things we're asking, is that absolutely goes to the bias of the witness. And if I'm not allowed to tell the jury that, then that's what I said. We do want to leave this in the hands of the jury. That we can agree. But then let me tell them all of the facts. Let me tell them where this doctor, who sent them there, right? Let me tell them how many times that plaintiff's attorney works with that doctor. Let me tell them what that doctor is getting paid and what that doctor will actually take. Why the smoke and mirrors? If they want truth, then let me have the truth. Let me tell the jury that, and they can decide.
Senator Schwartner and then Senator Bardwell. Go ahead.
Thank you again, Mr. Chairman. Ms. Casey, you're trying to explain the system as it currently is regarding an injured individual that seeks through a plaintiff attorney's care for their injury. And you said something very pertinent during your initial testimony, that plaintiff attorneys don't really deal with their private doctors or private insurance. One, they can't control them, is I think what you said, but also in private insurance, it figures into the paid or incurred amount. Instead, they look toward affiliated networks of providers to overdiagnose, overbill, overcharge, which figures into the non-economic damages eventually in the final award settlement. Do I have it right there? Is that something, I think the members of the committee need to understand how it truly works. These are not independent doctors that generally are taking these cases. These are affiliated doctors that have a working relationship with plaintiff attorney firms and have a known, quote, expectation of what they are to do when they have an injured worker or injured individual. Can you explain that more clearly for us?
Yes,
Am I wrong?
Exactly. A lot of these usual suspects, the healthcare providers, have conglomerates, right? They own the MRI center, they own the chiropractic, they own the pain management where ESI shots are given. They're all in a strip mall, and it's all, they will refer to each other then, all in-house, and then send these absolutely inflated, fictitious bills, right? It was mentioned earlier that we don't want to, there's all kinds of reasons that a plaintiff might not want to use their personal insurance, but what's left out of that is that there is a negotiated rate, which would be much less, and there's always that duty to mitigate, right? That's one of our core foundations of legal principles. A plaintiff doesn't get to just jack up their damages and even ask the tortfeasor to pay for it then. It's compensatory, it's a duty to mitigate, and that is what is the opposite of what's happening. So when the plaintiff uses their insurance, if they, I mean, all I'm asking is that be something that would go to the weight of the evidence, that we would still be able to introduce the issue of bias of a plaintiff's treater, right? And then they can say why they didn't use their insurance, and then the jury can decide. But why can't I bring that into evidence, right? And more importantly, there was one of the reasons given that, well, maybe it's some sort of thing that's going to affect other people or whatnot, but they don't realize then that healthcare provider, or I'm sorry, that insurance company will also have a lien against any judgment or settlement. So they are going to get their money back, but it's just that negotiated rate, which is much less than the rates that we're being presented with. And that seems like a much more fair system. If you have insurance and a negotiated rate and the insurance company's going to get their money back anyway, then let's do that. Let's use that insurance. But they won't do it because they can't control that doctor and because then the numbers stay reasonable and it's not going to get them to that policy, right? They only want the policy in a case. And if there's excess, they're going to work it up to excess. That's the goal.
This bill also speaks to disclosure of those affiliations, disclosures of letters of protection, the particulars of data and information between providers and PI firms. And it also tries to expand disclosure of medical history. And my intent was to try to, and to speaking to Mr. Island's contention, my intent is for that medical disclosure to be the most relevant and pertinent information. And as far as wording that needs to be protective of individuals, I'm open to that. Ms. Aker or Mr. Island, do y'all have any input regarding the disclosure of patient? Mr. Island spoke a lot about it, but again, the intent is that instead of having to seek discovery multiple times by a judge, that is just a process in which relevant and pertinent medical history, the entire medical history, to make it so that it's appropriately adjudicated during the case by the finders of fact, the jury, happens. Ms. Aker, am I missing the mark on the provisions of the legislation regarding the disclosure of the medical history? You want to speak to that? I know Mr. Island thinks I am. Or Ms. Casey, either one of you.
No, I think you stated it right. Certainly my argument that it reduces the amount of litigation during the discovery phase if all of this is just automatically produced. And I would like to say that one of the things that I think that this bill gets very correct is that I don't actually think that 100% of the plaintiff's bar is operating fraudulently. I have a lot of friends in the plaintiff's bar, maybe fewer after today's hearing, but several friends, and we've discussed and debated this bill quite honestly, and they don't believe that it affects those that are operating above board. This is information that should be provided. These are disclosures that if there's nothing to hide, won't be a problem. This is information that should, if it's relevant, I had my evidence professor, who I loved at the University of Arkansas, said that all evidence is admissible unless a rule keeps it out. And that rule starts with 403, which we've been speaking about several times. If it's not relevant, it's not admissible. So just because it says that it's admissible under 1801 or one of these Chapter 41 rules doesn't make it actually going immediately in front of the jury if another rule keeps it out and the judge still remains the gatekeeper. So I think that this bill is going to get this right, and then it's going to reduce discovery. The above board lawyers are not going to have any problems with this at all, and it's going to leave the judge the gatekeeper of the evidence and the jury reviewing the evidence. There's nothing in this bill that prevents a plaintiff from getting to a jury. It simply changes the evidence that the jury is allowed to hear. And as I said earlier, I think that our juries, when they are better informed because they have all of the evidence and not just the pieces that certain lawyers want them to hear, then we're going to have more fair trials and then more fair judgments, which then will hopefully also reduce the burden on the courts of appeals.
Mr. Island, she's making the contention that the role of discovery is different than the role of admissibility as provided by a judge. You were shaking your head no, according to the rules of evidence that you articulated earlier. Tell me why.
Page 20, lines 1 through 4. This legislation says it is admissible, period. Period. That's what I'm relying upon to make my statements. And I am an above-board lawyer, and I still have problems with this bill. And right now, the system is set up to discover everything about the back, everything about the history that could be related to the back, but I have a chance to go to the judge and prevent irrelevant and prejudicial information and let the judge decide. Under this bill, as the way it was given to you, that is not possible. And That's one thing that should be eliminated, because I don't know that you can fix it. Either, I mean, if they want all of the medical records from the UTMB health system on me for any injury that I have, and then they get to bill for it. You get 30 years of records. What do you get to do as an insurance lawyer or defense lawyer? You get to bill for it. And then you get to report about it, and then you deal with it. So don't take away the tools that we have right now to prevent irrelevant information from being admissible to the jury.
I always appreciate it when plaintiffs' lawyers create work for me. I have plenty. I do have to keep my time every 6 minutes. It is a painstaking requirement of my job. But I guarantee you this bill is not written to increase my minimum billing for the year.
Senator, if I may just add something quickly. So I don't know that this point has been made, but every doctor who treats a victim of an incident or an injury, it subjects himself or herself to discovery about their practice, discovery about their billing under Texas Supreme Court rules and law. They also subject themselves to cross-examination. If they are biased, if they are otherwise, their bills are opened up, and cross-examination deposition, cross-examination in trial where they have to defend their bill. And so I just didn't want it to seem that it's a unilateral process, that there isn't defenses and deposition of these doctors who have made the choice to be part of this process.
Thank you, Mr. Chairman.
And thank you, Senator Schwartner. Senator Birdwell, you're recognized.
Thank you, Mr. Chairman. I'm going to go return back to some more rudimentary things, if I may. So I want to make sure you're defense counsel.
Yes, sir.
Do you do that of your own accord, or are you of counsel or a partner in a
I'm
law
a
firm?
partner at a defense law firm.
Okay, defense law firm. I assume there's a defense bar as well as a plaintiff's bar. Is that a?
Certainly.
Okay. You may have touched on it with Senator Perry, and as the conversation's gone, I'm trying to, does the bill enhance your ability in discovery or evidence gathering? Because you mentioned subpoena or go to the court. Does it give you confidence that everything you ask for you're going to get? I mean, how do you know that if you approach a defense counsel and say, I need X, Y, and Z, you're going to get, you may get X, Y, and Z, but you don't know that double A, double B, and double C are out there. So what's your confidence level that you'll get all the material that is relevant to the defense of your client?
I understand the question, and what I understand the question to be is that when I request discovery through one of the processes, we call them interrogatories, request for production, disclosures, how do I know that I'm getting 100% of the information that I'm asking for? And the answer to you is that the bar license, the oath that we all took. We expect that the lawyers on the other side are living up to their oath, as I'm going to live up to my oath, and we are all going to sign those pieces of paper with our name and bar number, and that means something to most of us. I think that the problem is that it means less to some, and we are slowly discovering that through the other discovery processes, and the very bad actors have really spoiled it for the bunch. Okay. And have caused major problems leading to these nuclear verdicts that we're talking about, and then social inflation, which leads to more nuclear verdicts. And so I do believe that the way that this bill works, it will, but actually by codifying any rule or common law standard, something that's just written down in an opinion that's been that's always subject to interpretation, then we're going a step further to ensure that there's teeth, essentially, that there's recourse. So I do think that it helps.
If the entity that has the records is a governmental entity, does that change your opinion of the bill? I mean, I'll just tell you, if you have to go subpoena, like if you were my defense,
sure,
or if I were I guess, in opposition. But if you have to go to DOD, Department of Veterans Affairs, and some of the other places, like medical records, does this bill affect your ability to go to non-private but governmental healthcare-based entities? Or is that just a bigger inconvenience factor, but you can still do it?
It's a bigger inconvenience factor because, no offense, but asking the government for much is a slow process. It's a slow
None taken.
Okay.
None taken.
But other than that, no, it shouldn't actually differentiate between the two.
Okay. Thank you, ma'am. Thank you, Mr. Chairman.
Senator, if I may follow up. In your area, if somebody is taken to Baylor Scott and White, and the defense orders the records from Baylor Scott and White, Baylor Scott and White will give them all the records they have of that individual, right? And if they don't, that's Baylor Scott and White's issue, not the plaintiff. I don't control what Baylor Scott and White gives you. What I can still do today is go and object that there's certain records that I don't want the defendants to have because they're irrelevant, not related, but it's Baylor Scott and White that gives the records.
But then here's my, if I may, Mr. Chairman, my follow-up with Craig. Then what's the confidence level that the defense counsel knows that you've informed defense counsel of every potential or historical provider? I mean, the community doesn't need to hear my baggage, but that's an immense list. So how does she know that your client has given every, I had this over here and this over here and this over here and that. How do you know that what your client provides you is comprehensive for your needs and for hers?
That's not changed by this bill, right? I provide them, my client tells me where all they've had care related to this accident. They will ask me, where else have you had treatment over the last 5 years or 10 years? And I'll provide that. And then they can go get those records. That's part of the discovery process is not impacted one way or another by the bill. The only thing that changes in the bill is that it says they can go get all of my records, and once they get them, even if they're irrelevant, they're admissible into evidence. That's the only thing that changed. How they find out who they are,
right? And
change.
And the judge in the courtroom of fact finding is the one that determines relevancy. Who decides that?
The judge determines the law on what is relevant and irrelevant.
Okay, all right. Thank you, Craig.
And Senator, I would like to add one thing. And the reality of the practice is when they ask for all medical providers and they're listed and those records are ordered, many times we'll enter into an agreement. Because if I have a client who has a broken ankle, but they want to discover the gastroenterology where they maybe remove the gallbladder, right? Then we have to create what's called a privilege log based on physician-patient privilege, give them that privilege log, and they can still order us to have the judge review those in camera. And if the judge reviews them and said the gallbladder is not related to the ankle, that's how that works.
Senator Hinojosa, you're recognized.
Thank you, Mr. Chairman. So I've heard last panel, a lot of discussion this panel regarding, and I just want to make absolutely sure I'm hearing this right. So it was alleged or said that it's common practice for plaintiffs' attorneys to actually require or suggest that their clients use a different medical provider, instead of using their own in-network medical professionals, that they utilize those that are suggested of the plaintiff's attorneys. I just want absolute clarity. Is that a common practice? Do you actually do that? When somebody comes to make a claim, you say, go use these people that we have here?
I don't. There are.
Well, is it a common practice for plaintiff's attorneys to do that?
I don't know if it's common, but apparently they've raised the issue that some people do.
But to your knowledge, do you see that a lot of, you represent a lot of Texas trial attorneys. Do you see that practice being utilized?
Lawyers will refer their clients to doctors that will see them on a letter of protection if they don't, especially if they don't have health insurance, right? Number one. Number
Yeah,
two,
you listed a couple of reasons why they might, but just in general, I just want to understand, it is a common thing then for plaintiffs' attorneys to require, suggest, recommend that their clients go see the attorney's preferred doctors and medical professionals. Is that correct?
it
That'd be fair?
occurs. Yes, that occurs.
Okay. You mentioned a word, remitter. Am I getting that right?
Yes,
Okay, is that a maneuver? Is that a tool that a judge uses?
right.
So, go ahead, ma'am.
So it exists in the appellate procedure and the civil trial practice, in the, our rules of procedure. Remediator, meaning to be sent back, or really a reduction in damages, is a tool that is used by trial court judges. It's also part of the standard of review for an appellate court to be able to reduce awards currently without substituting their fact-finding for that of the jury.
What percentage would you say, just rough guesstimate, of all the claims that have been made that I guess fall to this nuclear verdict description? How many, roughly, in percentage-wise, would you say that a remediator was actually utilized to reduce the award? How many times, or roughly how often is that done?
Right, and I'm under oath, so I have not done that research, but I have seen cases where remediator is suggested even by the Texas Supreme Court in mental anguish damages. There's a case 2025 out of the 14th Court of Appeals, just in February, where remediator was used to reduce the future damages and to reduce the past damages based on what the evidence supported.
Right, so I did hear you mention that earlier, and
Yes.
I remember you citing that
Yes.
case, but is that common? Does that happen a lot?
Well, the defense has the option to use a defendant, if they think that's an excessive award, they have the option to suggest remediator.
So the defendant
Defendant can do it.
The defendant can
Right,
do it.
and the plaintiff can do it.
Okay,
plaintiff
but
can
I thought you just said the judge decides that.
The judge decides it, but the defense can suggest that this award needs to be reduced because there isn't evidence that's sufficient to support that award.
So for those other, how often are the defendants making that?
Well, I would say that if a judge is going to change the amount awarded in a verdict, it would have to be against the manifest weight of the evidence. But that's what we're talking about. The weight of the evidence, when it is the fictitious bills that no one expects to be paid, is this giant pot of money. And it's very difficult then for a judge in good faith to reduce an award because that was the evidence as it was submitted. And hence the reason for this bill is we're asking for the amount of the bills to be the real amount, the truthful amount, the usual, customary, and reasonable amount. And then there would very unlikely be a very large verdict that's out of proportion with the injuries, right, or the medical care that was rendered, because, and so then, yes, if there becomes a nuclear verdict on a reasonable medical bill submitted, then the judge could absolutely exercise the right for remediator.
So it would be fair to say that that very rarely happens?
Very rarely.
Okay.
And there's also editor. The judge can also increase a verdict, by the way.
If I remember correctly, in 2003, I remember that Prop 12, that limited medical mal lawsuit, or it was some tort reform with that. And I remember the term summary judgment for frivolous lawsuits. Would y'all all agree, or let me ask the question, how, are there prevalent frivolous lawsuits being filed? Please.
So unfortunately, it's very, very difficult to win summary judgment. We call it a dispositive motion, meaning that the judge will take it outside of the purview of a jury to render a verdict, and they will, as a matter of law, say that based on facts or law, there is no lawsuit here, right? I have a case where the plaintiff committed suicide by jumping in front of a commercial motor vehicle driving down a major highway, traveling at 70 miles an hour. And the coroner investigated this. It was on the news. They even said very clearly on the news that this guy, people had been calling it in, and he jumped in front of the truck. There were tons of brake marks on the road, tire marks, excuse me. The coroner's report then, the manner of death on the death certificate says suicide. My commercial motor vehicle company is still being sued for that, and brought a motion for summary judgment. It's technically pending, but it's been a while. I don't have a ruling. I don't know how hard it would be if that's, I think that's a frivolous lawsuit. It's just very difficult to obtain that kind of judgment. I don't think a judge feels comfortable taking it outside of the jury.
And so I think my point is it fair to say also that summary judgments are very rare,
Yes.
rarely done. So summary judgment's a tool that can be done, very rarely exercised. A remediator to reduce claims is a tool that can be used, very rarely exercised. And I'm sure that we could probably all agree that not 100% of these claims are completely, non-frivolous. So I guess my point is, and I'm sure it's probably to the point of the author of this too, that if very little of these tools have actually ever been utilized, I'm sure that's why there needs to be some sort of something.
I do want to make one clarification on the remediature. Right now, if the judge, there's a motion for remediature, the judge can tell the plaintiffs, okay, I don't believe there's evidence to support this portion of the jury's verdict. You can either accept a reduction down to X, or I'm going to grant a new trial, right? The judge does not get to substitute his opinion for the 12 jurors' decisions, right?
Goes back to my point, though, how often is that exercised?
Every time that there's a quote excessive verdict, the defendants should ask for a remediature. They have to. There's no reason not to.
May I? So the reason that it's not used very often is because there is no measure for how the jury should get to non-economic damages. There's no standard by which the legislature or the courts outside of the most recent Gregory versus Shokera opinion says that, hey, jury, this is the formula that you use to get to non-economic damages. So requesting a remediature on non-economic damages at the trial court level is basically useless. When it's used is if the plaintiffs come in and they say, hey, past medicals were $100,000, and for some reason the jury writes down $200,000 in the past medical. That clearly isn't supported by the great weight of the evidence, is what the law says. And so the judge will say, hey, go correct that, jury, because you must have seen this wrong. They only asked for 100. The bills are only 100. You can't give them more in the past than what they actually paid or incurred, words we've used a lot today. So you should probably switch that up, or I'm going to give them a new jury trial. So that happens on the economic damage side, but because there's no formula and there's no cap for the non-economic damages, then it doesn't happen on the non-economic damages side. Although the Court of Appeals, it applies differently in the Court of Appeals and with the Supreme Court than it does at the trial court level.
Thank you all so much for answering my questions.
Senator Perry, you're recognized.
I appreciate, Mr. Chair. I'll try to be as brief. I'm trying to wrap my head around, and y'all may tell me it doesn't exist. So I have a physician. They're giving you the incurred, which is inflated, and on the back end, they're telling you what they would take. Is that really happening? I mean, Craig, I trust Craig. You're saying it is or isn't happening?
I don't know.
You don't know?
She says it is. I don't do that, so I don't know.
Well, the follow-up, is that not basically fraud? And if an attorney was doing that, knowingly doing that the charge is incurred or paid, it didn't say incurred would be the highest of the bills. It says incurred or paid. So if a doctor's providing some support that I'll take this, but this is what you should ask for, and then I'll sign an affidavit that that's what it really should be, market value, would that not be some type of fraud in its inception? I mean, to me, you can't be an unfair dealer in this conversation, but we're told it's happening. You're saying you don't know, but somebody's doing it, or it wouldn't be part of the conversation.
Yeah, I think there are people coming behind us that can answer that question of how that operates, because I think we have some providers who work on a letter of protection. They can tell you how it works.
Let me back up. Just 10,000 foot view, would that be fraudulent if you're getting two different amounts for the same services?
I don't know if it's fraudulent or not because I don't know the circumstance. For example, if he says, okay, I'm gonna charge you $10,000 for this, but if you're not gonna get much for the case, come back and we'll talk, and I can do it for less if I have to. I do that all the time. I sign up a client on 33 1/3%, but if it turns out that I need to reduce my fees in order for them to accept a settlement, I say yeah. And I go to providers all the time, especially like you do it with insurance companies. Health insurance companies that file a lien, they file a lien for the entire amount of the bill that they have paid. But when it comes time to go to mediation, or even if you get a judgment, you go to them and say, hey, you got a $100,000 lien on this case, but we only got $200,000, whether it's by settlement or verdict. And I negotiate with health insurance companies all the time under that circumstance. So is that fraud?
Yeah, but I think you make my point for me. We're not asking what we're going to negotiate from, and we're not asking that you should start with a higher amount so that whatever you're willing to take is a lesser amount. We're asking what is the actual cost of those services, and that goes to an objective database to tie that to.
Yeah.
And an objective database that represents what was actually paid across the board and not what was billed, because the medical practices of today, and THA and these people will disagree, is built around a bogus chart that's been around for the dark ages called master billing. But I found out today that that's not even a standard that is used. It's whatever the medical professional decides, hey, ask for $100,000. It really probably only going to cost me about $10,000, but you can get a bigger settlement if we inflate it on the front end. So you make my point. If your perspective is we got to start here because we can have more to negotiate, that's not what the fair settlement should look like. It should be what it cost for that person to get the medical treatment and compensatory damages in a loss of wages and those things. It should be very much, I can agree that there is a subjective piece of this, but I also know how much someone was worth if their college background was this and they're in this profession and they can no longer fulfill it. Those are things that you can kind of get to. But what I heard you say, and I don't mean it's a bad thing, what I heard you say is, I'll negotiate down based on what they're going to pay me. And to the opposite, it's not to the, you shouldn't be negotiating down to what you can get paid on. It should be, what does it cost to do this health care, period. And it should be what was paid and not billed, because that's the game the insurance companies and the hospitals and the medical profession. When we talk about runaway inflation in Medicare, which is averaging around 8% for the last 10 years per year, highest inflationary cost we have, and you look at it, and it's all built around these master billing charts that don't reflect actual cost. And nobody wants to tell us what actual cost is. You ask a hospital, what's your cost of delivery of care? You ain't gonna get it, promise you. Because how their cost accounting is and what I learned in school is cost accounting, no relevance to reality.
I would also point out, Senator, that if I don't have health insurance and I go to a doctor's office and say, can I get the Blue Cross Blue Shield rate? The answer is no, right?
What most providers do, not all, and we've got legislation to this session or in prior sessions, there are some that take health insurance that cannot take a cash payment if you have both. So that tells you the game in that conversation. But secondly, typically, providers have a discounted rate for cash payers, private payers. So it's never usually the opposite end where it goes up. So I understand that, but that's apples and oranges comparison in what we're talking about here on your settlement. So that's at the heart of it. What is the real cost? Does the jury have the information to determine what real cost should look like? And then have the judge make the assessment that that was a fair and balanced deal. Today, it's not very transparent on any of those levels, and it starts with the provider. Really, honestly, sounds like he's getting ready with theft. If I can just tell you, put this on there to get your settlement number up, and I don't have any connection to reality, to me, that's just outright fraud. And if it's going on, I hope that there's people to tell me how it works, not, well, if you can get this amount, I want this percentage, but if you can't, I'm willing to go down. That's not That's not what we're trying to get here. What did it cost to deliver health care?
Thank you, Senator Perry. Sir, does any other questions for the witnesses on this panel? We thank each of you for being here. You're excused.
Thank you.
We'll have one more panel of invited witnesses, and we'll open up public testimony. And so for our next panel of invited testimony, the chair calls Earl Duke Austin and Will Adams. And while they're making their way here, I'm going to go ahead and call the names of our first public testimony panel. And so the folks I'm about to call, please be prepared to come down and take your seats as soon as we hear from Mr. Austin and Mr. Adams. Our first panel of public testimony in a few minutes will be Honorable Jim Wright, Charla Aldous, Joseph Montgomery, Cheryl Welsh, and Bill Ward. Again, on deck, please be ready after this panel. Honorable Jim Wright, Charla Aldous, Joseph Montgomery, Cheryl Welsh, Bill Ward. So y'all please be ready to testify as soon as we hear from this panel. Welcome. Introduce yourself. Give us your testimony.
So good afternoon, Chairman Schwartner, Vice Chair Perry, and distinguished members of the committee. My name is Duke Austin, and I am President and CEO of Quanta Services. I am pleased to testify in support of Senate Bill 30. Quanta Services is a Fortune 200 company proudly headquartered in Houston. We provide infrastructure solutions to the electric power, industrial, and communications sectors. We have over 60,000 permanent employees across North America, including over 15,000 in Texas. We have invested millions of dollars in our advanced training center in LaGrange, Texas, where we have provided training to over 80,000 craft-skilled workers. Our men and women in the field are the first responders to repair and restore after major storms. Excessive litigation poses significant challenges to our business operations and overall growth. In the last 10 years, our insurance costs have increased 5 times, and our deductible is up 10 times. The financial burden drains our resources and diverts our funds away from essential investments in infrastructure, training, and emergency response. Litigation also disrupts our daily operations and takes valuable time away from our primary responsibilities. We have been directly harmed by excessive litigation and these so-called nuclear verdicts. We have recently tried an auto case in Harris County to verdict. Jury awarded over $16 million in damages, despite the fact that the plaintiff's medical bills were significantly lower, and his expert admitted that the plaintiff could have avoided the accident. In many cases, we've seen the actual cost an insurance company would pay is less than 10% of what the plaintiffs claim they were billed. We invested to locate our corporate headquarters inside the Houston Loop. Now we have dozens of cases pending in Harris County, many of which have no nexus to Harris County or even Texas, solely because the lawyers see it as a friendly jurisdiction. We have had minor incidents in places as far away as Cook County, Illinois, and Los Angeles County, California, and lawyers have chosen to try these cases here where their clients can get bigger payouts. I never envisioned our commitment to the city of Houston and the state of Texas being weaponized against our company, but that is exactly what is happening. I am from Texas, 4th generation in our business. We're passionate about the state. It pains me to know that Texas has more nuclear verdicts than anywhere else in the country. We appreciate the thoughtful reform in Senate Bill 30. Specifically, we support protecting Texans from higher insurance costs by ensuring that personal injury claims are not based on inflated numbers. We support that the guidelines that ensure compensation reflects actual harm. We support a legal environment that encourages transparency. In closing, I want to emphasize the importance of continued investment in infrastructure to support Texas's growth and prosperity. Senate Bill 30 provides a pathway to a fair and balanced legal system, and I thank you for your efforts to ensure the protection of both business and individuals. Thank you for the opportunity to speak today, and I look forward to answering your questions.
Ms. Austin, thank you for your testimony. Thanks for being here. Mr. Adams, welcome. Introduce yourself and go ahead.
Thank you, Chairman. My name is Will Adams. I'm a former president of the Texas Trial Lawyers Association, and I'm here in opposition to the bill. It's an honor to appear in front of this committee, and frankly, an honor to appear next to Mr. Austin. Mr. Austin and I got to know each other a long time ago when he was a Sigma Chi at Sam Houston State University, and I would visit my friends there. And we recently reconnected, and oddly reconnected for a second time as we ran into each other over on the sidewall. So it's good to see him. He runs a good company. My president, Jack Walker, asked me to speak on a very specific portion of this bill, and that is the medical bills portion. It's been discussed a lot today already. I've been listening to the questions and the comments, and I want to be as direct to those as I possibly can. There's been a lot of talk about lying and cheating and fraud and that sort of thing. My personal experience is different, not just in my practice, but with my colleagues and my friends who are in the association with me, so it's not my experience. It sounds to me like what we're trying to do is legislate towards that fraud, which I get wanting to do. The problem is when you try to legislate the bad apples, you are sweeping in the rest of the bunch with that. And I want to talk about that today specifically, and how this bill would impact cases and injured Texans who do not fall under that accusation in any form or fashion. So the way the bill works quickly in 4104A1 and 2, if the injured victim has the means to pay for their own bills, they get those recovered. If someone pays them on their behalf, third party or not, they get those recovered. What this bill impacts the most are those who cannot pay their own bills, do not have their own health insurance, or cannot use it for one reason or another. And so what this does, and I want to be clear, this does cap medical bills that can be recovered. 4104A, it says the economic damages that may be awarded for healthcare services are limited. And then it sets forth those 1, 2, and 3. The third one is the major concern, obviously. It's the 150% multiplier on what I understand at this point is going to be workers' comp. So 2, what I believe are unintended consequences of that provision and how it will impact cases that I think we all would agree don't fall into that accusation. So picture this. A young woman is in a terrible crash. She fractures her hip terribly. She doesn't have health insurance. A surgeon agrees to operate on her and afterwards sends a bill for what is the range of either what private insurance would pay or the cash pay rate, which from what we've been able to determine is between $10,000 and $20,000. That woman is forced to file a lawsuit on that between $10,000 to $20,000 bill. Why? Because with this law being in effect, the auto insurance company for the responsible party is only going to pay what's under 411043, which is 150% of that's what I understand is the comp rate. From what we've been able to determine, that's $4,137 approximately. The young lady who was injured through no fault of her own has a $10,000 to $20,000 bill. She still owes it. This law doesn't cap the bill, it caps the recovery at trial. The bill remains. So a lawsuit's filed because the auto insurance company does not want to pay the $10,000 to $20,000 bill, because why would they? This bill says that all this young lady's going to get at trial is the $4,000. I disagree with the witness who said that this will decrease the backlog. This will increase the backlog of cases for this very reason. May I wrap?
Go ahead, thanks.
The one thing that we should all want to do is avoid shifting the harm back to the injured victim who was injured through no fault of their own. The only people that that is good for is the wrongdoer and their insurance company. Thank you, Mr. Chairman, committee.
And thank you for your testimony. Senators, any questions for Mr. Ross or Mr. Adams? Dean Severity, you have the panel.
Thank you, Mr. Chairman. Mr. Adams, you said that this bill would increase the backlog. In what way, sir?
So in the situation where you've got to be clear, under 1 and 2, if you're recovering what you paid or what somebody paid on your behalf, I don't think it's going to change it at all. Under 3, where you've got the uninsured or the folks who can't use it for whatever reason, high deductible premium or whatever, the bill will be larger than 150% of comp. It will be, probably significantly. And so if all the auto insurance company believes that the injured victim will be able to recover is 150 of comp, well, the only way to attempt to get more money, maybe in other areas to be able to pay that bill, is to go to trial. The other areas that we've talked about with other witnesses, pain and suffering, mental anguish, otherwise the bill sits. So you've got a injured party, injured through no fault of their own, who either has to come up with the balance or the doctor has to decide to not pursue it. But that also puts the doctors in the position of deciding whether or not they're going to pursue it. And sometimes they're going to do that up front, which creates another problem in this bill, is patient access to care. The sad reality is the pool of doctors willing to see, for example, car wreck victims is already small. I know this in my practice, and I practice in Katy, which is a conservative, middle to upper class, health insurance covered community for the most part. There are treating doctors who will not see them, even if they have health insurance, because they don't want to be involved, which I get. But to answer your question, I think I went a little far afield. They're going to be forced to. They're going to be forced to file a lawsuit because they aren't going to be able to pay the bill unless they do and take it to trial.
Thank you. Sir, you also referenced unintended consequences. Could you expand on that, please?
Sure. Well, I believe in my heart it is not an intended consequence that what we just described, that someone who was injured through no fault of their own is saddled with a medical bill that they didn't want, or a balance of a medical bill that they didn't want. I think that's an unintended consequence that is necessarily going to happen, even in cases, for example, set aside what I believe are outliers, set aside the whatever it is, $100,000 visit to the doctor, because that's what the doctor says it's worth. And let's look at what doctors charge for cash pay. The disparity between that and 150% of comp will end up with the patient holding the bag or the doctor pursuing collection. I don't think that's an intended consequence, but it's going to be a consequence. That's what I meant by unintended consequence.
Thank you. Did I hear you correctly say this bill doesn't cap the bill, it caps the recovery?
That's correct.
Thank you. Thank you, Mr. Chairman.
If I may respond, I would
please
just
go
say in
ahead.
practicality, when you're trying to acquire insurance and they won't insure you because of the way that that things are litigated today in Harris County or any other state in Texas, it becomes a real issue for family businesses. We acquire them. We've acquired over 300. My family was a family business. And so yes, there's good and bad actors, I agree, but the intentions may be good or bad, but the facts are the facts. And today, insurance, you either become uninsurable or the costs rise so much, it's very difficult to stay in business. And not just workman's comp, it's auto. And on the face of it, when someone's coming from Cook County, Illinois, or Los Angeles, California, to try in Harris County, fundamentally, we have an issue here in the state.
And thank you both for your testimony. Members, any other questions for either of our witnesses, Mr. Ross or Mr. Adams? Thank you both for being here. Thank you very much.
Thank you, Chairman.
Mr. Chairman, as you bring up the first group of individuals, I just wanted to mention to the senators, y'all have been very attentive, as y'all always are, and if there's ideas that your staff, people you know, I would, as the author, I would certainly appreciate the work of the committee, really. And we do this a lot in B&C, ideas or thoughts about how to work the bill, suggest changes, et cetera. So I just want to make sure y'all all heard that directly from me. Thank you.
And thank you to Swartner. Senator Perry?
I'd just say, Chairman Swartner, I think the last witness made a pretty critical distinction that if you're private pay, non-insured, and a doctor does good faith surgery in that example, that if it falls within that 150 of the range, that, but the actual costs are supported because that's what in that case, a hip surgery needed to rehab that person back, that maybe you can do some type of the lesser of or the greater of, as long as it falls within that reasonable comp, because in that situation, what I understand is the person's going to get a $4,100 check to pay a $20,000 bill, but probably $20,000 is not unreasonable. So some way, Mike can look into that, but that I don't. Kind of goes to what Chairman Hughes was asking today. The private pay keeps coming up. It's a recurring theme. If you're private pay, because you don't have the uninsured, not the private pay, but the non-insured, how is that delta of what the chart does and what an actual cost of reasonable care that was provided, how does that work? So I think that was pretty telling in that perspective. So.
We've seen this obviously in other settings, the surprise billing in hospitals and being, the non-providers of a network, and then you go in, you have a bill, and you're not on network, right? Whether it's sending ER or hospital, and so you get charged the delta of the amount, and so it's a real issue at times that this is in reference in this case of an individual without any health care coverage being billed a certain amount and their potential settlement amount with an insurance company outside of litigation is a lot less than the billed amount. So I understand your concern, Senator.
And thank you, Senators. We'll now open public testimony, and I'll call the panel that I had previously announced. Chair calls Honorable Jim Wright, Charla Aldous, Joseph Montgomery, Cheryl Welsh, and Bill Ward. Again, we're looking for Honorable Jim Wright, Charla Aldous, Joseph Montgomery, Cheryl Welsh, Bill Ward, and I'm going to call a few more witnesses, so some folks may have had to leave. We understand that. In the next panel, we'll be looking for Anthony Holm, Dr. Bita Shakiba, John Esparza, Michael Leonard, and if any of those folks are close by, we can take you on this panel. But I tell you what, we're going to go ahead and get started. But and don't anybody rush or break your neck. But if one of those persons arrives, we'll have them over here on this panel as well. Commissioner, welcome. On the end of the table, you got to get close to the mic. Introduce yourself and give us your testimony.
Thank you. Good evening, Chairman and committee members. My name is Jim Wright, and I am testifying for the bill. I want to be clear that I'm not here testifying as one of the current railroad commissioners, but as an individual, as a small business owner, who has endured the hardships of the premiums from increasing auto insurance coverage cost. I own a business that as part of its services offers transport of commodities, both interstate and intrastate. My main business is housed in Robstown, Texas, which is considered South Texas. SB 30 focuses on providing a path for plaintiffs injured in an accident, which then seek a legal setting outcome allowing accessibility for concisely compensated matrices through a defining and clear measurement. I believe it goes a long way in preventing, among other things, medical damages fraud and more precise definition in calculating pain and suffering and mental anguish damages. These items being contemplated within the bill is one of the real reasons I offer my support. I have seen firsthand the result of blatant abuses. It seems every time one of my commercial vehicles is involved in an accident, a lawsuit shortly follows, regardless of which vehicle is at fault. A particular example is a commercial vehicle of mine leaving my operation. My Robstown operating location is fronted by a highway that is heavily traveled by commercial vehicles. It's a main highway that leads to two of our community's 3 dominant waste landfills. The highway along our property has a maximum speed limit of 35 miles per hour. Our operating property is equipped with cameras, and one of the cameras is positioned to watch traffic along our highway frontage and the operations entrance. Although I was not physically at the property when this particular incident occurred, I was able to view the camera, which clearly showed this particular event. In 2014, one of my commercial vehicles was exiting our property onto this highway. My driver failed to come to a complete stop before entering the roadway, but as the camera showed, I can stop if you need me to.
You go ahead and finish that thought, Commissioner. Go ahead.
My driver failed to come to a complete stop before entering the roadway, but as the camera showed, he apparently did not notice traffic coming down the road and stopped halfway out in the first of the 2-lane highway. The camera showed a work truck approaching at a speed according to camera calculations above the posted speed limit. It was obvious in reviewing the camera's footage that the driver of this work vehicle actually did notice the truck, and there was an apparent attempt to go over to the other lane, but then suddenly turned back, just scraping the front of my vehicle. When stopped approximately some 20-30 feet beyond the position of my commercial vehicle, 3 of the 4 occupants exited, sat and laid in the highway at the front of the vehicle, which was still located on the roadway, and an ambulance was called, and all 4 work truck occupants were transported to a local hospital. When I was made aware of this incident by my safety officer, I was told 3 of the occupants had no form of IDs and were apparently not legal citizens, and the 4th was a citizen and owned the concrete construction company the work truck belonged to. My safety officer stated in his report he had not observed any sort of major physical injuries from any of the occupants of the work vehicle. The incident was reported to my company's insurance carrier, and I asked my corporate attorney if a person not legally residing in our country could bring suit claiming personal injury. He informed me they can and they will be allowed to remain within this country until a decision and a legal claim is made. The result of this incident was a mediation settlement made by my insurance carrier's attorney, and where the driver owner of the concrete construction company received $3.5 million, and each occupant $1.5 million, which was the maximum amount coverage that my company had at that particular time. This is why commercial insurance cost is becoming a cost few small businesses like mine can afford. Today, with the escalating cost of insurance, we only insure equipment that is 100% utilized and parked the rest. This has resulted in revenues way less than what my company has the ability to do. My workforce in recent years has had to be decreased by 60%. It is my hope this bill will cut down made-up claims amounts like the ones I just described. I hope it will make trials and mediations more fair to produce honest results. I hope it will help reduce the cost of insurance, because right now the cost of insurance is about to drive me out of business. Thank you for allowing me to present this testimony to you, and I'll take any questions afterwards.
Thank you, Commissioner. Welcome. Introduce yourself and give us your testimony.
Thank you, Mr. Chairman and members of the board. My name is Joseph Montgomery. I'm a safety supervisor for coastal transport out of San Antonio, Texas. I'm also a former driver of the company. As a professional driver for the past 27 years, I've seen my share of accidents. I was involved in one outside of Houston about 5:30 one morning. It was raining, the lady hit some water, hydroplane, and she ran into me. I did not hit her. I got out of the truck, had a conversation with her, asked her if she was okay. She said she was fine. I asked her, did she need an ambulance or a doctor? She said, no, we just called the police. Police arrived on the scene. All of a sudden, she didn't speak English anymore. So, got to the company. About 2 hours later, her attorney was calling the company following the lawsuit. Her attorney had not seen the video in our trucks, and we do have cameras in our trucks. Once her attorney saw the video, he dropped the case. They didn't see the video. All they saw was dollar signs because they saw this big truck, and they heard truck accident and automatically assumed that I was at fault. There has got to be checks and balances, and that's why I'm here to support SB 30. We just can't allow attorneys that are not above board to just run amok in the system and just do whatever they want to do. Now, people do need to be compensated if they're legitimately injured. I have no problem with that. But I do have a problem with nuclear verdicts that put companies like this man here out of business, or smaller companies that inflate, that have to pay more for insurance because of a verdict. It's difficult to trust the system when you're told that a system is not working. It's difficult to go to an attorney and they tell you, well, this is between you and I, or under the table. I yield. Thank you. I'll answer any questions later.
Thank you for your testimony. Welcome. Introduce yourself and go ahead.
Good evening. My name is Carol Welsh. I am a victim of a 18-wheeler wreck right outside the building on I-35 here. I was moving from Virginia to San Antonio, not even here yet, coming to close on my house, and the truck came from the left-hand lane, the far left. He was not on my tail, didn't brake or anything, and slammed into my car. And I have had 14 back and neck surgeries since that time. My cervical is fused 4 levels, my mid-back is fused 4, my lower back's fused, my SI joints are fused. I had several nerve, I had brachial plexus on both sides, nerve surgery, and I had several nerve, and it's just basically ruined my life. I am a victim and a survivor of this thing, but I wouldn't want to wish it on anybody, regardless of payments, no payments, whatever. It's a horrible thing to get in that situation, especially I was moving from Virginia to here. I didn't know a soul. I didn't have a doctor. I didn't have anything. And I ended up in Austin, and they x-rayed me, or CT scan, said you didn't break anything, you go home. I didn't have a home. So it was in the process of being finished built. So the whole process was very bad. It's ruined my life. I'm a nurse. I was planning on working when I got here, when I got settled. I could not take a job or even volunteer because I'm unreliable. I have good days and bad days. And so I can't sign up for doing a job, with pay or without pay for volunteering, like at church or something, because I don't know if I would ever be able to meet the obligation that I committed to. So basically, I stay at home most of the time. I drive to the H-E-B and Costco, and that's it. I sit at home most of the time, and what I really think about this bill is to really, really think about it and what it be doing for other Texans that are like, or even other travelers through the state that would have a similar accident that, just all of a sudden ruined your day, your life, basically. So anyways, for the others.
Thank you for your testimony. Welcome. Introduce yourself and get close to the microphone and give us your testimony.
My name is Bita Shakiba.
Just a second, Ms. Wells. We may have questions for you, so hold. That's okay. I'm sorry. That's okay. No problem. You're not in custody, but we may have questions for you if you want to stick around for a few minutes. Welcome. Introduce yourself and go ahead, please.
My name is Bita Shakiba, and I'm a root canal specialist. I only do root canals. I got sued fraudulously. I saw a patient, I did a root canal, I numbed the patient, my needle was 21 millimeters. I got sued I got a letter and I got sued a year later that my small needle perforated the mouth and went inside the orbital globe and perforated the orbital globe. Now, the expert witness and the plaintiff's lawyer, they are in the same street, they know each other for sure because they're practicing the same place. And it has been like 2.5 years that I've been like running in circles. I'm like telling people this is a frivolous case. Anatomically, based on human skull, this can't happen, but it has happened. My lawyer, who my practice insurance gave me, we don't still have like the plaintiff's medical history. We don't have any information about the plaintiff. And the whole process has taken time for me to treat my patients. I don't know, do you guys want your doctors to like have these frivolous lawsuits? Because you can't focus when you're like dealing with this. So many hours of my time, my precious time with my kid, my precious time with my patients have been lost due to this lawsuit. So I support the SB 30. And I think like I have been a victim of like a frivolous legal scam. And I hope that you guys will take care of like us, because doctors, dentists, we have like obligation to treat our patients. And yes, all the medical records have to be taken, because if a patient has syphilis, which is a sexually transmitted disease, they might have hearing loss. So yes, we have to get all the medical reports. And then the other thing is transparency. We have to know if like our doctor, who is like my witness, which is the expert witness, knows the lawyer. If they know each other, then this is where everything happens. Thank you.
Thank you, Doctor. Thanks for your testimony. Welcome. Now, since you're on the end, you got to get close to the microphone. Introduce yourself and go ahead.
Yes, my name is Charla Aldous, and I am a lawyer here in Texas. I've been practicing for 40 years. While I am a member of TTLA, I am not here speaking on behalf of that organization. I'm coming here today to speak on behalf of a very distinct part of our population who will be devastated by this bill, and that is survivors of sexual abuse. I have never said this in a public forum before today, but I'm doing it now. I know their injuries because I am a survivor of childhood sexual abuse. And when I listened to Ms. Fitzpatrick, Senator Paxton, with your bill 2420, my heart was broken. She talked about grooming. I wish I could sit down and tell you about the cases that I see on a daily basis. And I wish I could tell you about the threat of having to pay high damages effectuates change. In the interest of time, I'm going to give you one small example, but I've got I have a small firm. My daughter practices with me. I have one other lawyer. I've got 5 cases right now that if I could show you what's happened to these children, these girls, and show you what this law is going to do to them, I can't tell you how I'm pleading with you not to include sexual assault victims in this bill. I wish I could talk about other parts of the bill because there's so many things that concern me. I had a little girl that went to a private school about 12 years ago, and she was groomed by a teacher. She was around 13, groomed by a teacher for months and months. We had the evidence, and I didn't even understand the extent of it. She was groomed by that teacher who sexually abused her for over a period of months. The school found out about the sexual abuse. This little girl had gone to this school since she was in kindergarten. Her 3 older siblings had gone to this school their entire life. It was this family's entire community. What the school did when they found out about, may I continue?
Yeah, go ahead and finish the thought. Yes, ma'am.
Okay. When the school found out about the sexual abuse, they allowed the teacher to resign. They brought my client's father into their office and said, we know what happened. We don't want this taint on our school. You can withdraw your daughter or we will expel her, and there is no door number 3. They wrote that in an email. Another email revealed that they said they did not want this girl haunting their hallways with her sad, sad story. These parents had to come home and tell this little girl she could no longer return to the school she had gone to her whole life. She was suicidal when I started representing her, but I told her I would give her a voice. This school wanted to pay money, their insurance company wanted to pay money. I said, no, you're going to make policy changes. Because there were policies that were allowed in that school that allowed red flag after red flag after red flag to take place to allow this grooming to take place and this child to be abused. Well, I went and tried this case, and I'm usually not afraid in court, but I was scared to death. And the reason I was scared to death is because this child's teacher had betrayed her. Her school had betrayed her, and all the studies show that secondary victimization is worse than the actual assault. And I thought, God, what am I going to do if this jury betrays her? But the jury didn't. The jury awarded a verdict, and they awarded a verdict for millions of dollars, which I had never expected. But guess what? As in so many of my cases, after this verdict was awarded, the school and their carrier came and sat down, and they said, okay, we'll make the changes. Significant changes that will save children in the future. And we took so much less than what the jury awarded. But I can tell you case after case, I'm sorry, I'm very passionate about this, that would show you, I've got a rideshare situation right now. Can I keep going?
I think there's going to be questions as well. And Senator Schwartner had asked, and then we'll have Dean Zafrani after that. Senator Schwartner, you're recognized.
Thank you, Mr. Chairman. The adjudication of sexual abuse cases, are they done through Chapter 41 of the Civil Practices and Remedies?
I'm sorry, I can't understand you.
Are sexual abuse cases adjudicated through Chapter 41
Yes.
of the Civil Practices
Yes.
and Remedies Act? They are?
Yes.
Okay. That's what I wanted to know. Thank you.
Can
Go
I
ahead.
talk now?
Well, I think Dean Zafrani has a question as well. Dean, go ahead.
Thank you, Mr. Chairman. Ma'am, that's a horrific example that you gave us. But looking at this bill specifically, how would you amend the bill to address cases like yours and to ensure that they are not repeated?
Well, let me tell you, first of all, I am speaking on behalf of sexual abuse victims, but I take issue with a lot of what I've heard from some of the defense lawyers. I did defense work for many, many years. I still represent a lot of physicians. I have a small practice. But I'm telling you, they talk about nuclear verdicts. And this ties into the sexual assault victims. Every case, and I've had some really, really big verdicts, but every one of those cases, they did not give me a fair offer. When somebody said insurance companies are fair and reasonable, I can tell you in my experience over 40 years, some of them, yes. A good majority of them, no. Most of the nuclear verdicts that I have gotten, I got one last 6 months ago for $74 million. We would have settled for a fraction of that, But they said no. Now, I'm asking for a remediature because our Texas Supreme Court is taking care of these nuclear verdicts. They are. I'm asking for a remediature in that case to lower the amount to a reasonable amount so that my clients can be compensated. But for that quote-unquote nuclear verdict, it would have never happened. You hear these things about what's going on and what's wrong, but I want to tell you, these nuclear verdicts that they say are nuclear are being handled by the Court of Appeals. But what you're doing, and with sexual, I've got a case where a rideshare case, where she was a dentist in Dallas, went out for a drink with a friend. The rideshare company picked her up with her friend, took her friend to her apartment. She was in the car. He said, you're going the wrong way. He said, well, let me see your phone. She handed him her phone. He pulled out a gun and said, I'm going to kill you if you don't stop and pull over to this field. He violently raped her in the back of that seat. I find through discovery that 10 days before this woman was picked up by that Lyft rideshare driver, 2 different women had complained to the rideshare company about sexual advances this very driver had made.
But ma'am,
those safety calls are outsourced to Guatemala.
But my question, ma'am, is about, you said specifically, I wrote it down, survivors of sexual abuse will be devastated by this bill. Chairman Schwartner has invited the members of this committee to work with him in developing this bill. You could tell, I hope, by my questions that I have serious concerns about this legislation. What I want to know from you is specifically how would you amend this bill to address this issue? I know you have many, many cases to share with us, but we need to work on this bill. How would you amend it?
I can tell you this, the caps need to be taken out. And they say they're not caps, they are caps. If we have caps on our damages, it takes away our big stick to effectuate change. And I know there's a lot of the bad stories that you've heard, but you got to understand there is some good work being done. And we can say you have got to make policy changes or this is what you're facing. And then after we get a nuclear verdict, we can use that verdict to effectuate the policy changes. Does that answer your question? I'm trying to.
Not quite, but maybe you can look at the bill and get back to us. But thank you.
I would love to.
Thank you.
Can I say one more thing?
I think there may be more questions. Senator Paxton had questions as well, so I'll recognize her at this time.
Thank you. I wanted to clarify, make sure I heard you correctly. I think what you said was that the nuclear verdict came after there was no willingness to settle for something. Is that correct? So you try to settle, and that would be your preference, and you're willing to settle for much, much less, and there's...
And Senator Paxton, I can't tell you the number of times that has happened to me. Time and time again, we demand what we think is a fair compensation, and we're just snubbed. But also, I believe in policy changes. I believe that you bring a lawsuit not just for economic recovery. I believe that I have a duty. This is not a profession to me, it's a calling. I believe that I have a duty to effectuate change that will prevent something from happening to other people.
Well, thank you. And I think that's, I do think, Senator Zaffarine, I think what you're saying is you see this as child sexual abuse or sexual abuse in general is kind of its own sort of thing, and it does deserve a certain kind of treatment. I think you were asking something about that as well, Senator Schwartner. Thank you. I appreciate that.
Senator Betancourt, you're recognized. Thank you, Senator Paxton.
I just want to thank you for your testimony.
Thank you.
This is a complex issue, okay? And it's very multifaceted. And for every, I can ask the rest of the panel, they're already shaking their heads yes. So so we're here to listen and to understand what the implications of the public policy of this are. So I just, because I think everyone knows that these sexual assault cases are some of the most difficult ones to get adjudicated, get a settlement on, historically. And so I just want to make sure that you understand that the panel, especially some of the members, have direct experience with this problem. So thank you.
Can I tell you some good news, though? My client, I read the scripture at her wedding. I was at her law school graduation, and she's thriving.
Members, any other questions for these witnesses? We thank you each for being here. Thanks for your testimony. You're excused. We'll call our next panel of public testimony. Then the chair calls Anthony Holm, John Esparza, Michael Leonard, and still looking for Bill Ward, Shermiao Cohen, Ben Patterson, Sasha Norman, and if you get, there's one more seat over here. If you get to the table, there's not a seat, we'll get you on the next panel. We just want to make sure folks are ready. And so for the next, in addition to the names we have here, let me just go through a few more, and some of you may be here, but on this panel and the next, we're going to be looking for Michael Horton, Alexis Reza, Ben Patterson, Michael Leonard, Bill Ward, Shmariahu Cohen, Sasha Norman, John Esparza, Bradley Pearson, Anthony Holmes. So if I called your name, stick around close. Oh, no, very good. No, you're good. You're in the right place. Thank you. You're in the right place. We're trying to have plenty of witnesses ready so we can hear from folks who want to testify. Thank you for being here. And when you're ready, introduce yourself. Give us your testimony now. Since you're on the end, you got to get close to the microphone so we can hear you. Go ahead.
My name is Ben Patterson. I'm president of Patterson and Associates Insurance Agency, of which I joined in 1996. Our agency has been in business for 41 years in Richardson, Texas. I currently serve on the board of directors for the Independent Insurance Agents of Texas and for the Allen, Texas Economic Development Corporation. Over the last 10 years or so, I've watched commercial auto insurance rates skyrocket, where what used to be maybe a $1,400 per unit premium is now more than $5,000 to insure. The market is very limited and almost shut down to commercial auto and higher umbrella limits. Litigation reform will bring competition back and an interest to underwrite commercial auto and umbrella. Our own commercial auto this year went up 30%, so we're not immune to this, even as an insurance agency. Texas prides itself for being business friendly, but what we have been known for is starting to lose its luster.
And thank you for your testimony. Thanks for being here. Welcome. Introduce yourself and give us your testimony.
Good evening. I'm Shmaryahu Cohen. I am 20 years old and I am from Houston, Texas. I'm here today in opposition to Senate Bill 30 as it goes against individuality of people with traumas and ongoing mental health problems. I'm here today to present my testimony involving my own personal abuse that started when I was allowed to be adopted along with 8 other boys by a serial pedophile. This abuse was not just sexual, but was also physical, verbal, and emotional, and the effects will continue for the rest of my life. My abuser, Chaim Nissim Cohen, who was named at birth as Jeffrey V. Hill, was allowed to adopt several boys without any proper background checking or investigation, and as a result submitted false information without verifiable references. I was groomed at 11 years old, which started when my adoptive father forced me to lay in bed with him, which rapidly escalated to oral sex and ultimately became anal penetration. I was constantly degraded and forced to wear a dress while my adoptive father masturbated. When this became insufficient for Chaim, I was forced to perform what can be described as live pornography by being forced to have intercourse with my little brothers. This was extremely traumatic and is inexcusable, but was able to continue happening throughout 7 long years with no repercussions. I was also forced to perform live streams and TikTok videos for revenue, and if I refused, I would be beaten. Me, along with my brothers, were locked and confined in a room for upwards of up to 23 hours a day, which on multiple occasions was hot and humid from 7 boys sweating without access to water unless it came from a sink. We were not permitted to have clothes other than underwear. Chaim forced us to act out in ways that allowed him to write off mental issues, to get medications for us without proper background checking or proper testing. He also had us placed into therapies that were unnecessary for our conditions. We were not fed properly and we would only get a single meal every day at 4 p.m. with our medications. Is my time up?
Yeah. Go ahead and finish your testimony, please.
Thank you, I appreciate it. Refusal meant not eating anything at all. Food was often used as a threat and would be taken away if we didn't do what Chaim asked. We also were removed from public schooling upon adoption and forced into homeschool under the name Etz Chaim Yeshiva, which was a lie and contained 0 academic values. As a result, I have a 4th grade education. All of these experiences continue to affect my personal life, such as nightmares, anxiety, and panic attacks. Frequent flashbacks, fear of therapy and medications, confused sexual identity, struggles with trust and self-esteem, and internal pain and feelings of guilt and self-depreciation. When I think back on what happened to me, I can only describe it as a personal hell, and I ask, how can you place a cap on 7 years of hell? And this will become a lifetime of trauma. Stressors commonly cause physical pain as well, such as dizziness, nausea, difficulty breathing, shortness of breath due to the malnutrition. It has affected hormonal function, which may be permanent. I also have issues with social expression, internal anger, and compulsive behavior, as well as unnecessary risk-taking behaviors. My rights won't be affected by this bill. However, those children who are forgotten, abused, raped, and brutalized will no longer be able to tell their story to a jury or to determine their actual harm and damages, because their suffering and mental anguish and impairment will be capped by a law that is unfair for people just like me. And unfortunately, that number will continue to grow. Thank you for allowing me to speak today.
Mr. Cohen, thank you for being here. Thank you for your testimony. Introduce yourself. Go ahead.
Thank you, Mr. Chairman and members of the committee, for allowing me to speak. I know it's been a long day. I appreciate everybody's patience and hanging in there. My name is Dr. Michael Leonard. I'm a neurosurgeon in San Antonio, Texas, and I'm the president of the Texas Association of Neurological Surgeons. I am authorized to speak today on their behalf by unanimous vote of the board of that organization, and I'm here to voice my opposition to SB 30. I oppose this bill for the following reasons. Number one, it ignores economic reality. When treating injured patients, these cases typically involve long delays in getting settled, sometimes as much as 4 or 5 years. There's a high default rate where nothing of the bill is ever paid. There's a high cost specifically and associated with treating these patients, both in time and money. And of course, overhead as a small business association, a small business owner doesn't wait. Those bills for me are due every month. Currently, very few physicians in Texas treat injured patients precisely for the above reasons. This bill will force those few physicians who do treat these patients to deny treating these patients in the future, which will lead to a crisis in healthcare access for injured Texans who lack health insurance, driving them to our local ERs, which will exacerbate the care issues that these facilities currently face. For those patients with insurance, many are employees of small businesses, and these costs that will be added to their health insurance plans will lead to skyrocketing premiums for their health insurance, which will be very devastating for Texas small businesses. Finally, as I'd like to say, as a Republican myself, I've been told most of the members of this committee are Republicans. I understand we're supposed to be the party of small business, entrepreneurship, and free market ideas, but this bill seems to me more like big government dictating a solution that hurts everyone except the out for party and their insurance company. Thank you very much.
Thank you, Doctor. Welcome. Introduce yourself. Go ahead.
Thank you. I'm Anthony Holm. I'm a Republican pro-tort reform trial lawyer, so nobody here likes me. Son, that was one of the more brave acts we've seen. I have 8 substantive points, and Senator Zaffirini, I have solutions as well, or suggestions, and I think some clarities as well, Senators, and some of the questions, but I'm going to try to get as quickly through I can as the key ones. I want to flag for everyone that this bill, as written, says it is a reversible error as a matter of law to consider the value of human life for born, unborn, or a young man like this who suffered those tragedies when considering mental anguish. It says it verbatim on page 20. Affirmatively an error under the law that this body is asked to vote on. Born, unborn, or trauma like this. I suggest to this body it reduces substantially the value and the sanctity of marriage, because a loss of consortium is a current claim and it eradicates that. It says mental anguish is now defined as a litany of things which includes loss of consortium. So, and that's capped. I would agree aggressively that this is a cap, unequivocally. We have remitted, or this is to remit. It's a workaround over the 3/5 issue. It's a cap. So consider, for example, someone who is burned over 95% of their body. Well, they're going to lose consortium with their spouse. If I were burned over 95% of my body, my spouse has a very different life ahead for the next 30 years in our marriage. My past mental anguish, my future mental anguish, my loss of consortium are now lidded at 250. I have terrible burn victims. I'm not trying to scare anybody. These photos are brutal. $250,000 is offensive for these type of injuries and damages. We've also had some testimony earlier saying, hey, let's have 150% keyed to a database. Maybe, I think that's probably flawed policy, but if we're going to do that, we certainly should we not also make it the policy of the state of Texas that a doctor or medical provider shall accept as full and final settlement that same amount? Because these liens are similar to house liens. I have 3 other points that I'm happy to take on questions, and I think there was quite a bit of confusion on discovery and admissible of evidence.
There'll be some questions
sir.
for the panel, I'm sure. Thank you for your testimony. Welcome. Since you're on the end, get close to that microphone. Introduce yourself and go ahead.
Thank you, Mr. Chairman. My name is John Esparza. I'm the president of the Texas Trucking Association. I'm here to share the industry's strong support for Senate Bill 30. The industry has been subject to the growing practice of fraud within the lawsuit landscape in Texas for quite some time. You've heard a lot of testimony here thus far today, but the fraud part of it is the thing that we've heard our defense attorneys speak to it. And in deference to, I think, Mr. Adams earlier on the final panel, I think that was the only admission of the fraud that it's occurring that I've heard thus far. This is specifically what we're looking at. The fraud in the industry that has gone on for years in the state of Texas to a greater extent than other states that we've seen. We've got carriers that run all over the country. And by and large, when we are seeing issues in which insurers are putting a Texas premium on the ability to move freight across our state of Texas because of that environment that's here, this is the biggest challenge that we're having. We're also seeing, to the conversation earlier of the dockets, there's so many cases that shouldn't be tried in the state of Texas that are being brought to the state of Texas. If there's a connection, a way to connect, this is what they'll do. What is that doing to the dockets that we're seeing in the state today? We have hundreds of thousands of trucking companies in this state, all of which put their own families on our highways. It is our primary goal to affect safety in a manner that is positive and encouraging. And the irony of what we're not doing, if we are unable to make changes, is creating an environment that is even less safe. More and more companies are closing their doors that take the time and take the effort and the dollars to ensure that they're moving their freight safely across this state. The fear that we have with the growing amount of freight in this entire state, Senator Zaffirini, no more so than in your district, most certainly, crossing the border at Laredo. It's amazing how much freight is moving, and the concerns that we have for the future is that our companies are not going to be able to afford these rates that are compounding. Thank you.
Thank you for your testimony. The Dean of the Senate is recognized. You have the panel.
Thank you, Mr. Chairman. Mr. Holm, you said you had 3 more suggestions for improving the bill. Is that right?
Yes, ma'am.
What are those?
One of them, just to ensure that we heard it, was if we're going to peg to 150% of a database, then it's got to be able to not drive a person into bankruptcy. The doctors and the hospitals also have to accept that as full payment because we do have medical liens, and they go on to the settlement. You have a duty to pay it, just straight up. Some negotiations are sometimes permitted, but quite often they're not. It's a lien, number one. Number two, so there's the bucket of discovery, which means we're all going to share information, but that doesn't go in front of the judge and it doesn't go in front of the jury. What this bill actually says on pages 19 and 20 is, number one, all of the medical records must be available. We've heard a lot of testimony on that, and I won't go back into it. But number two, they shall be admissible. That's different than discoverable. They shall be admissible, and they shall be admissible by any party. So what does this mean? This means that a woman who had 5 miscarriages and now sues an individual for the mental harm of rape, they get to all that information, and if the defense counsel chooses, it shall be admissible. I think that just has to be struck. That's so onerous. Keep it in discovery if that is the will of the body. Currently, the judge decides what's inbounds and outbounds for discovery, but making it admissible is really tragic, and it will stop people from coming in. It will 100% limit it. I would, of course, honor the sanctity of marriage and have a standalone claim for loss of consortium. I would suggest that the body strike as an affirmative statement, which says, in an action to which this chapter applies, it's reversible error for a court to allow an attorney, witness, or other person through argument or introduction of the evidence to, and drop down, characterization of an award of damages for physical pain, suffering, mental, emotional pain, anguish, as establishing a value of life. Okay, what does this mean in practical terms? Drunk 18-wheeler driver T-bones a lady who's 9 months pregnant and she's due on Friday. She loses the baby. She cannot say, I lost life. I'm anguished for the rest of my life. How do I value this? I can't. It's a reversible error as a matter of law, and that's what the body is being asked to affirm into law. Okay, the multiplier, hours, the marriage. Yeah, and that's what the body is being asked, but that's also what the jury pool, your constituents, are being instructed, that you can't bring in or hear about the value of life. Damages beyond the value. Currently, they are instructed on community values, and that is right and appropriate. And then just the limitation of 250 across the board. If a woman is raped by an illegal immigrant, the lid is 250 on mental anguish. If a child is pulled into a Walmart and molested by the security guard, that's 40 or 50 years potentially of therapy. That's a lid of 250 on mental harm.
Thank you so much,
Yes,
Mr.
ma'am.
Cohen. Thank you for your courage and sharing your story with us. And Dr. Leonard, I'm the only Democrat on the committee.
Sorry?
I'm the only Democrat on the committee.
Oh, yeah. I was told that.
Senator Betancourt, you're recognized, and then we'll go to Senator Paxton.
Thank you, Mr. Chairman. Anthony, just so you know, one of our committee members, Senator Birdwell, has had 57 operations after he survived the Pentagon attack on 2000, back on 9/11. And I'm not sure if he was burned on 95% of his body or nearly almost all of it. But he breathed two-phase plasma at over 300 degrees and somehow survived. So we have seen a lot of burn victims. But if you needed to, you can always show your exhibit because his book, Refined by Fire, is pretty similar to that. So
And this isn't the worst part, Senator. What I didn't bring was the audio of debrisement where they have to cut away the dead skin. I've never heard anything like it.
well, I've only
They're
heard,
screaming, saying, please let me die.
I can only tell you that publicly, there are times that Senator Birdwell was ready to have his maker call him home. And he said it publicly in his book. So we understand the problem. We also understand that the trucking industry has a problem with their cost structure, especially with these type of awards. And, this is such a multifaceted problem that we're going to maybe go all the way down on Occam's razor, and we may end up having to divide that atom at the end to find balance here. Now, I want to spend my time just telling you, I didn't catch your name, son.
My name is Shamar Yahu Cohen.
Okay, Mr. Cohen, I just want to say that to come here and be able to take this step means that you can leave the past behind and that your life is worth living. Because I know at times you have thought it has not been. But the fact that you can come into this chamber and be able to describe what happened to you and be able to do it in such a manner that the only thing I saw was a little bit of shaking of your hands on your script means that you have the future before you. And no matter what happens with this bill, I want you to know that we know that you have value. And we want you to be with us in that future, no matter how this bill comes out. Because I know what you did today took a tremendous amount of courage to be able to come and do that.
Thank you.
Thank you, Senator Betancourt. Senator Paxton, you're recognized.
Well, thank you. And Senator Perry, do you mind? Thank you so much. Mr. Cohen, if I could just begin and say that what you've done today demonstrates tremendous courage and dignity. Thank you.
Thank you.
Everyone else is here talking about, and you're talking from, and we appreciate it. It's helpful for us to hear your story. And it makes a difference. Thank you.
Thank you.
Anthony,
Yes, ma'am.
you've given us a lot of examples of where this kind of ends up falling out of bounds, I think, maybe for what a victim would need. And there's been some discussion around, when we talk about economic damages, we can look at numbers, right? We can look at bills, and although I understand many times that those numbers at the end of the day don't add up to the actual expense that someone is under. But when it comes to mental anguish and pain and suffering, could you just give some insight into how do you arrive at a number? There's no formula that's apparent to me, but could you kind of talk about that a little bit?
Well, some of it has evolved recently with Supreme Court precedent, and there's some things that they've said you can't do. Someone spoke to the Grayson ruling earlier. It is somewhat arbitrary, and it is based on the jury's standards and values. Like, I don't think anybody necessarily has a malintent on this bill. A $250,000 mental anguish lid for somebody who has PTSD, who's 45 years old from a crash, that seems pretty reasonable to me. But again, to me, it's subjective. The problem comes on these other examples. And even the $1 million lid on a death. Well, maybe that's reasonable, but what if you have 5 kids, right? And the loss of the next 25 years of a parent for each of the 5 kids. We're equating that to $200,000. The bottom line is, and I can go through lots of examples, but ultimately where I've come out is none of us can. And when you leave it to the juries and to the masses, they usually get it right. All of this is under the banner of nuclear verdict. And nuclear verdicts are crazy. They probably shouldn't happen in society, generally. But guess what? They really don't. Even the ones that get done at the trial level, a judge can currently have a remediator, and guess what? They can set it up and it gets popped on appeal. We've seen it over and over and over again, and the system largely does it. What this seeks to codify is a roadmap for the defense counsel and the appellates to overturn it. If it's $250,001. That's my read on it, just straight away, and why I fervently believe it's a cap. So the bottom line, to answer your question, ma'am, I don't believe any of us could. But I could give lots of examples of doctors on the defense side, slow roll. And we've heard about all the claims on the pro plaintiffs doctors. They're on all sides. I could give tons of anecdotal examples of LOPs that go both ways, because it all does happen a little bit. Everything that you guys are concerned about happens in the fringes for sure, and it happens on both sides. We could maybe solve them. But taking it out, most of these decision trees out of the jury and a thoughtful judge and the appellate court system, I don't believe is a solution. We just aren't going to be able to value human life, us as legislators, without a fact pattern. It's different on each one. I understand that there's a whole bunch of 18-wheeler truck litigation. I do a lot of it, actually. I went to CDL school and learned to drive them up and down and everything else. And I've seen cases where a guy's FaceTiming his wife talking, doesn't notice the red light, drives right over a grandma, grandpa, their grandkids to the left. Well, so that's a death case. Okay, you could probably put a value on that. But guess what? Right beside that grandma and grandpa at the stoplight that the trucker didn't see was the mom and dad and the other kid. They were all at dinner. Or actually, it was lunch because it was daylight. They were at lunch, and they were driving home, and a couple of the kids said, I want to ride with Grandma and Grandpa. And they were all going back to their homes, and they were side by side at a red light, and an 18-wheeler driver was FaceTiming his wife and didn't look up. And just, you couldn't even tell it was a car. So how do we value the trauma or a life in that situation without knowing that the little brother and sister watched it happen, and their words, I don't understand what that gray stuff was that was on the windows. Well, they're going to understand that it was brain matter when they're adults, right? Like, unless humans have the specific facts, I don't think it's reasonable to sit anywhere and try to dictate it on the front side. We have fixes if the humans who have the specific facts get out of bounds. Remedier, which exists, appellate courts overturning. We do it well in Texas. So,
Thank you. So what you just said, that element of things, how do you incorporate that into this bill? What do you do with that in this bill to make it the way that it would make more sense to you anyway?
Well, you can try to do a list of carve-outs, and you won't catch them all, right? Perhaps sexual assault, perhaps minors, perhaps unborn, perhaps children, loss of parent. There's all, you can do a list of carve-outs, but we'll invariably miss some. We'll come back with more and more. Or you can strengthen the appellate system if you're really concerned about it getting out of bounds, but I'm going to suggest that we have them. We'll get a headline of a nuclear verdict, but it never gets paid because it goes up to the appellate court and it gets fixed, just like a system should. Very rare. I think there was someone who was going to testify, I believe they had to leave, but my understanding was there's been 3 quote-unquote nuclear verdicts that have stuck in Texas over the last 15 years and been paid. Certainly some have been awarded. Many have been awarded, perhaps, and we see them in the headlines. I'm just suspect that that is a credible concern of having to pay $15 million for a broken foot.
Thank you.
Yes,
appreciate it.
Mr. Sparza, you wanted
I had just one comment. When we're talking about the cases that, one of which he just mentioned, these are cases that there's fault found. And when there is fault, we're not talking about that. We're talking about the fraud, and this is specifically what we're looking at. Cost to the community, cost to the state. The U.S. Chamber of Commerce just recently put a study out in which the cost that we're seeing in all of these fraudulent cases is now reached over $4,594 per family, Texas family, per household. So there's an actual cost of who's taking on these $15 million deficits, these bills that we're saying, they're getting paid. This is part of the issue that we're here to talk about, is the abuse that we're seeing within that scope. And there's no question in my mind, and I heard this earlier, we want to be able to see the doctor that is the best. Well, the best by who? I think that's the problem, is that I have no doubt that person that spoke about that earlier, that trial lawyer that said it, we want to be able to communicate to our client who is the best doctor. But not every case is like that. That's not what's happening across the board. We're seeing abuse there, much like not every judge is created equal. This is part of the challenge, and I know this is what this bill is seeking to address.
Mr. Strong, go ahead.
Yes, sir. Just briefly, anything that's fraudulent in the medical system, or frankly the legal system, increase the penalties, 100%, and I'll help you all I can. If there's a lawyer doing something fraudulently, let's go get them. I sent a note about Barrontree and case running, but here's the nugget here. Either you get to, in Texas, you get to choose a doctor, whether they're in your plan or not, and seek the care that you want, or you don't. I mean, this is kind of the Obamacare problem, right, that now we're talking about here. Well, you can see the doctor that you want, but we may not pay for it, or the jury doesn't have to pay for it. If we could all pay Medicare and Medicaid rates, that'd be exceptional. But we can't. Yes, sir.
Senators, any other questions for these witnesses? Dean Safrini, you're recognized. I thought you were turning it on. You were turning it off. I apologize. Senators, anything else? We thank each of you for being here. Thank you for testifying. The chair calls Megan Farrell, Adam Blanchard, Michael Wharton, Alan Riddick, Sasha Norman, Bradley Pearson. All right, welcome to each of you. We'll start over here, and since you're at the end of the table, you got to get close to that microphone. Introduce yourself and give us your testimony.
Yes, sir. Thank y'all. My name is Alan Riddick. I am the DOT manager for T&T Crane, based out of Houston. We're a Houston-based company, and we're all over the United States and Canada now. And I'm not going to bring up individual cases or anything, just for a matter of time, but I handle the safety and the weight for DOT, and been doing some risk management for some time with our company. We now have a full risk management department that's separate from that. But and what had been brought up here before, we just want a fair playing ground. That's all it is. We just want a fair playing ground. If it's a $1,500 damage to a car, and it's some soft tissue, and the person goes for 5 treatments to see a chiropractor, and then later on, a year later, we get served with a lawsuit, and before it's over with, it's $2.1 million. Where did that come from? It's hard to calculate that, and it's hard to keep that going. When so you just you get shell shocked for that, and it happens quite often that it comes like that. And I travel around the United States, and it's what was brought up earlier about people coming in from other states. I travel around the state, and I drive a lot because I carry my scales, my portable scales. I've noticed a lot of billboards that used to not be in other states with lawyers standing there wanting to get you some money, is what they say. I notice them with Texas lawyers on them in other states now. Why are they there? There's got to be a reason. So it's really difficult, and it's really raised our insurance is just astronomical. What we were paying 7 years ago, it's just gone through the roof.
Thank you for your testimony. Welcome. Introduce yourself and go ahead.
Yes, my name is Megan Farrell, and I'm here representing Texas Towing and Storage Association.
Get a little closer to the microphone. Go ahead.
I'm sorry. Texas Towing Storage Association, as well as my family-owned business in the Texas Panhandle. I am in support of this bill. Our system is broken, and we need help to fix it. I agree that the nuclear verdicts and the abusive lawsuits in Texas have gotten out of hand, and we need to do something for that. I do not want to mix up that if it happens and it is needed and warranted, we're gonna support that and we're gonna pay it. But you're talking about frivolous lawsuits that are fender benders, nobody's hurt, and 2 years later we get sued for millions. So that's got to stop, or we're all going to be out of business. So thank you for your time.
And thank you for your testimony. Welcome. Introduce yourself and go ahead.
My name is Michael Wharton Insurance in Austin, Texas. We've been around 52 years. I've been in the business 35 years. I have a degree in business from Baylor University, where I spent 200 hours in this building in 1989 doing Texas workers' compensation reform. We don't have any cost containment in our Obamacare. We don't have any cost containment currently in the auto liability situation in the state of Texas. I represent 4,500 to 5,000 businesses here today. Hines Pool and Spa, Andy Hines, has 56 units here in Austin. They service and support swimming pools for property management companies and residences. Last year, his insurance was $200,000 out the door. That included property, general liability, auto, umbrella. This year, his auto alone was $600,000 just for the first primary limit of $1 million, and another $200,000 to get to a $5 million umbrella limit that was mandated by the property management companies that he contracts with. The man is barely hanging on. The reason that that man's insurance rates are the way that they are is because he had 2 or 3 frivolous lawsuits against him, vendor benders, less than $15,000 in property damage. Those closed for $200,000 to $300,000 each. The next nearest alternative from that was close to $2 million from some layered insurance programs that are not even standard. The other person that I'd like to bring to mind today is Meta Ready Mix, an educated man, runs 23 trucks. 5 years ago, each truck would have been $14,000 per concrete mixing truck. The latest one he purchased last week, the insurance is $42,000. You have to mix and deliver a lot of concrete to pay for that. There's so much more here that I could discuss in 13 seconds. I would love to sit down with Senator Schwartner about what we can do to move the bar here. I know that what we have going on is what we call doctor shopping.
You can finish that thought. Go ahead.
So just like workers' comp in 1989, we had doctor shopping. We have medical providers right now that are in the network of these attorneys. It is a racket. And you were talking about fraud earlier. Technically, it's not fraud. You just have different pricing levels. The reality of it is in 1989, we had cash prices for workers' comp. We had health insurance prices where people didn't have workers' comp, and then we had work comp prices, which were through the roof. And that we're talking medical expenses. Just like when I testified in DC, we need to go to a POS system, which is a point of service. You break 2 arms, it's $763 out the door. And the reality of what's going on is that everything's being padded. And so those costs are added to the ultimate verdict. And when you have international investment companies that are investing in lawsuits in Texas, something's going on here that we need to fix. Thank you for your time.
Thank you for your testimony. Welcome. Introduce yourself and go ahead.
My wife, okay,
Go ahead.
start over. I'm Bradley Pearson. My wife Leslie's with me over here. We're from Newark, Texas, just north of Fort Worth, and we oppose Senate Bill 30. So this day, today, March 31st, 2025, is the 5-year anniversary that our son was killed and run over by a cement truck. He was on his way to our house, and cement truck driver talking on his cell phone turned in front of him and hit him head on and killed him. So we sued, and we've obtained justice. Well, the driver was a felon, drove for Burnco. We have sued, and but we brought to attention a lot of their safety failures in that company. So hopefully those have been addressed where tragedies like this won't happen to others. And that was our goal. Just don't let it happen to others, you know. But, you know, as a parent, you're not supposed to lose a child. He was 28 years old. He was my only son. So, you know, we were looking at land to buy together, to build each of us a house, to build me and him a big workshop. You know, we had common interest in that. Well, that's gone. Never, you know. After that, my wife went in deep depression, you know, contemplated suicide, and thankfully she didn't go there and that. But feel that the Senate bill effectively caps the money that can be awarded to families, like in our worst scenario, and arbitrarily devalues life and loss, you know. So, I mean, it can happen to anybody. It can happen to any of us on the way home tonight, you know, and when it affects your family, you know, it matters. But I think if it's passed, it won't hold a lot of these companies liable. If 250 is the max, that's a slap on the hand. So I just feel it's important to hold them accountable to those standards. So thank you for listening.
And thank you for your testimony. Thank you. Thank you for being here. Welcome, and get close to that microphone. Introduce yourself and go ahead.
Honorable members of the Texas Senate, my name is Sasha Norman. I'm a corporate attorney. I've been practicing for about 20 years. Since starting my career in big law to working as Associate General Counsel for a publicly traded company, I've represented corporations big and small. But I'm not here as an attorney, but as a constituent and a mother. And I stand before you to urge you with every ounce of my being to vote no on SB 30. When my beautiful son, who I have a picture of right here, was 5 years old, a defective product changed the course of his life and devastated our entire family in one instant. A product that should have been safe, something we trusted, was defective and led to my son experiencing severe burns over 13% of his body, including half of his face, neck, chest, and arms. He endured agonizing pain, and us with him. He endured surgeries, skin grafts. You heard earlier about the pain of debridements. My son had 5 over a period of 2 weeks, and years of medical treatments and daily physical therapy. His screams from that morning and the pains from these treatments still haunt my dreams. We didn't let him look at himself in the mirror for months so that he wouldn't be frightened by what he saw. After he healed from the original injury, we've been dealing with the remaining scarring, which continues to change as he grows. But the physical scars are just one part of his story. He's experienced a world that looks at him differently now. He hears the whispers and the stares that last just a moment too long. He has to answer questions and sometimes rude comments from adults and children alike about the source of his scarring and disfigurement. I've had to watch him nervously going into every new environment, hoping that nobody notices the obvious. As a parent, I wonder how this will affect his future, his confidence, his mental health. With SB 30 specifically doing away with compensation for disfigurement, you propose that this suffering doesn't warrant any compensation, that a disfigurement, that's something that will affect a person's ability to make a living, to interact with the world, should be met with nothing. That potential future medical needs, psychological care arising from this disfigurement, should be left for the victim to shoulder alone. Even though we had medical insurance, we were drowning in bills. Medical insurance doesn't cover cost of medical procedures for disfigurement because it's cosmetic. What you are considering is not just legislation, it's a message to victims of horrific preventable injuries, that their pain doesn't matter, that their futures do not matter, that those responsible will not be held accountable. You're sending a message to the responsible parties that Texas is a safe place to inflict harm with limited consequence. Let me be clear, disfigurement is not just a cosmetic issue. It is a lifelong burden. It can affect employment opportunities, social interactions, mental health, and self-esteem. It can mean years, decades of surgical procedures, therapy, and emotional struggle. And without the ability to seek just compensation, without insurance to cover the cost, victims are left abandoned. I ask you to look into your own heart, senators. Imagine if it were your child, your grandchild, your loved ones who suffered as my son has. Imagine not having the resources to provide the lifelong support needed. And now imagine a law that mandates that the effects of this type of horrific injury deserve no compensation, or at best, a capped compensation. So I'm saying please vote no for this bill.
Thank you for your testimony.
And I have an image if you guys would like to see the before and after of my son.
Yes, ma'am. Thank you.
Can I show it?
Yes, ma'am.
So this was my beautiful son before, and this was his injury. Very traumatic.
Thank you. Senators, any questions for any of our witnesses on this panel? We thank each of you for being here. Thank you for your testimony. Thank you. The chair now calls Adam Blanchard, Mary Myers, Charlie Pfeiffer. Darcy Mayan Gowie. Ty Turkett. And Susan Sizemore. And that'll complete this panel. And in a moment, we're going to be looking for Pam Grooms, Graham Van Dusen. All right, welcome to each of you. We're going to start over here. Since you're on the end, you need to get close to that microphone. Introduce yourself and go ahead.
Thank you, Senator Hughes. My name is Adam Blanchard, and I'm the co-founder and CEO of Double Diamond Transport and Tanager Logistics based out of San Antonio, Texas. I'm here in support of Senate Bill 30. I'd like to begin by thanking Senator Schwartner for authoring this bill and bringing to light the issues that we're dealing with in this environment in the state of Texas. If you want to wonder why the cost of milk and eggs is going up the way it is, look no further than the issues that we're addressing today. The transportation industry is the backbone of our economy and transports over 80% of the goods that are on the shelves every day. To begin, I would like to state first that, in my opinion, there's no lack of access to the judicial system by anybody that's injured as a result of this bill. And I also, in my opinion, doesn't affect any major cases, because the major catastrophic cases are going to be those where we receive a Stowers demand, and in all likelihood is going to be settled well before we get into the litigation process. What we're here to talk about today is the abusive medical practices and billing practices that are happening in collusion with these trial lawyers and these doctors. The scheme goes like this. These trial lawyers send their patients to a doctor that works directly with them. In exchange for that, they are told not to bill their insurance or any other payment providers that can cover those costs, which would be essentially all Texans, whether it's through private insurance, Medicare, or Medicaid. Then they overinflate the medical bills and represent those as the actual costs in order to make them whole for medical damages in these lawsuits. They do this fully well knowing that at the conclusion of that case, they are going to go back and renegotiate that rate in a back room without anybody involved in that case and bring down those bills. I do not know, as a practicing attorney myself, or a licensed attorney rather, how that is not considered fraud and how that is not unethical. If you're representing that medical bills are a certain amount, knowing full well that you're going to go back and reduce those substantially, I cannot imagine why that would not be something that should be addressed immediately. And I'll give you a perfect example. I have a 17-year-old son. He just had an MRI doing an athletic injury. At the same time, I have a truck accident case, which was a minor fender bender and a scratch. In both instances, there was an MRI done. In the truck accident case, that was a minor scratch, we received a bill for $18,000 for an MRI. At that exact same time, my son went to receive an MRI through our health insurance, and we were billed less than our $2,500 deductible. There is a huge disconnect that is happening as a result of these practices, and I think it's fair to ask, why are the trial lawyers that are coming before you not acknowledging unequivocally that they're not engaging in these practices? Why are the doctors that are coming here acknowledging that they don't engage in this as well? I think it is a question that must be addressed by this legislature. We appreciate very much the support of the members of this committee in support of Senate Bill 30. Again, I'd like to thank Senator Schwartner for his authorship of this bill, and as a licensed medical professional himself, as we in the trucking industry, we don't want bad actors in our industry any more than anybody else does, and I'm sure as a medical professional, y'all don't either, and I think this bill is a perfect opportunity to get things back on track, do what Texans do, try to reduce costs, not increase costs. Thank you very much.
And thank you for your testimony. Welcome, introduce yourself, and go ahead.
Good evening, Chairman Hughes and committee members. For the record, my name is Charlie Pfeiffer, and I'm testifying for Lone Star Economic Alliance and also the Independent Electrical Contractors of Texas in favor of Senate Bill 30. I serve on the board of directors at the IEC of Texas. We're the largest association of electrical contractors in the state, representing over 700 contractors, and we also employ over 40,000 Texas electricians. I'm also one of 3 brothers that are owners of Pfeiffer & Son Limited in LaPorte, Texas. Our family has been in the electrical trade for 6 generations, and our business is in its 62nd year. Everything that we do is to maintain this legacy and to extend it to future generations. My son has just started. He's gotten his CDL. Sadly, we are concerned that an employee may get into a wreck that will put us out of business. We have recently been involved in several auto wreck lawsuits that in previous years would have been resolved with a trip to the body shop and nothing more. Lawyers, unfortunately, are consistently pushing for even higher verdicts, with one right now seeking $10 million for a fender bender. This is enrichment for the attorneys. It's not justice for the victims. We are very safety conscious and have implemented all manner of safety procedures and technology to minimize any wrecks, but the amount of damage to the vehicles often has little bearing on the amount of the settlement. Even if we avoid all accidents, our insurance premiums are rising to unsustainable levels. The carriers are being forced to raise rates across the board. This year, our auto insurance premium went up 33%. Right now, it represents 75% of our total insurance spend. We appreciate the balance that our Texas government has struck between providing a great business climate, consumer protections, and low costs. We want this to continue into the future, and as such, request that the Senate approve Senate Bill 30. We want to ensure that verdicts and settlements fairly treat all parties in an accident. The system's not working properly now, and respectfully, we need to fix this problem and not let it get kicked down the road. I recognize that you guys are putting in a lot of work into this, and you're dealing with a difficult situation, so I want to thank you for all your work in that. It's a hard job.
And thank you for your testimony. Welcome. Introduce yourself and give us your testimony.
Thank you. Esteemed Senators, my name is Mary Myers. I have a master's degree in neurosurgical nursing, and I am a 37-year attorney. I represent businesses, small and large, and defend them in support of this Senate bill. I am submitting to you the history behind this 18.001 that you are being asked to review. I wrote the opinion and defense of the recent case in Ray Allstate that addressed changes that were made to the legislatively creative 18.001. That history is as follows. The 18.001 provides 2 things. One, that the plaintiff's attorneys may submit an affidavit to show reasonable and necessary applicability of medical costs for care. The second being that you can file a controverting affidavit. It's not mandatory. It only shows that there is factual support for a finding by the jury that the medical care was reasonable and necessary. However, in 1995, an Eastland court decided that that wasn't sufficient and decided to elaborate on the legislatively creative 18.001, holding that when a counter affidavit is struck for not complying with that rule 18.001, that party serving the counter affidavit, the defendant, is precluded from presenting any other evidence at trial that opposes that conclusion of reasonable and necessary. What did our Supreme Court say in response to our filing? The court said, Section 18.001 nowhere provides for the exclusion of any evidence based on the absence of a proper counter affidavit. That Beauchamp court provided no rationale for creating this additional standard, changing what the legislator created. Beyond that, by creating an exclusionary sanction for the sanctions to satisfy Section 18.001 finds no basis in the statutory text, and the effect is a death penalty on the issue of past medical expenses and future. The court then corrected that and went back to what you wrote originally as to what 18.001 should say. What we are asking for here, though, however, are 2 parts. One, that the Senate bill creates an obligation to explain more than it's simply reasonable and necessary. It sets forth what the parameters must be to complete the affidavit, now that we know what the counter affidavit must say. It then sets forth the standards by which the affidavit can be applied, and it suggests guidelines. We have guidelines for virtually every aspect of law. In criminal law, we have sentencing guidelines. In every aspect of law, including the 2003 Medical Malpractice Act, in which I was also involved, we have guidelines. Nothing is capped here. Nothing is preventing the judge from doing his job and being the gatekeeper. I submitted a summary of this history to the Senate this afternoon. It's before you so that there's a summary that addresses all of these issues. And I would give you these real-life examples, if I may briefly show, to address your questions. One, I've given you pictures of a car accident. The red vehicle ran into the Freightliner that was owned by my client. The passenger in that red vehicle sued my client after obtaining a physician to give her a statement that it was reasonable and necessary for her to incur $400,000 in back injury complaints. She went through ESIs, she went through surgery, and she has a cracked front grille. We then received a demand based on the same reasonable and necessary affidavit for $1 million. How much is that? $400 in the medicals, $600 in non-economics. A second example addresses the questions of the Senate. Addresses the issue of whether or not we should provide all of the medical records. In a recent case that I addressed, I was told in this car accident case that the back injuries are the only times that the individual had ever suffered from them. Presented no medical records and said there was no history whatsoever. In going through his pharmacy records, I found a previously undefined physician who treated him for what? For gastric sleeve. I ordered those records, and lo and behold, when he looked at the stomach, there's a picture of the spine with the discectomy clearly in place that he had undergone 10 years before. And finally, another example, I have gone through a recent car accident in which the death of the father was, of course, horrendous for the family to go through. We were trying to identify what is the value of a life and try to, again, provide guidelines. The mother was seeking enormous damages for her lost comfort, companion, solace, and all the other non-economics that go with it. Somehow she neglected to mention that between the death of her husband and this trial, that her child had been murdered in a drive-by shooting. There's an opportunity for every jurist to hear the circumstances. I would be happy to address any questions, but it is a fact that this particular bill presented to this Senate provides an opportunity that is broad, that gives discretion to the jury, gives discretion to the judge, allows the judge to be the gatekeeper, and addresses the needs of every single person who is able to prove their case and demonstrate their right to recover an appropriate amount that does not bankrupt companies, but allows the succession that perhaps we've reached some accord for the loss that they have suffered.
Yeah, thanks for your testimony. Welcome. Introduce yourself and give us your testimony.
Thank you, Beryl. Honorable Senators. My name is Darcy Miangui. I live in Wimberley, Texas. I'm here to speak against SB 30. So as the day started, I heard people who spoke in support of the bill talk about how it's affecting businesses in Texas. But as the day has gone on, I've seen that it's all about the insurance lobby. And from my experience, this is all, for example, the one lawyer that spoke earlier about getting a $600 ibuprofen bill. Well, I grew up in a very pro-union socialist household, but ever since I was a teenager, I've been a staunch conservative. And all of this talk from the pro group just reminded me of one of my favorite symbols in the world is the Gadsden flag. Don't tread on me. And I feel like the insurance lobby is too lazy to do their job, that they're trying to get you to legislate their job for them. My lawyers hired expert witnesses, expert doctors that I paid for out of my settlement. The lawyers didn't pay for them, I paid for them. They talk about fraud between the collusion between the lawyers and the doctors. Well, there's systems in place for that. Do your job. If you're a lawyer and you suspect another lawyer of bad ethics, report them to the ethics board. If you think a doctor is doing something wrong, report them. We have systems in place for that. Don't legislate against the people getting money for what they deserve. Punish the bad actors, not the good ones. You talk, like the $600 ibuprofen thing, like she could get experts in and hire people to get that proven that it's not a reasonable cost. Like my experience was none of the insurance lawyers, the companies didn't hire their own lawyers, they used the insurance company's lawyers. And the insurance company lawyers, they didn't go after any of the facts. And you hear about all these companies, saying, oh, well, 2 years later, I'm getting sued for soft tissue and all these damages. Well, hire better lawyers. Like, do your job, protect your business. Don't expect the government to do it for you. Like, don't tread on my rights. Don't tread on other people's rights. Protect your business. Don't just allow insurance companies to dictate who represents you, because they're not looking out for you. They're looking out for themselves. And, as I was sitting in the gallery, I had people that were watching from home. I was a truck driver working in the oil field, and they're texting me like, if these companies or if these insurance companies really cared, they'd enforce laws. Every day, every week on the news up in West Texas, you hear about deaths and injuries, and a lot of it is unlicensed drivers. There's untrained, they're hiring people off the streets. These companies are not training people. These companies are causing these accidents, and they should be held accountable. And if there's any questions, I'll tell my story dealing with workers' compensation if anyone wants to know that. Thank you.
And thank you for your testimony. Welcome. Make sure to get close to that microphone since you're on the end and give us your testimony. Go ahead.
I'm here to speak for my daughter. Her name is Emily Turkett. I too have a picture. That's 3 days before she got ran over by a 78,000-pound semi-truck. My name is Ty Turkett. I live on a ranch approximately 12 miles west of Waco, Texas, just outside of Valley Mills in McLennan County. I oppose Senate Bill 30 because it's more than just what the insurance has to pay. On September 22nd, my daughter was 7.5 months pregnant. At 7 o'clock on September 22nd, it was one of the best days of mine and my wife's lives. At 8:07 on September 22nd, it was the worst day. My wife and I were standing at the entrance of our ranch on a beautiful Friday morning, waiting on our daughter to stop and pick my wife up to go get a teeth cleaning a mile down the road at the dentist. Me and her were talking. I asked her, "What are you doing?" She said, "I'm waiting on Emily. She'll be here in just a minute to pick me up." My daughter pulled up on the highway about 60 feet from us and stopped. We had bought her a new Denali ATV, or Denali, to keep her safe. And she was 60 feet from us, looking right at us, waiting for two cars coming west to come out of Valley Mills. Moments after her vehicle slowed down to stop, we watched in horror as the 18-wheeler came barreling down the highway. He had over 1,000 feet of clear line of sight, and he hit her square on. Me and my wife were the first ones to the car. There's nothing like pulling your 19-year-old pregnant daughter out of the back seat of a Denali. We removed her out of the car and started doing CPR on her. We laid her on the asphalt, and we waited for some help to come and help us. Fortunately, help was close by. She was transported by helicopter to Baylor Scott and White Hospital in Waco, Texas, with a transected vertebrae. I didn't even know what that was until I saw the x-ray. Her vertebrae was separated by about 3.5 inches. They did emergency C-section and took the baby. My daughter was clinically dead for about 4 minutes. So the umbilical cord went acidyne, which means the baby stopped developing. The baby was delivered. Her name is Ava Wren. She survived and she's with us. The father could see the medical bills coming. So we adopted the baby. We've been living in catastrophic and severely abnormal for 18 months now. We are the physical therapy. My son is 23. We don't go anywhere. We have become Avaologists. We do physical therapy. We do occupational therapy. We have a little education in neurology, but her little brain has a lesion in it. She can't stop looking to the right. She doesn't reach. She doesn't crawl. She looks perfect. She has the most beautiful blue eyes, but she can't look at you straight on. She's going to have problems. There's not any neurologist at Texas Children's, Boston Medical, Baylor, Scott, and White, because we've talked to them all. We know we've got bumps in the road. I heard that fella talk about losing his son, and his wife wanted to kill herself. I know what that's like. SB 30 doesn't give anything for that. I'm 57. This collision has taken years off my life. Who's going to take care of this little baby whenever me and my wife are gone? We talk about mega judgments. If that's what it takes for my granddaughter to live a life, then that's just what it takes. My son is 23. We don't know how far Ava can go. And my wife is deathly afraid that there won't be nobody there for her at some time. I've assured her that everything will be taken care of, and Ava will be taken care of. We'll make sure of it. But the destruction that this has done to my family, nobody leaves the ranch but me. My wife can't even go and get the mail. SB 30 doesn't give any consideration to what we're going through. SB 30 just slaps us again. You can't put a cap on a daughter. It doesn't matter what the insurance pays. It's not enough. It's just not enough. And we have no idea. There's no neurologist that can tell us what's ahead of us. There's nothing that anybody can do other than me and my wife and my son there every day, 24/7. I'm praying that she will just skip the crawling and go straight to walking. I see in God we trust. I ask myself, is there anything worse? Is there anything that you have worth more than your children? And I'd have to say, it's your salvation. Because that's the only foundation that we can stand on, is in God we trust. If SB 30 passes, there's going to be other families that I just don't know how they can do it. I don't know how they could take care of this problem. And I know that it's few and far between. I hear an accident here, but nobody's carrying on a generation like we are. And if there was a cap that limited me to protect her, it would be devastating to us. It would be like the accident over again. So I hear about these smaller cases, and I don't know about the doctors and the money under the table, and I don't know nothing about any of that. And I'm sorry that goes on. But if this bill passes, it's going to hurt the people that really need it. It's going to limit the insurances from being able to say, we're going to help you take care of her. We're going to be there for you. She was rear-ended. She was a good driver. She wasn't doing anything wrong. When I saw her, I thought, look at her. She's got her seatbelt on, her blinkers on. She's doing everything right. And her life was taken. Even all the love that me and my wife can give our daughter, granddaughter, she'll never get the kiss from her mother. It's just a shame. So I oppose Senate Bill 30. And I've heard some fellas say, I'm a fourth generation Texan. There ain't nobody more Texan than me. And I got generations that go way back. I built custom homes. And not to brag, but I was sought after. I don't have a custom home business anymore. Because I'm an avologist now. So I've given up. I've given up everything I had. And when I had to pay more for insurance for my builder's risk policies and so forth, I passed it on. I didn't pay for it out of my pocket. I understand it's a lot more money for some of these companies, but I came here to speak for her and to just let you kind of know our situation, and that if you limit this and cap it, you're going to hurt the people that really need it, because there are people out there that really need it.
Mr. Turkett, thank you. Thank you for your testimony. Senators, any questions for any of our witnesses on this panel? We thank each of you for being here. Thank you. Thank you for your testimony. You're excused. Call William Wolf, Nolan Howard, Marcia Fashingbauer, Pam Grooms, Tricia Graham, Alden Williams. Welcome to each of you. We'll begin over here, and you've probably heard me tell somebody else, but because you're on the end, get close to that microphone, introduce yourself, and go ahead. Welcome.
Thank you all for having me here today. My name is William Wolf. I'm with the Davis Crane Group based out of Irving, Texas, and I support this bill. Over the past few years, our crane rental company has faced a dramatic increase in insurance costs. In just the past 3 years, our automobile liability rates have risen by 68%, with our umbrella premiums having surged over 70%. This alarming trend is primarily driven by the frequency of litigation from plaintiff lawyers. We've experienced several incidents with minor bumper damage that led to policy limit demands. Shockingly, the allegedly injured parties are claiming hundreds of thousands of dollars in medical costs. This pattern has become increasingly common, and while these lawsuits are often presented as necessary for enhancing safety, that are in fact creating negative consequences. Rather than improving safety, they are draining essential financial resources that we could otherwise invest in safety enhancement, equipment upgrades, training, and growth. The rising insurance costs spurred by frequent lawsuits are alarming and have made it challenging for us to remain competitive in an already price-sensitive market. During our last insurance renewal, we were informed that there were only 2 companies that would consider quoting us in our market. In particular, as many carriers are retreating from Texas due to the current plaintiff-friendly legal environment and unprecedented number of nuclear verdicts. Without insurance, our 62-year-old company, which has played a vital role in building infrastructure in Texas, would face the risk of going out of business. This bill aims to stabilize the insurance market and allow more transparency for the jury. This challenge is essential for the sustainability of businesses like ours and for the overall health of the industry.
Thank you. Thank you for your testimony.
Yes, ma'am.
Ma'am, if you'd introduce yourself and give us your testimony. Thank you.
Thank you. Yes, ma'am. My name is Pam Grooms. I'm with Atlas Energy Solutions, and I'm strongly in favor of SB 30. Atlas Energy supplies frac sand and other services to the oil field industry in the Permian Basin. We use third-party trucks to help haul the sand. It takes 500 trucks of sand to drill one oil well. And we have about 75 third-party vendors, and 95% of the trucking industry has less than 10 trucks. We have about 5 vendors go out of business every year because they can no longer afford insurance. Independent owner-operators and small trucking companies are especially hard hit because they lack the financial resources to absorb the rising cost of insurance. And nuclear verdicts have a ripple effect to the industry. Atlas has several sand plants in the Permian Basin and a fleet of trucks. Recently, there was a person on a motorcycle on the street in front of an Atlas plant, and he ran off the side of the road. He doesn't remember seeing any truck, but he claims an Atlas dump truck ran him off the road. No truck hit him. 3 years later, we're still in litigation. And he had 22 stitches to his arm. I believe he is suing Atlas for one reason. We have insurance, and he's after our insurance limits. Large verdicts encourage others to file suit with truck companies that have insurance with high limits. There was an incident in September of 2024. A red truck had a flat tire and said an Atlas fleet truck caused it. A state trooper called me 2 weeks ago about this incident. The state trooper appeared and told the man driving the truck there's no way the Atlas truck caused the flat tire, and he did not write a ticket. He wrote up a non-citable crash. Today, the person is claiming he's hurt from the incident and has run up medical bills to over $1,000 and filed open records claims with the state trooper, claiming he's not doing his job. I'm advocating for legal reform and fair insurance practices so we can protect Texas truckers, state troopers, and promote economic stability and ensure that justice serves everyone, not just trial attorneys chasing massive payouts. Thank you.
Thank you for your testimony. Would you mind repeating your name, please, for our record?
Pam Grooms.
Okay, thank you. Thank you very much. Thank you for being here, and would you give us your testimony, introduce yourself?
I'm Marcia Fashingbauer, President and founder of X-Cargo Services. I'm on the executive committee of TXTA and ATA. I'm in support of SB 30. We were sued 6 months and 6 days after our truck was hit by a speeding car that illegally passed us on the right at Port Houston. Our truck driver had stopped at an intersection to allow a crane to pass, turned his blinker on, and was slowly beginning to turn right when a speeding car passed him on the right, all captured by our onboard cameras. The Port Police report deemed this to be a minor incident caused by the car with no bodily injury. We were clear of fault. Time would tell the damage to the car was minimal, and evidently bodily injuries were not treated for 10 months. That's 3 months after the suit date. Why did it take 10 months and an established lawyer-client relationship for claimants to seek medical treatment? How could this minor event result in $400,000 in medical bills and a nearly $250,000 settlement? It's called lawsuit abuse. Work the system and create your own payday. If you don't like being denied by insurance because you're at fault, move on to the courts. Hook up with the right attorney who will lead you to the right medical clinic, and you're set. Our attorney affirms having this medical provider say under oath that he charges more where there's insurance to pay. It's a travesty, sucking the energy out of business and our ability to create more jobs. This is demoralizing and wrong for those hardworking, dedicated professional truck drivers who've chosen an honorable and essential career, but find themselves a target for lawsuit abuse. Further, this is a direct hit to the cost and availability of basic consumer goods, estimated to cost every American family $5,000 annually. Our supply chain threats are real. We must return to a focus on facts, fairness, and financial ethics. We must remove the financial incentives from the client-attorney, patient-doctor relationships. Thank you very much for listening.
Thank you. Thank you for your testimony. Sir, if you'd introduce yourself and
Good evening. Thank you. My name is Dr. Alden Williams. I'm a pain management specialist in Boerne, Texas, and also San Antonio. I'd like to thank the committee chairman and also the distinguished chair members for this evening to talk to you. So I've been practicing for about 30 years in pain management and anesthesiology. I'm board certified in both anesthesia and pain medicine. I oppose SB 30. What I've heard tonight is basically throwing the baby out with the bathwater. So we have good things and we have bad things, and we're trying to put everything in one bucket to try to make a bill. So the loser in all of this is the injured Texas patient. Those are the losers in this process. So when I started out my career 30 years ago, I started off as a Democrat. And after practicing medicine, I became a Republican. And I've been a Republican for many, many years. Republicans are the champions of free market in the healthcare system. They're also for limited government. And they're also for personal choice. These are three core values of the Republicans that I treasured and I became a part of the movement. I've heard the word cap endlessly today. It's really a limit, which you can call a cap, because you are capping many part of this bill. The part that I'm going to talk about that's being capped is the hidden socialized medicine part of this bill. Why do they call it hidden socialized medicine? Because it's not truly socialized medicine. What you're doing is you're creating a reimbursement system that has a limit, and the limit is compared to Medicare and compared to what insurance pay. But basically, insurance pay a certain percentage over Medicare, such as workman's comp as well. So basically, you're creating a limit in a very narrow window in what you're going to get reimbursed as a physician. So basically, you're removing the free market system from this process. The context of healthcare, which is a fee schedule that I used for the last 30 years to create my bill, it's not an arbitrary number, because I've also heard tonight that this is an arbitrary number, that doctors bring these numbers to try to create this fee schedule to charge insurance companies. That is not the case in many, many cases, and especially in my practice for the last 30 years. So the way that we looked at this also is that we looked at this nuclear aspect of reimbursement. In my 30 years of practicing, I have never seen a nuclear award, never. I've 30 years. The majority of the cases that I take care of are non-commercial cases. These are limited liability policies, very small policies. But there's a big part of this. It's limited liability, but it affects the person who gets injured in a very big way. Why is that? Because that person had no insurance. Mainly, most of the people in Texas have no insurance. So now they've lost their vehicle. They lost their job, and they now have pain. So now let's take that all out of context. Let's not give them any medical care. Because if you pass this bill, and I have to get reimbursed at 150% of workman's comp, I cannot open my practice to take care of these patients. It can't work. Those numbers do not compute. So basically, the losers are going to be the Texas injured patients. The patients are going to lose access to care. The doctors are going to stop accepting insurance patients like this. And you're going to end up with patients who are doctor shop emergency rooms and also go into the streets for medicine to try to combat their chronic pain. Because chronic pain is a real disease that's going to affect a lot of these patients when they don't have adequate medical care.
Thank you, sir.
I thank you very much for allowing me to speak tonight, and it's been a long day, and I appreciate you very much.
Thank you. I appreciate you being here. Ma'am, if you'd introduce yourself and give us your testimony.
Hi, I'm Tricia Graham. I'm from Nevada, Texas, and I oppose Senate Bill 30. Almost 2 years ago, I kissed my husband goodbye, and I received a phone call about an hour later from his coworker, Captain Costin from the McKinney Fire Department, that he had been in a terrible accident. A rock hauler had run a stop sign, and my husband could not avoid him. They sent firefighters out to get me, and called and told me that they were coming. Little did I know that it was going to be 2 police officers and 2 firefighters vehicles that were picking me up. And with us being married almost 30 years, I knew what that meant, because they don't just do that for any reason. So I'm calling our 3 grown sons. One was at college baseball tournament, one was at A&M, and one was working to meet me at the hospital because I knew what was ahead of us. Nothing can prepare you for turning the corner into the hospital parking lot with hundreds of firefighters, fire trucks, ambulances, everything standing there, and you know what that means. After spending the day waiting for my children to get there, also waiting for MRIs and all of that stuff, we were told it was up to us when we wanted to take him off of life support, because there were hundreds of people there to support us because they loved him and he loved them. I didn't want them to have to wait any longer, so that evening we removed him from life support. To say this has affected our lives is an understatement. Every single day we're still kind of in shock that Daddy's not coming home. He traveled a lot, so of course there was days that he wasn't at home, but now it's consistent, and the shock has not worn off yet, because it's still like so weird to think that you kissed him goodbye and then he's not coming home again. For me, it's just almost a daily thing because we were together almost 33 years, not having him to talk to anymore, not sharing victories, not having struggles. One of our sons has cerebral palsy. So it's really hard to single parent that as an adult, even though he's an adult. All 3 of our boys, one is going to be getting married on Thursday. The other was in August, another one's in November. All will be doing that without their daddy there. They've gotten jobs. 2 of them work at the McKinney Fire Department, and it is very painful to hear them talk about wanting to call daddy and tell him about calls, but they can't. It's ongoing. It's the daily things that you just don't think about until they're just not there. Not only is it with us, but our family, the fire department, because he was in McKinney. He worked at the Central Fire Station B shift is who ran on him, who cut him out of the truck after it went underneath the rock hauler, who did CPR on him, who did procedures to start his heart again, but ultimately because of the damage to his neck, he wasn't able to live. I believe wholeheartedly his accident could have been It should have never happened. The company and the driver both broke the law, killing my husband, and were not held fully accountable. I cringed thinking there could be another family to have to go through this horrible, terrible pain that we live with on a daily basis. It's one you just can't imagine until you're the wife that gets the phone call. Praise Jesus, I know that God has ultimate control, and I will get to see my husband for all of eternity. But in the meantime, I really hope and pray that you consider this bill and do not allow Senate Bill 30 to pass. It is a bad policy to not hold a driver and company like this fully accountable.
Thank you for your testimony. I'm so sorry for your loss.
Thank you.
Thank you for your husband's service to my hometown, McKinney, and to your service as well.
Thank you.
Members, are there any questions for the witnesses? All right. Thank you. Thank you for being here. The chair calls Andrew Indrasano, Amy Shimizi, Michael Lyons, Juan Fuentes, and Stacy Elms. Oh, a little while ago. What's your name? It was, we'll catch you. We'll catch you. All right. Yes, if you don't mind. Thank you. All right. So that's Michael Lyons, Amy Shimizi, Andrew Indrasano, Juan Fuentes, and Stacy Elms. Okay. All right. I'm just watching to see if the other person is not here. Samantha, sorry about that. Why don't you come on and take this seat right here? Thank you. All right, thank you all for being here. We appreciate it. We know it's been a long day. Thank you for giving us your testimony, and we'll start on this side. If you'd share your name and then give us your testimony. And I know it's everybody has a lot to say. If you can do your best to stay within the 2 minutes, that's helpful for everyone who's coming behind you and waiting for their turn. Thank you. Go ahead.
Welcome. Thank you. Thank you, Senators, for letting us talk to you today about this. My name is Dr. Andrew Intrasano. I'm an orthopedic spine surgeon that services the Dallas-Fort Worth area. I've been in practice in that area for 8 years and been serving Texans for a little over 10 years at this point. There's been a lot of impressively disparaging comments about physicians tonight, or today. Interestingly, all by defense attorneys. So I just wanted to clear up a couple things. 15% of my practice has to do with third-party liability patients, not all my practice. I don't have a practice in a strip mall. I don't own my own MRI. In the last 10 years of treating Texans, I have not done a surgery on behalf of a lawyer. It's been because patients need the surgery if they're getting a surgery. I take that seriously, and I base that comment off of the fact that the oaths we take in medicine we take just as seriously as the oaths that lawyers take themselves. In regards to this bill, and I am here in opposition of Senate Bill 30, if that's not obvious, there's a major problem in the bill, partly because of contracts that we have as practitioners between ourselves and the medical insurance companies, as well as the fact that you are now basically punishing the injured patients if they don't use their health insurance contracts. So in all of our contracts, we have clawback clauses. This is an example of one from our contract, one of our contracts where basically insurance companies have the right at any point in the future to claw back funds that were paid to us if they think they should have been paid by a third party, is basically the short of the long. So because of that, most of these patients' own primary care doctors will not see them. Other orthopedic groups will not see them. There's a very small group of physicians in this state who are willing to treat these patients because of this and because of a lot of other issues that I think have been partly brought up today. But forcing us to see the patients under their insurance is not a possibility, given the clawback clauses and our restrictions from our insurance side of things. And I think that's a really important piece to the bill that's flawed.
Thank you. Thank you for sharing your testimony. Ma'am, if you'd introduce yourself and give us your testimony.
My name is Amy Skamitsi. I'm a board-certified hand and upper extremity orthopedic surgeon in Dallas. I'm here today to express my strong opposition to Senate Bill 30 because it obstructs patient access and undermines the very foundation of our healthcare system. And I would also just add that in our practice, we see patients both with insurance and without insurance. We do not randomly set our bills. We set our prices at based on a national database of medical billing. So I just want to set those records straight. I think there's been a lot of selective bias from a lot of the lawyers that have spoken tonight. But in terms of the bill, I oppose this bill because for patients, it creates financial barriers that make care unattainable. Health insurance coverage does not equal care. According to the Financial Capability Survey of Texas, 52% of Texans live paycheck to paycheck, meaning that the average health insurance deductibles, which often exceed $5,000, are unattainable for the average Texan. In addition to that, most physicians won't even see these patients because of the clawback clauses that they have in their insurance policies. These patients have often suffered severe functional limiting disability and injuries that prevent them from working and stripping them of their ability to generate income when they need it the most. For physicians, this bill imposes arbitrary price controls that make it financially unsustainable to treat these patients. This is not how the free market works. Free market and price control has failed in every industry where it has been attempted, leading to shortages, reduced quality, and fewer providers willing to participate, and healthcare will be no different. This bill is not by the people or for the people. It's an obstruction to care, particularly for the most vulnerable patients in the most vulnerable moments of their lives. This bill is an invasion of the free market, and it opens the door to socialized medicine in Texas. Trauma is a great equalizer. Many of us in this room will experience trauma ourselves or through our loved ones. And when that moment comes, I can only hope that access to high-quality medical care still exists and has not been erased by legislation like this. And I urge you to reject Senate Bill 30 and stand up for your constituents, stand up for patient access, stand up for physician autonomy, and a truly free market in healthcare. Thank you for the opportunity.
Thank you. Thank you for your testimony. Please introduce yourself and give us your testimony.
Good evening, Senators and Chairman Hughes. I appreciate the opportunity to share an anecdote with you this evening for your consideration. My name is Stacy, ma'am. My name is Stacy Elms. I'm the current treasurer of the Texas Trucking Association. In my professional capacity, I'm the Vice President of Risk Management for the Housley Group, headquartered in San Angelo. We're a utility contractor operating more than 200 vehicles, all the way from SUVs to Class 8 tractors. I'm testifying today on behalf of TXTA, my company, and myself in support of Senate Bill 30. In 2018, an employee driving a 3/4-ton pickup in the Rio Grande Valley was involved in a minor rear-end collision at a traffic signal. The driver of the other vehicle initially refused medical treatment until her husband arrived at the scene. When he saw the logo on the side of our truck, he insisted that she be transported by ambulance to the ER. 5 days later, we received a letter of representation from an attorney. We were willing to settle the claim and made several attempts to do so, although the plaintiff's counsel never responded to any of those offers other than sending a Stowers demand for our policy limits. Plaintiffs sued for numerous allegations claiming permanent injuries and sought over $500,000 in damages. Our medical review controverted those claims as she had numerous documented pre-existing conditions due to her employment in the healthcare field. The claim was settled at mediation in 2020 for $331,250. Our retention for this claim was $250,000. Our vehicle sustained no damage, and our insurer settled the physical damage portion of the claim in the amount of $1,318.22. I'm happy to answer any questions you may have.
Thank you. Thank you for your testimony. Thank you for being here. Please introduce yourself and give us your testimony.
Yes, and thank you for being here and your hard work and for this time. My name is Juan Fuentes. I'm an attorney. I've been practicing over 25 years, and we work primarily in commercial accident cases across Texas. So I want to provide some insight of what we're seeing now, get to the heart of the matter of the medical bills, the referrals, and these practices that we see practices set up exclusively for these cases. Now, earlier you heard from Dr. Leonard. He was here. So we see Dr. Leonard in our cases. We see him, it's typically the same billboard attorney that he's working for, but they won't admit that there's any referral relationship there. He says he doesn't know. But I want to show you, here's a case we have. One visit, he charges $1,500 for that visit, which small potatoes compared to what we're looking at in these cases. And he recommends a surgery. It's this easy for them to start blowing these cases up. 1-level neck surgery, cervical fusion. Estimated surgical cost, $280,000. He says his fee's $33,000. His assistant surgeon's $15,000. Foundation Surgical Hospital's fee, $195,000. This is a basic neck surgery. They do 2 or 3 of these a week in the same day. They do 100 plus a year. $280,000, it's that easy for them to get that. And that's because this is a doctor who we regularly see in these cases tied with a certain attorney. That stuff is blocked. Either the plaintiff doesn't admit it, the court doesn't allow discovery into it, it's not allowed to come in. And so these guys give the impression of they're just this regular doctor treating the patient, not that this is someone who's always involved in these cases. All right, I tried a case 2 weeks ago in Goliad County. The neurosurgeon in that case, he admitted this, 95% of his patients are in litigation. He does not take any form of health insurance. Neither does Dr. Leonard is not in network with a single health insurance provider. There's a clinic in Houston that's in a strip mall, okay? And you guys don't do 100% of this, and I respect that. I haven't dealt with you guys too much. But this is, I'm sorry, can I finish on this?
If you could wrap up your thought.
Okay, real quick. Okay, they don't take any health insurance, rely exclusively on these cases. There's a pain management doctor who's associated with them. Normally $238 is what he gets paid for an injection. In these cases, steers him over to the surgical center at $25,000 to $30,000 per injection. Thank you so much for your time.
Thank you. Thank you for your testimony. Thank you for being here, and please introduce yourself and give us your testimony.
Hi, I'm Samantha Sizemore, and I'm here on behalf of my family's business, Sizemore Logging. We're based out of Liberty County. My husband and father-in-law have built our company from the ground up in 1990. We run 5 log trucks that are not only a vital part of the timber industry in our area, but they're also our livelihood. This business has supported our family for decades. In recent years, we've seen our commercial trucking insurance rates skyrocket, despite having only one at-fault claim totaling just over $1,000 and maintaining a very strong safety record. From 2020 to 2023, our premiums averaged around $50,000 a year. But this year, we were hit with a premium of $98,000, nearly double that previous average. That kind of increase isn't just hard to absorb, it's crippling. And we haven't changed anything in the way that we operate. We pass our DOT safety audits, we have a formal safety plan in place, we even employ a full-time mechanic to make sure that our trucks stay fully compliant. We strive to do everything right. We're being told by our insurance agent that because we border Harris County, we should expect higher premiums simply due to our zip code and proximity to these high verdict regions. That's not based on our behavior or our track record. It's based on fear of nuclear verdicts in neighboring counties. After so many years of hard work, we should be at the height of our career, not facing the possibility of starting over. Without these trucks, we're just cowboys without a horse. Our logging company will fail. We're one of the last remaining logging contractors in our region, and we run a high-producing operation. If we're forced to shut down or move, the impact does not stop with us. The entire logging supply chain, mills, landowners, and local economies will all feel our loss. These stories I've heard here today are what has me upset. They're very hard to follow, and there's been some tragic stories told today, and I want to make it clear that I believe in accountability. But right now, this system is not balanced. So that's why I'm here today to support this bill. We need fairer rules that protect operations like ours from being swept up into this legal environment that we did not create and we cannot control. So thank you for listening.
Thank you. Thanks for sharing your testimony.
Madam Chair.
Senator Schwartner, you're recognized.
Thank you. To my two colleagues on the left there, could y'all please elaborate, if you'd like to, regarding how you set your fees for letters of protection cases when you see a injured individual that is currently in litigation? Would you like to explain how that
Yeah,
is?
sure. So just to clarify the first point, the fee's no different for a letter of protection patient or personal injury patient or work comp patient or patient seen under Medicare or any other structure. The fee structure is the same. So this idea pushed by the TLR that we are all charging different amounts and inflated amounts for these patients is not true.
Would you say that there is that, though, what was illustrated by this gentleman, that there are a large percentage of pain doctors and surgeons that do set a different fee schedule for their work in a letter of protection situation relative to their general practice?
I'm not familiar with that. I can
You're
just
not
speak to my
familiar with that
practice.
at all?
But my practice, that is not true.
Expect more.
And the other people that I
really
work
did
with,
from you.
that is not true. And if you to answer your other part of your question of like, what do we base our bills on? And that's a great question because you guys have been fed a whole bunch of misinformation because
What are you basing it on? Tell me.
context for healthcare. We bill between the 80th and 90th percentile of a usual, reasonable, and customary database that's been around since 1994. Not one person in this room, other than the gentleman at the end there 2
What
sessions
database?
ago, brought up context for healthcare. It is a well-recognized, been around since
So
the
it's
90s.
It's not 300% of Medicare or some other methodology? as
No,
commonly
it is
was.
a database collected privately. It's been collected for 30 years. They update it every 2 years based on geo-zip codes of all the providers in the same geo-zip code that bills whatever they bill for that CPT code. So for all procedural codes, we choose between the 80th and 90th percentile.
And y'all
then
practice together? Are y'all in the same group?
I have a different partner, a spine surgeon partner, Mark Valenti. Just to be on the same page, why that percentage I think is really important as well. And that's the other piece of information that nobody's talked about today because they want you to think that the insurance reimbursement rate is supposed to be the appropriate reimbursement rate.
As Senator Perry
Right.
listed.
And that's not true. And that's why 50% of private practices, 50% of private practices in this state closed between 2019 and 2023 because the rates that we are being reimbursed by insurance companies do not float. 70% of Texas physicians do not accept work comp. Yet you're going to base a bill off of it. That's what we should supposedly accept for payment 3 to 5 years later. That does not work. Everybody, the few physicians that take care of them, we cannot take care of these patients at that rate.
I appreciate what you're saying, and I'll just stop you there. But also what doesn't work is a system in which the connection between those that are receiving the service and them having to pull out their first dollar and pay and somewhat be responsible for that service. In this case, the responsible party is not insurance. In this case, it's the plaintiff's attorney's firm, and as such, there's really not a free market because it is distorted by the relationship of the providers with the plaintiff's attorney's firms, just as the free market is distorted by the providers and their relationship and contracts with insurances. So healthcare is not a free market at all anymore. I do agree with you on that, at least.
Can I explain to you why we choose that percentage? Because I think it's an important piece of information. Context for healthcare. There's only
Context
three.
for
There's
health-
fair
I'll
health.
figure it
There's
out.
fair health and context for healthcare. Fair health, just to be on the same page, their reported usual customary rates have fallen dramatically once insurance
Context for healthcare.
Context, and then for
I've been around here a long time, never heard of that fee schedule, but I will look it up.
it's in almost every counter affidavit when you have a billing expert. Both sides bring up context for healthcare. So there is a system for this already for usual, reasonable, and customary billing, but they want to tie it to insurance rates. And the reason we use this is because if we get in disputes with insurance companies that we're not contracted with, the agreed upon reimbursement rate for this type of patient, an out-of-network cash patient, usually resides somewhere between the 80th and 85th percentile. So that's why everyone charges somewhere between the 80th and 90th, because if you don't charge that, you are essentially telling the insurance company that you'll let them keep money that you know they would have paid for the service. So the insurance companies, medical insurance companies, know the services are valued at 85% of context for healthcare, because that's what they pay in an out-of-network dispute. That's why we charge that or higher, typically. But that is in a UCR database. It is not a randomly inflated number. You can purchase it for $1,200 every 2 years and get the data and look up 1,000 codes every year for free under that $1,200.
And again, you don't see a major problem with other physicians, their physical therapy, chiropractor, pain management that are billing at rates, as was discussed and has been also discussed earlier, that are hundreds of times greater than the typical billed rate or reimbursed rate.
So just to be on the same page, for your example, a one-level ACDF, and I'm assuming it's one level, because 1, 2, 3, 4 level.
C6, 7.
So one-level ACDF at the 85th percentile of context for healthcare is around $25,000 to $27,000, depending on.
What is the Medicare reimbursement rate for that?
I don't accept Medicare.
Do you know what
I
it
opted
is?
out of Medicare as.
It's probably around $2,500 to
28%. 28% of doctors in DFW do not accept Medicare.
I understand.
It is not.
But
It is not
Medicare
a
is
reasonable
nationwide,
reimbursement.
And is de facto what other insurances are based on to a great extent. And you're telling me your context for healthcare is $28,000. That tells me immediately that's a tenfold differential versus Medicare, and that tells me that whatever context for healthcare methodology is methodology that is manufactured to benefit the provider relative to whoever is footing the bill.
They simply collect claims data. They are independent physicians. They collect claims data from the providers in a geozip code.
Right.
That's all they do.
Appreciate the discussion.
Thank you, Senator Schwertner. Thank you. Members, any other questions for these witnesses? All right, thank you so much for being here. You're excused. We appreciate your testimony. Chair calls Glenn Hamer, Sarah Nicholas, Ronnie New, Stacy Stein, and Brent Becking. Glenn Hamer, Sarah Nicholas, Ronnie New, Stacy Stein, and Brent Becking. I'll go on and keep calling a few other people. Neil Becking. I think I already called Sarah Hammond, didn't I? Okay. All right. So Neil Becking, Sarah Hammond, Barry Detlefson, might have room for one more. Let's see. Alexis Reza. Andy Webb? Okay, here we go. All right, we've got 5. If I've called your name and there's not another seat right now, if you'll just come on down and get nearby and we'll call you on the next panel. Thank you for being here. We'll start on this side, and would you please introduce yourself and then give us your testimony? And we appreciate you staying within the 2 minutes.
Thank you for having me. Good evening, Chairman Hughes and Senator committee members. My name is Dr. Neil Becking. I'm a proud 7th-generation Texan, and I've been treating injured Texans for over 21 years. I founded ProCare to ensure that injury victims, especially those with limited or no access to care, could receive best-in-class treatment. And Senate Bill 30 would devastate that access, regardless of whether patients have health care insurance or not. In Texas, someone is injured in a car accident every 2 minutes and 6 seconds. Many uninsured are unable to use their health care insurance due to sky-high deductibles or denied claims. The only reason they get care at all is because of doctors and clinics like ours who treat now and get paid in 1 to 5 years later, if at all. Doctors who treat personal injury cases face burdens most providers avoid, such as depositions, affidavits, and trial testimony. Time-consuming tasks far outside of standard clinic operations. The majority of medical providers screen out auto accident victims entirely at intake. Even when patients have insurance, doctors turn them away because health insurance frequently delay or deny payment when an auto claim is suspected. Worse still, many insurance contracts prohibit doctors from accepting cash payments for those patients. I think we've established that through the day, leaving providers but no choice but to say no. By creating barriers to presenting full medical damages in court, this bill turns doctors and patients into collateral damage in a campaign to protect insurance profits. That's not reform, that's a roadmap for denial. We can't count on if we can't count on fair compensation, we can continue to provide care. Doctors will leave patients, they will be left with nowhere to turn, and that's not justice, that's abandonment.
Thank you. Thank you so much for your testimony. Thank you for being here. If you'd start with your name and then give us your testimony, please.
Yes, good evening. My name is Alexis Reza. I'm with BTC. I'm the Director of Operations of BTC Insurance Services, Inc. We are based out of El Paso, Texas. We specialize in transportation insurance. We have companies of all sizes, but I want to focus on the 1 to 10 unit companies, which are typically family owned, whether it be brother and sister, father and children. And I'm here today to express our strong support for Senate Bill 30, a crucial piece of legislation that promises significant positive impacts for the transportation industry, particularly for small and medium-sized enterprises that are right now struggling with the burden of rising insurance costs. SB 30 introduces essential reforms to how personal injury claims are managed. SB 30 will bring much-needed transparency and fairness to the process. For our clients, this means more predictable insurance premiums and the potential for a reduction in costs. Many of our clients have been forced to either stay stagnant, downsize, or in the worst case, close because of the disproportionate impact of high insurance costs. These are not faceless corporations. These are taxpayers. These are people in our communities. These are customers that have now become friends, almost family. So I just really urge you to take a look at SB 30, make any tweaks that you need to make to get it passed, but we need to have more protection for these smaller companies. Thank you for your time.
Thank you. You get the prize for stopping right on time, too. Thank you for being here. Thanks for your testimony. Sir, if you'd state your name and then give us your testimony. Thanks for being here.
My name is Barry Detlefson. I'm here today on behalf of my employer, Coastal Transport Company of San Antonio. The company's been in the fuel hauling business since the end of World War II. We bring the motor fuels to your neighborhood service stations. As an example, last Friday, during that 24-hour period, our fleet traveled 60,000 miles that day. We delivered 747 loads of gasoline across our business footprint. We completed this task with no incidents, no collisions, no crashes. 60,000 miles a day, which is pretty typical with us, is a pretty large exposure out there on the public highways. The few times that we're involved in multi-vehicle collisions, more often than not, it's the other car that triggered the collision. All of us in this room have witnessed the distracted drivers today, addicted to their phones, disobeying traffic signals, speeding, and other violations of law and unsafe acts. It seems, even though we're doing everything right, we still find ourselves in a runaway lawsuit just because they can. We find ourselves having to defend our right and our ability to use the public highway system. We want to do what we do best, deliver fuel to your service stations. We don't want to spend time in the courthouse. Just like motorists with bad driving habits, there are transportation companies out there that do not take as much pride in their compatibility, their compliance, and public safety as we do. Those bad actors need to be identified and prosecuted and punished. We challenge you, our legislators, to support the contents of SB 30 in reducing the threats and consequences of the push for nuclear verdicts that exists in our civil court system today. Thank you.
Thank you. Thank you for your testimony. Please state your name and give us your testimony. Thanks for being here.
Thank you. Chairman Hughes, Vice Chairwoman Paxson, members of the committee, my name is Glenn Hammer. I'm the President and CEO of the Texas Association of Business. We're the Texas State Chamber, and we are in strong support of SB 30. Texas is known for having the best business climate, I say, in the galaxy. And a big part of that has been having the light and right regulatory touch, as well as a sensible, well-functioning civil justice system. And if you go back to 2003, I could tell you that 49 other states really looked at what Texas did in terms of reforming its civil justice system. But things have gotten out of whack, and we've heard a lot of stories from great small businesses across the state of Texas about rising unsustainable premiums, insurance premiums, as a result of the expenses of the tort system. And we like being #1 in Texas, but we don't like being #1 in nuclear verdicts. And this bill is extremely important in getting that balance right. And to that U.S. Chamber study showing that you have $4,500 per family because of the tort system costs, that's real money. That makes it more difficult for Texans to operate. And again, we've heard from so many small businesses in this state, the backbone of the state of Texas's economy, that they're hurting. And we believe SB 30 is a very responsible solution to this. We strongly support it and want to thank Chairman Schwartner for his leadership and the Lieutenant Governor for giving a low bill number for this important effort. Thank you.
Thank you for your testimony. Thank you for being here. If you'd start with your name and then give us your testimony, please.
Good evening, Chairman Hughes and Senate committee members. My name is Brent Becking. I'm a 7th-generation Texan, a proud Aggie. I've dedicated the last 20 years as a co-founder of ProCare, along with my brother, that testified just a minute ago, ensuring that we treat Texans like family. It's a big deal. I'm here to respectfully oppose Senate Bill 30 because it undermines our core Texas values, access to care, constitutional process, and conservative principles. As a conservative myself, I oppose Senate Bill 30. In the roughly 2.5 weeks since the bill was filed, Austin alone has had major stoppages on I-35 due to some very significant accidents that have been in the news. Imagine if that was your brother, your sister, your dad, and them not having access to high-quality care. The reality is we've heard several instances where they're not going to necessarily have access to care. The most likely consequence of this bill is a devastating reduction to access to treatment. And let's be clear, juries in Texas already evaluate medical bills for reasonableness. This is not a carbon copy of the Florida law. The Florida law shows it is based on reasonableness, not based on a cap, as otherwise has been stated. So juries already evaluate based on reasonableness and including comparing them to Medicare and Medicaid rates. We've also heard that, you can submit a $2 million bill and you're going to somehow be considered for $2 million. That just is substantially false. Juries already get to see substantial basis for what somebody would be considered for reasonable. But in our cases, we may not get paid for a year to 5 years, or potentially not at all. And so the vitriol that we've heard with regard to, all the different adjectives we've been called this evening, the reality is, and what I want to leave you guys with, is that we treat injured Texans like family in our office. And honestly, that's what I want to be remembered for.
Thank you. Appreciate you being here. Members, are there any questions for these witnesses? All right. Thank you. Appreciate y'all being here. All right. I may repeat some names from before, but I'm going to go on and call Sarah Nicholas, Ronnie New, George Christian, Steve Woleb, Andy Webb, all right, I'm going to call a couple more. Chair calls Ronald Luke and Carolyn Kale. I'm going to keep going. Sarah Hammond. Did you say Sarah is not here? Thank you. Thank you. All right. Jerry Maldonado. And Brandon Woods. Okay, I think we have 5 folks now. No, getting close. Thank you. Appreciate you all being here. We'll start on this side and begin the testimony. And if you'll do your best to stay within the 2 minutes, I know everyone that's still waiting to testify will especially appreciate that. But let's begin by stating your name and then giving us your testimony, please.
Thank you, Madam Chair and members. Good evening. My name is George Christian. I'm Senior Counsel of the Texas Civil Justice League in support of Senate Bill 30. I won't repeat a lot of the prior testimony, but as you know, and particularly Dean Zaffarini knows, she's been through this a few times in her career. This is a very difficult job that you all have. It's to balance the interests of injured parties, of businesses that are swept up in this litigation, of families who are affected by these terrible accidents. And this is hard. And just from the league standpoint, I really want to express our appreciation to each of you for your attentiveness and your consideration. This is difficult. I think tempers can flare and run pretty high on these issues. And, again, I don't think y'all get enough credit for, just how well you treat the citizens who come before you with legitimate grievances. And that's what I wanted to say. So thank you very much.
Thank you. Thanks for your testimony. Please state your name and then give us your testimony, please.
Good evening. Thank you for taking the time to see us today. My name is Jerry Maldonado. I'm the current chairman of the board for the Laredo Motor Carriers Association. I am also the director of operations for Warren Transport, asset-based trucking company. Corporate office is in Iowa. I run the Laredo and Mexico operation for them. I live in Laredo, Texas. I'm here to show our support for SB 30 as a trucking industry, as the industry of Laredo, Texas. As you all know, the city of Laredo is the biggest port in the United States of America. A lot of trucks go through Laredo every single day. Why do we support this? Why do we feel this is good for our industry? Because it's going to help us. Is it a perfect bill as it sits right now? No, it's not. There can be tweaks. There can be things that, after today's discussions, can possibly be changed. Is it a good start? We believe it's a good start. At the end of the day, our drivers are on the road, and that's sometimes we forget. The drivers are doing their job out on the road every single day, and they're on the clock. as they drive. And their goal is to deliver our goods that we all use every single day from point A to point B safely. They are exposed more than most of us. We don't drive for a living. I don't drive for a living. I make a living with my drivers, but I don't personally drive for a living. So we have to remember that while they're on duty and they're out there working, to move all our goods, they are exposed more than the majority of us. And they, unfortunately, from time to time, will make mistakes. And we are not asking for us not to be accountable when our drivers make a mistake. If they make a mistake, that's why we are insured. And if something happens, God forbid, we will be responsible for their actions. But what we're trying to hope here is that what gets resolved is the abuse. And I'm sorry to use that word, but it's the abuse. I have an example of an incident in our company where, one of our drivers was involved in an accident. We had just installed our forward-facing cameras on the trucks, and that camera saved us because we got a lawsuit. That video was the first thing we sent to the attorney that sued us. He left us alone because it clearly proved that our driver did nothing wrong, right? So clearly there's things we need to fix, because if we didn't have that video, that could have been a lengthy process, and we could have paid money on that. But we just want your support, and we ask to be treated fairly. Thank you for your time.
Thank you. Thanks for your testimony. Please state your name and give us your testimony.
Yes, my name is Graham Van Duzen. Chairman Hughes and other esteemed members of the committee, thank you for having us here today. I'm the owner of Cypress River Logging Corporation based out of Longview, Texas. I'm also the chairman of the Texas Logging Council, and I'm here representing the interest of the entire logging industry, and I say that we are strongly in favor of SB 30. Over the past 10 years, we've seen at a minimum of an increase of 50% in our insurance costs. For most people, it's been 100% or even more in our insurance premiums. Because of this, owners like myself have not been able to hand out raises to our truck drivers that they need and deserve to put food on the table for their families. The cause of this rising insurance is the constant increase in frivolous lawsuits and the fear of unfair litigation and nuclear verdicts. I could share many examples of accidents in the logging industry where I feel like we've been treated unfairly, but what has happened to me, I believe, is even more damning. Over the past 5 years, we've been running cameras in our trucks, and in those 5 years, on numerous incidents, I have showed up to scenes of accidents with camera footage showing that people were attempting to scam us. And this has happened on multiple occasions. When I show up and show the footage, the troopers will go and show the footage to the other parties of the accident. And in one occasion, one person even tried to attempt to flee the scene. The only reason they would do this is because it's an easy payday. Run into a log truck, get paid. That's what they tell you. That's the only reason they would do this. So I believe that going forward, it's absolutely imperative that the personal injury claims are based on real medical costs and not inflated or fraudulent costs. Thank you for hearing my testimony.
Thank you. Thanks for giving us your testimony. Please state your name and give us your testimony.
Yes, thank you. Good evening, Senators. I'm Steve Wallab. I'm with the Texas Hospital Association, and I'm here tonight on behalf of our membership, respectfully testifying on Senate Bill 30. We understand the problem this bill is trying to address and are generally supportive of liability reforms aimed at improving the Texas business climate and related to healthcare, specifically promoting access to care. We are also supportive of the part of the bill that encourages patients to use available health benefit coverage as good public policy. We also support the provisions in Section 2 of the bill limiting discovery from facilities and providers. However, we are concerned with the provision allowing a judge for good cause shown to allow discovery and testimony. Experience as related from our members has shown that third-party discovery requests to hospitals can be extremely burdensome and time-consuming, and believe the purpose of the bill can be accomplished without the provision found in Section 18.001B2. Removing that section would give greater certainty to hospitals and limit expensive and time-consuming legal work. We also have concerns about the provision in the bill found at Section 41.104A3 that limits the recovery of medical expenses to a percentage of an external benchmark. Our concern relates to the legislature defining in statute reasonableness of medical expenses at some multiple of an arbitrary benchmark. Many factors go into how a hospital sets its charges that are unique to the hospital and not factored into those benchmarks. THA has long maintained that outside of government payers, market forces rather than the legislature should define what constitutes the reasonable value of healthcare services. Thank you.
Thank you. Thanks for your testimony. Please state your name and give us your testimony.
Good evening, Chairman and committee members. Thank you for the opportunity to testify in favor of Senate Bill 30. My name is Brandon Woods, Executive Vice President of Refrigerated Transport, a small trucking company based out of Burleson, Texas, that has been in business in Texas since 1947. For the last 21 years, I've worked to run this company to help deliver food to grocery distribution centers and food service companies that supply restaurants in Texas and around Texas. We pride ourselves on being a very safe company, having one of the lowest accident rates based off of miles traveled per year. I want to share just a couple of instances where frivolous lawsuits have negatively affected our business. First one was in Dallas. We had a minor fender bender at a four-way stop sign, less than 2 miles an hour. Second one in San Antonio, Texas. Our truck was making a right-hand turn. The bumper of our trailer hit the front fender of a car. Both times, very minor incidents, very small damage, really just scuff marks. Within weeks of both of those instances, we received a letter from an attorney that most likely everyone in this room knows because of their TV, radio, and billboard ads. Same attorney in both instances, same essential form letter both times. In summary, the letter reads, "We've been hired by the individual you were involved in an accident with and would like to settle this claim outside of court in the amount of $1 million each. If we don't hear from you, we'll be forced to file a lawsuit to recoup these damages." Our insurance company set reserves for both of these cases in excess of $800,000. Both of these cases took over 3 years to settle. They both did settle, but in those times we had insurance renewals. Those reserves were over our head, and which ended up being premiums and 20 to 30% increases year over year. If that continues to happen, we no longer have a viable business model. Both cases were settled. First one, $125,000. Second one, close to $250,000. In conclusion, I just want to make it clear we are not trying to get out of paying when we are at fault. We want to make sure that those people are whole, but we do want it done in a fair and common sense manner. I want refrigerated transport to be able to deliver food to hardworking Texans and to provide jobs to hardworking Texans for another 80 years. And with tort reform such as Senate Bill 30, we can make sure that happens. Thank you.
Thank you. Thanks for your testimony.
Chair, just one
Senator
quick question.
Schwertner.
To the gentleman from THA, is there any benchmarking that y'all would be supportive of, or do y'all support maintaining your bill charges as the last remaining vestige of reimbursement methodology when it comes to these type of patients that are served?
Senator, I can't think of any that, as I said during the testimony, it's been our longstanding position that really these matters in terms of how the hospital gets reimbursed for its services, outside of government payers where we simply take what the government is going to pay us, really should be left to those market forces, and no benchmark comes to mind. In fact, I think that's been as I said, our consistent position that we wouldn't be in favor or supportive of tying our reimbursement to that external benchmark.
Y'all freely and willingly sign contracts with the government through Medicare, the state through Medicaid, and many, many different private insurance companies, correct? And workers' comp for that matter as well.
Sir, I'm sorry, I didn't hear that.
Hospitals freely set their rates based on a benchmark when they sign contracts with Medicare, Medicaid, health insurers of all sorts, and workers' comp, for instance, and Champus, VA, correct?
In those instances, yes, we are certainly price takers in those circumstances.
There should be any sort of benchmarking or price control based upon any sort of benchmark when it comes to reimbursement methodology off of billed rates for those that have been injured and y'all are working with a letter of protection, as other providers do, with that agent, with that PI firm.
We would not be supportive of any benchmarks.
All right, thank you.
Thank you, Senator Schwertner. Members, any other questions for these witnesses? If not, we thank you for being here and you're excused. Right. The chair calls Ronnie New Bain Philippi, Jason Robbins, Matt Riley, Nolan Howard, Andy Webb, Ronald Luke, have a seat, Carolyn Kale, she's left, thank you, thank you, Dave Embertson, Gerald Ladner, all right, thank you. I'm going to go on and call the next 5, and if you'll just be ready to be on deck. Annie Gunn, Bill Ward, Henry Higgins, Vivek Mahendru. I think that was only 4, wasn't it? Charlie Gordon. Well, thank you all for being here. We'll start with you. If you'd begin by stating your name and then giving us your testimony, and again, if everyone will do their best to be mindful of 2 minutes. Thank you.
My name is Gerald Ladner. I'm a 44-year veteran of the property and casualty insurance industry. I'm here today to support Senate Bill 30. I recently retired as an officer of a publicly traded insurance company. I brought a major company here in 2006 because it was a very strong business environment, as well as the litigation is not what it is now. The game has changed, and there's never discussions about what are the proximate causes. One is social inflation. People have a propensity to sue more often. Secondly, venture capital is entering the litigation funding, and they're making record profits on the backs of these businesses who are struggling to survive. I'm also independent board member of a captive insurance company that insures 130 colleges and universities around the country, some of which are in Texas, that are beginning to see an increase in litigations, which ultimately will impact tuitions. In all disclosure, I'm also the presiding officer of the State Office of Risk Management Board of Directors. I look at this business from a macro perspective. We have dynamics in play that have the potential to cause insurance companies to retract capital from this market, further reducing options for these very businesses that need the industry's support. We take a lot of hits as an industry when the market changes, but reinsurance is global. When states are tagged as being untenable in terms of being able to make a profit, rates go up, coverage gets reduced, and these businesses are exposed. That is my testimony. Thank you.
Thank you very much. We appreciate it. Please state your name and give us your testimony.
Good evening. My name is Matt Riley. I am a vice president and general counsel at Ranger Excavating. We're a local earthwork contractor that works on a lot of the really cool projects you see going up around Central Texas. I wanted to spend a few minutes discussing an active claim that we've got right now that I think demonstrates just how bad the overbuilding issue has gotten. It's a minor impact collision. There was no airbag deployment, no EMS called to the scene, no injuries noted at the scene. The claimant did not go seek any medical treatment that day or for 2 weeks after the accident. It wasn't until after she met with a plaintiff attorney that she finally went and sought medical treatment 2 weeks later. And he referred her to all of his doctors. And now, as we sit here a year and a half later, they have worked up $402,000 worth of medical bills, all related to soft tissue injuries. There's no herniated discs, there's no broken bones, there's no traumatic brain injury. Soft tissue injuries, $402,000. She's got $167,000 with a pain management doctor that she's seen 4 times. He's given her a series of anti-inflammatory steroid injections. In a normal setting, those would cost about $1,000 a pop. He has somehow submitted a bill that's $167,000. She's had a nerve ablation done. That's a minimally invasive procedure that in the real world costs about $3,000 to $5,000. They charge $72,000 in this case for a nerve ablation. You can have a heart surgery for less than $72,000. You can go all the way down line item by line item. Every bill that's been submitted in that case, they are literally all 10 to 20x what a normal rate would be. And the messed up thing about it is that those bills will never be paid in an amount that's anywhere near the numbers that have been charged. And the really messed up thing about it is the plaintiff lawyers and the doctors know that before they even submit the bills. They don't expect those numbers to be paid. They know that those are fake numbers for the sole purpose of a lawsuit. In any other arena or industry, we would call that fraud, or we would at least call it price gouging or other bad names. But for some reason, it's allowed here, and it has the effect of, in all these minor car wrecks that happen every day in Texas that used to settle for reasonable amounts. The plaintiff attorneys want over $1 million on every one of those now, and it's an unsustainable problem, and we need your help. Thank you.
Thank you. Thanks for your testimony. Please state your name and give us your testimony.
Paxton. My name is Bain Philippi, and I'm here for McCoy's Building Supply, a Texas-based company with 85 retail stores, over 500 delivery trucks, and over 3,100 employees. We support Senate Bill 30. With the exception of one military deployment, I've practiced law in Texas since 1998, first in private practice and now as Senior Vice President and General Counsel of McCoy's. McCoy strongly believes in our legal system and access to fair compensation for those with legitimate injuries. However, in the past several years, we've witnessed firsthand a significant increase in a scheme that attempts to warp, pervert, and distort nearly every minor incident into a multi-million-dollar case. Whereas a few years ago, a minor fender bender would result in punctual and reasonable settlement, today that same event will result in manufactured medical damages that total hundreds of thousands of dollars. Conservatively, over 85% of all cases currently brought against McCoy's involve this scheme. To fight back, over the past 15 months, we have taken 2 of these cases to trial. After each of these very minor incidents, the plaintiffs stated they were not hurt. The plaintiffs' lawyers then referred them to associated doctors for overdiagnosis and overtreatment, morphing non-injuries into grossly inflated injuries and charges. Between these 2 cases, the claimed medical costs were over $900,000 and were used as the basis to make combined total demands exceeding $20 million. This scheme has had a profound impact on our business. McCoy's cost to defend just these 2 cases was over $600,000. And over the past 6 years, while our truck fleet has grown 9% and our store count has been stable, our auto and general liability insurance rates have increased 239%. For a business that's operated across Texas since 1927, such a rise in legal defense and insurance costs is simply untenable. Thank you.
Thank you. Thanks for your testimony. Please give us your name and then your testimony.
Thank you. My name is Ron Luke. I'm a resident of Austin. I'm testifying in support of SB 30. In my consulting practice, I specialize in healthcare economics and public policy analysis. My clients include plaintiff and defense, personal injury attorneys, health plans, and healthcare providers. I've been accepted as an expert in state and federal courts and by the State Office of Administrative Hearings. A large part of my practice involves reviewing plaintiff medical bills and plaintiff life care plans. Plaintiffs very often have health insurance, and I would point out that about 83% of Texans have health insurance, but do not submit claims to the insurer at negotiated rates, but incur unreasonably high charges under letters of protection. This includes plaintiffs over 65 with Medicare coverage, and plaintiffs with workers' compensation coverage where there is no problem of the bills being denied. Many others have employer-based coverage or coverage under the Affordable Care Act, where again, there is no exclusion for pre-existing conditions or for accidents. There's often no reason for plaintiffs not to use their insurance coverage other than to inflate their past and future medical expenses to secure larger judgments. I hope SB 30 lets defendants tell juries the true cost of medical expenses at the rates available to the plaintiff, whether they use them or not. I hope SB 30 will reduce or remove the economic incentive for plaintiffs to inflate medical costs by not using available insurance. If the defendant is at fault, the insurers have subrogation rights, so the reasonable cost of the medical expenses falls where it should. I support the provisions limiting the amounts plaintiffs can recover for medical expenses to 150% of the median non-governmental payment rate as an improvement over the status quo. But I would go with the second option, which is 150% of the workers' compensation rate, because we've had those rates under formulas in effect since 2008. And there's been no problem of access to care, and when some has emerged, they've made the adjustments. So that's a very reasonable basis for payment. Thank you very much.
Thank you. Thanks for your testimony. Thank you for being here. Give us your name and then your testimony.
Yeah, my name is Dave Embertson. I own a company called Erling Sales and Service. Our company provides, installs, and services vehicle fueling facilities. In short, we build and service gas stations. We have 6 offices in Texas. Territory is the eastern half of Texas from southern Oklahoma to the Mexican border. We have roughly 100 employees, 70 of which drive vehicles on Texas highways every day. I'm testifying today because largely due to a very large insurance settlement for a very minor accident, our insurance costs have increased over $500,000 in 2 years. We're in a competitive industry, have not been able to pass those costs on to our customers, and as a result, we've had to eliminate some jobs in our company. Our story began, in this case, in April of 2022 when one of our employees was parked at a red light. When the light changed, our employee began moving, but the vehicle in front did not, resulting in our vehicle striking the vehicle in front. We have GPS systems on all our vehicles, and the GPS showed that our vehicle was traveling at less than 10 miles an hour at impact. The 2 occupants of the vehicle that was struck got out of their vehicle and exchanged information with our driver. At that time, both said they were not hurt. In June of 2022, a couple months later, our insurance company settled the vehicle damage claim for $3,183.67. And by the way, that was the cost of replacing that bumper on that pickup truck. In November of that year, we received a letter from our insurance company stating, to our surprise, that they had settled a bodily injury claim for one of the people in the vehicle in the amount of $82,300. In February 2023, a few months later, we were served with a lawsuit from another person in the vehicle asking for damages of $1 million for negligence, negligence per se, and gross negligence. The lawsuit included a demand for a jury trial. In March of 2023, I'm sorry.
You can go in and wrap up your thought.
Keep running? Okay. March of 2023, our insurance company has sent us a letter advising us that this case appears to be so serious that the total value could exceed our $1 million policy, and advised us to hire our own attorney at our own expense. A year later, in April of 2024, we received a letter from our insurance company that they had settled the case for $500,000. In summary, in an accident where our vehicle was traveling at less than 10 miles per hour at impact, where the damage to the vehicle was settled for about $3,000, and where the occupants of that vehicle said they had no injuries at the scene, that claim cost us $580,000. I'll wrap it up, but that increased our insurance costs by $500,000. In a company of our size, that's the difference in being profitable or not being profitable, and frankly, that means payroll or not payroll.
Thank you. Senator Birdwell, you're recognized.
Thank you, Madam Chair. Mr. Philippi, if I hope I'm saying that correctly. In reading your testimony, you mentioned here that because of the abuses, your company McCoy's made the decision to fight 2 of those cases. Did that turn out to be a good return on investment?
We won the cases, Senator.
Right. Did you win on the legal matter and lose financially, or did you win on the legal matter and win financially?
We won on the legal matters. The last case was dismissed with prejudice after a long fight. That case, we had over $400,000 just to defend that case.
Okay.
So financially, I would say that's a loss,
Right.
Senator.
Right, because you're making the conscious decision to risk. I heard you
Absolutely.
served on a deployment. It's the difference between choosing your Article 15 or a court-martial. You risk the court-martial to get acquitted as opposed to taking the Article 15 and walking without,
That's right, Colonel.
So,
That's right.
so what I'm really looking for in your perspective the business's perspective is you're having to do defensive trucking, for lack of a better term, just like defensive medicine, and then determine the risk factor of whether or not to settle, go to court.
Absolutely.
And I assume each of the companies represented here are having to do the same thing?
And I appreciate the question, Senator, because it'd be cheaper, frankly, to settle that. But after a while, it doesn't. We turn into an ATM for trucking, right?
But at some point, if you've settled so many times, your premium's going up anyway, right?
Absolutely.
I mean, did you get any relief in your premium in your winning the case?
No, Senator.
That sucks.
Yeah, so in fact, it went up on our auto side about 30%. On our GL side, it went up even more. What I gave you was the last 6 years, that 239%. But we've installed cameras in all of our trucks. We're doing everything we can. I've got a corporate mandate that if I don't do the right thing, I'll be in trouble. I'll lose my job. Like, we are expected to do the right thing. At the same time, we're trying to fight this, and fraud's a big word, right? Trying not to use that too much. But the two cases I outlined, they both said they weren't injured. They both said that. And then they went and got the lawyer, and then they went and got the doctor. And then they get these inflated medicals that are frankly fabricated for over $600,000. It's incredible.
Yeah. You had mentioned the what we would call fraud in some other place.
Yes, or at least price gouging. If on the Texas Gulf Coast, if a hurricane hit and contractors came in and tried to charge 10x to help clean up the trees or provide generators, we would say that's price gouging, and we wouldn't allow that because they're taking advantage of people. That's exactly what's happening here. I don't know why we're scared to call it what it is here. And kind of piggybacking on your point, while the runaway verdicts are certainly a problem, it's the everyday minor impact collisions that happen every single day that you used to be able to settle for a reasonable amount, $75,000, $80,000. Even in those cases, the plaintiff lawyers want over $1 million in every single one of them now because they've got such inflated medical bills. They've got $400,000 in soft tissue treatment. They want $1 million on a 3-mile-an-hour fender bender. Those are the ones. I understand the runaway verdicts are a problem, but these everyday minor accidents that add up over time, those are the ones that I think are really going to cripple the industry.
Yeah, because they're metastasizing into something worse. So.
Yes, sir.
Thank you. Thank you. Thank you, ma'am.
Thank you, Senator Birdwell. Senator Perry, you're recognized.
So back to McCoy's. So the two people said were not heard at the rec site, which is a common thing, most people. But you go to trial and you have these inflated bills. Is there an opportunity for you guys to have your medical team look at that information, or is?
Absolutely, Senator. In fact, when I retain outside counsel and experts, I want them to tell me the truth. If we cause something and they're truly hurt, we will figure out, maybe with our carrier, if it gets outside our deductible, how to make that right. But that's not what happened in these cases.
So y'all drug this out for 3 years, you said, something like that? 3 years? It went for 3 years, $600,000 in legal cost, right?
Yes, they both went 2 to 3 years. That's right.
And so at the end of the process, they determined somebody was lying. Was it the doctors? Was it the victim? Was it who was lying in that process?
Senator, in our experience, it's been the combination. So on the first case, December 2023, we had plaintiffs that that fabricated what happened. We think that was guided by plaintiff's counsel. And the doctors, in that case, they did steroid injections. There was 10 to 12. They charged $85,000.
So the question becomes, you were vindicated through the trial process that y'all were correct and there was no problem. Is there recourse for those people that lied on the stand that I was injured when I wasn't, and the doctors that said they were when they weren't, and the trial lawyers that were bringing it? Is there any recourse for anybody that's in the attorney world to start hitting it at the heart of where it's at?
There's no apparent recourse today that I'm aware of, Senator, but we're actively searching for that.
Okay, well, and I've said this before, and we all acknowledge some of the stories we've heard today, but it's the bad actors we chase. Bad actors come in lots of forms. Some are people that get a fender bender and sue for $1 million. Some are that take that lawsuit on, and then some are that have her complicit in the lies that get them to that process. And so I don't understand how we can't close that gate too. Additionally, and I've heard this time and time and time again, and I have good friends that are in this business, it's the big bad insurance companies. But I hope, if nothing else today, for the time that we're sitting here, it's not the insurance companies. It's the W-2 employees that work in these companies that at the end of the Christmas day, you can't say, I can give you a Christmas bonus, much less I have to let you go. Because the cost of doing business does not allow me to pass that on to the lumber board feet cost, because then I'm non-competitive with the next lumber company. I heard somebody earlier today, we just couldn't pass that on, or you pass that on. It's just like taxes. There's one payer. I don't care if it's federal, state, or otherwise, there's a consumer pocket. One checkbook writer. It's not the insurance companies. It's the people that work for those companies that suffer the most when this is out of control. And that's what we're hearing the theme today. It's out of control. Unfortunately, the legislature is called back to pull it back in. I don't know where it lands today. But until the industry, i.e. attorneys, police their own and stop participating in the lies on the stands, and then there's no recourse, I think there has to be recourse somewhere in there that I don't know where it's at. So,
well, I assure you, Senator, that we are trying to fight back. That's why we took these to trial. The reason we were able to get some of those relationships out was because of the judge in that case that happened to let that in. But that's part of the problem. If you're in an unfriendly jurisdiction, you won't get that relationship.
I appreciate that. Thank you. And you are a great company, great store in Lubbock. But I know the family. We're there in opening, and it's a good company being around. But
thank you,
I just can't believe people can get by with just, basically, I'll call it what it is. It's a lie. It's a fabricated lie with support to perpetuate it. And it is the fender benders, the $1,500 damages of property. There ought to be some correlation there.
Thank you, Senator Perry. Members, any other questions for these witnesses? Thank you all so much for being here. You're excused. All right. I'm going to do some recalling of some names, but the chair calls Ronnie New, Jason Robbins, Nolan Howard, Andy Webb, Annie Gunn, Henry Higgins, Vivek Mahandru, Ware Wendell, Charlie Gordon, Christopher Choon, Brett Butler. All right. Thank you all for being here. We appreciate it. And if you'll do your very best to stay within the 2-minute testimony, there's still a lot of people that want to testify. If we'll start with you, and you could state your name and then please give us your testimony.
My name is Brett Butler. I run a First off, thank you. It's very late, and I appreciate it. I run a small commercial construction subcontracting company here in Round Rock. We're in Round Rock. I've listened to everything today. It's very interesting. We bid all of our business, so we cannot pass it along. It's competitively bid, and the concept of just pass it along to the next guy, it's just not possible. I don't think we've raised our prices in the last 5 years, but our insurance has gone up about 65% on the auto side. Not due to unsafe driving, not due to anything but the market. And we get told every year that insurance companies aren't making money on auto insurance. And then the second part is settling. Because in we drive one-ton trucks with cargo trailers behind them with a load. And we're guilty until proven innocent. And if we can't prove ourselves innocent, it's going to be settled, because insurance companies are businesses too, and they're going to make a decision for you. And I've started recently trying to get them to drive to litigation, because it's got to stop somewhere. And even if I have to participate in that, it's got to stop somewhere. We have employees just like anyone else that depend upon us to do the right thing and give them a good place to work that's safe. We provide medical insurance for them. That's also another issue that's just incredibly high and difficult to continue to provide. But we do that. And the thing that keeps me up at night, is not securing the next deal, the next project. It's whether or not the fours are going to call me. That's it.
Thank you. Thank you for your testimony. Sir, if you would please state your name and give us your testimony. Thank you.
Thank you, Madam Chair. Ware Wendell with Texas Watch. We are opposed to the legislation for over 25 years. We have advocated for safety and accountability in this state, and we're very concerned. I'm having distributed an analysis of census data. We lead the nation with the most uninsured folks. Wallet Hub did an analysis recently and shows that Texas is 49th in the nation when it comes to patient access. So we have a patient access crisis in this state, and the bill that you have before you is going to make it worse, unfortunately, because it's going to deprive injured Texans of care, many of them. We believe that you should be able to get the best doctor you can, and it's really not the government's role to get in between that doctor and that patient. That's intrusive, that's invasive. You've heard the reasons for why you may not be able to use your insurance. You may have a high deductible, you may have high copays, you may have a bad HMO where you can't get to a good surgeon to get you the best care. And if that patient can get that care early, that is a cost savings to the system because they have a better recovery. They don't have a complicated recovery. They have a better recovery. We've heard some insurance testimony, but I'm surprised that I haven't heard this number. In 2024, according to AM Best, the property casualty industry made $144 billion. Record numbers. And it's too voluminous for me to distribute to the committee, but I will submit it through the clerk. The Consumer Federation of America, former Commissioner Bob Hunter, who regulated our market in the 90s, and the Center for Justice Democracy have done the definitive analysis of what's happening in the insurance industry. I understand people are mad about their insurance premiums. We're working together, Senator Schwertner, to work on that when it comes to other lines of insurance. But they're over-reserving. They're sitting on surplus. I'm out of time. I will take questions.
Thank you. Thanks for your testimony. Sir, if you would introduce yourself and give us your testimony, please.
Yeah, good evening. My name is Dr. Vivek Mahendru. I practice here in Austin, Texas, and I am opposed to the Bill 30, SB 30. First of all, thank you for allowing me to speak. Thank you for the opportunity to testify. I believe SB 30 is bad for Texas for several reasons. This bill violates free market principles. Republicans believe in free enterprise. SB 30 is a government-imposed price cap on private transactions between doctors and patients. That's not free market, it's central planning. This is the beginning of socialized medicine. This bill dictates medical fees, undervalues care, and replaces negotiations with bureaucracy. In addition, Texas workers' comp rates are artificially suppressed. Workers' comp rates are heavily regulated and deeply discounted. Using them as a benchmark for private injury care is unfair and unsustainable. It discourages providers from treating injured patients altogether, which is what we've seen with the workers' comp in the past. In addition, SB 30 will shrink medical access across Texas. This bill will hit rural Texas hardest. When reimbursements don't cover costs, doctors stop taking these cases. The result, long wait, ER overuse, and less access for those who need it the most. This bill helps liability insurers, not injured Texans. Let's be honest, the bill benefits insurance companies, not the people of Texas. It's a corporate handout, and that abandons conservative principles and hurts working families, small clinics, and rural hospitals. Texas and Texans that are injured deserve better. Thank you.
Thank you for your testimony. Thank you for being here. Please introduce yourself and give us your testimony.
Thank you all for being here so late. I'm Charles Gordon. I'm a neurosurgeon practicing in Tyler, Texas. I'm the only neurosurgeon or spine surgeon in a 100-mile radius that will agree to see these people who've been injured, who are represented by an attorney. So this is not some boondoggle where, at least in my neck of the woods, people are clamoring to make obscene amounts of money. I'm concerned about this bill for two reasons. One, it will hamper access for my patients. They really have nowhere else to go. And so regardless of what you've heard, there's no question it will impair access to care for patients. Secondly, I run a small business. Our clinic employs about 125 people, and we all know that if their healthcare dollars are used to pay for liability cases, our healthcare costs are going to go up. So for those reasons, I oppose this bill, and I appreciate you guys' time.
Thank you for your testimony. Glad you're here. Please give us your name and give us your testimony.
Good evening, Senators, and thank you for hearing my testimony. My name is Dr. Henry Higgins. I'm the founder and CEO of Family Hospitals. Family Hospitals is a very small, bootstrapped healthcare system that was founded here in North Austin about 11 years ago. We currently operate 7 what we call neighborhood healthcare facilities, small hospitals, urgent cares, primary care. I represent about 65 physicians, including internists, ER docs, family doctors, psychiatrists, and surgeons. Less than 5% of our care that we provide is to accident victims. This is a very small part of our practice. However, it's a very rewarding part of our practice. Our system tends to focus on providing, we're small, we're very highly accountable to our communities that we provide care for, and we focus on trying to give patients care that they can't get anywhere else. We do a lot of work with eating disorders, behavioral health, substance abuse, and also accident victims. What we kind of fell into was, and this was through our emergency medicine practice, our hospitals have ERs. For the first several years, we've been open for 11 years, and for the first 2 or 3 years, when a patient would come in and they were in a car wreck, we just never got paid. We'd treat them, but we just never got paid. We'd try to approach the insurance company if we could find out. We'd approach the patient, but we never got paid. The insurance companies basically just snubbed their nose at us. Eventually, we stumbled across a patient who was represented by an attorney, and we got paid. It was crazy. We couldn't believe it. We actually got paid for the care we were given in the emergency department. We started talking about it. We're a small company. We had several members who had been in car wrecks and found it very difficult to even get care. We recognized that, oh my goodness, there's a whole section of people who are needing health care, and they're having trouble getting that. So we stepped in, and I'll go ahead and stop it.
Thank you. Appreciate you being here and waiting for your time to speak. Members, are there any questions for these witnesses? Senator Hughes, you're recognized, sir.
And I think each of the witnesses
And Dr. Gordon, you testified you're the only neurosurgeon within, I think, 100 miles of Tyler who helps patients in these situations. And I should know this. How many total neurosurgeons are there or at least in Tyler in the area, if you have a sense for that?
The number shifts around, Senator, but somewhere between 15 and 20 neuro and orthopedic spine surgeons in our area.
Go ahead. Thank you. That's all I got for now. Thank you.
Okay, thank you, Senator Hughes. Senator Schwertner, you're recognized.
One question to the Tyler neurosurgeon. You heard my questions regarding the fees that are set by your, in the case of the orthopedic surgeons. Can you tell us how you set your fees regarding generally for all patients and also obviously for those that are represented by attorney and you're protected by letters of protection?
The fees are the same across the board. Our office manager works with a consultant on a regular basis to make sure those fees are fair and reasonable.
With what methodology?
I'm sorry?
What methodology? Is it the Connects for Healthcare or Fair Health, or do y'all use a percentage of Medicare? What do you do when you set your fees?
It's our office manager works with an economist and looks at the work involved and sets those.
All right. You don't want to say. Thank you.
I'd leave it up to them.
Thank you, Senator Schwertner. Members, any other questions for these witnesses? All right, thank you for staying and thanks for being here. We appreciate your testimony. You're excused. All right, the chair calls Christopher Chun, Michael Lyons, Mike Englehart, Devin Pettit. And those are the last four that we have registered. Is there anyone else wishing to testify on, for, or against? So I tell you what, we've got 5 total chairs here, and the first 5 people here. And we'll just make sure we get you registered with our clerk. I've got 2 more chairs. Go on and have a seat. Go on and have a seat, sir. All right. Is there anyone else wishing to testify on, for, or against Senate Bill 30? All right. Make your way down if you would like to. But we'll go on and begin with the folks that are here. Sir, if you would begin, state your name and give us your testimony, and we appreciate you staying within the 2-minute time.
Good evening, Chairman and Committee. I'm Dr. Christopher Chun. I'm a pain management physician, and I appreciate the opportunity to testify. I'm in opposition of Senate Bill 30. A lot of things have been said today and this evening and been assumed about physicians and medical providers, and I can tell you that I'm not one of those physicians. I have just a disclosure, I have no agreements, nor does anyone control what I do. I choose to treat injured patients and realize the quality of care for these patients were below standard of care. I believe I was part of increasing that quality of care in my geographic area, the DFW area. I treat patients ethically, and it doesn't matter if an 18-wheeler hit them. If they're not having pain, they don't get injections, they don't get surgery. I treat patients in pain. 100% of my patients have pain, and I don't treat accidents. No one has said the obvious. All of these cases, all these accidents, there was negligence involved. If I had a med-mal claim and I had negligence, my med-mal insurance would go up. And so all these companies say their insurance premiums would go up. Just do better, train better, be safer. I've heard, like I said, a lot in the hearing today, and accusations were made and questions that needed to be answered. And I'm here to answer and shed light on any questions from the physician's point of view. Thank you.
Thank you. Thank you for your testimony. Please state your name and give us your testimony.
Good evening, Mr. Chair, Madam Vice Chair. My name is Mike Englehart, and for the last 16 years, I have served as judge of the 151st Civil District Court in Harris County, Texas. I know Harris County gets a bad rap, but I want to tell you I'm here as practicing an attorney now. I left the bench after December 31st, and I've been practicing with a law firm in Houston as a partner there. The point that I want to make, or the few points that I want to make is, trying hundreds and hundreds of civil jury trials over the last 16 years, I can tell you that juries almost always get it right. And for every nuclear verdict, of which there are maybe, honestly, the 7-figure verdicts make up about 8 or 10 of the verdicts that I've gotten in the 16 years that I served on the bench. It just is very rare. And for the most part, for each actual positive verdict where plaintiff's attorneys in auto accidents or other types of accidents collect any sort of damages, there are probably 3 or 4 where they get poured out and get 0. I believe that Senate Bill 30 is a solution in search of a problem. I should have said at the outset that I'm here to oppose Senate Bill 30. I don't think it solves any problems that we're facing because juries do get it right. And the other issue that I wanted to raise, this 2 minutes goes really fast, is that I do think this would dramatically add to the backlog that is perceived in Harris County and around the state. Remember, even though Harris County gets a bad rap, there are lots of judges all over the state that are elected by voters, both Republicans and Democrats, who have to deal with this and who make decisions every day about these issues. And this bill would take away a lot of the discretion that good judges have to let in relevant evidence, exclude irrelevant evidence, et cetera. So I would ask that the committee not impose this on our judiciary, because they are very well equipped to make these decisions without these additional tasks that I think this bill imposes.
Thank you. Senator Perry, you mind holding until we finish the panel? Is that all right? Okay. Thank you. Appreciate that. If you would introduce yourself, please, and give us your testimony.
Good evening. My name is Kyle Weaver. I'm here in support of SB 30. I'm a licensed attorney in Florida, Georgia, Alabama, and here in the great state of Texas. I presently serve as the Assistant General Counsel for a group of family-owned trucking companies in East Texas. We're proud to have existed in one form or another in various business organizations for nearly 100 years. We directly employ about 540 different people, and we contract with thousands others. Many of those are Texans. SB 30 is critical to our essential business. The transportation industry faces mounting pressure from lawsuit abuse. Unfortunately, nuclear verdicts have changed our industry and our world, not only for business, but for all Texans and all Americans. Essential businesses like ours pay significant premiums for insurance to protect from nuclear verdicts. And it's not just nuclear verdicts, it's the death by 1,000 cuts, because my colleagues in the plaintiff bar will always advertise those mega verdicts as reasons to get us and our insurers to pay more in every single case. Increased insurance costs are added into every product that you, the consumer, purchase, causing the goods and services you buy and consume to cost more now more than ever. Nuclear verdicts benefit the few at the expense of the many. It is a socialized or societal risk and a privatized benefit. In other words, you and I, as consumers and members of the middle class, pay increased costs on all the things we buy so that the trial bar can obtain large verdicts and become wealthier. At a time where the middle class is under constant and increasing attack from taxes, tariffs, political uncertainty, and other challenges, we must ask, what is justice? The unimaginable wealth of the few at the expense of the many, because our tort system cannot be good policy for our state. HB 30 is needed to return common sense to our laws, to litigation, and to ensure that just results are obtained from our jury system. You, as the legislators of this great state, have the opportunity and the duty to level the playing field and to protect Texans from the problems that is tort litigation in our court system. On behalf of all Texans, please pass SB 30.
Thank you. And could you repeat your name, sir?
Sure, it's Kyle Weaver.
Kyle Weaver, and we don't have you as registered, so in just a minute, I'll have you go over here to the table and make sure we get you everything down for you. Thank you.
Yes, ma'am.
Sir, if you would state your name and give us your testimony.
My name is Richard Yates. I live in Allen, Texas, and I'm a disabled CPA. I was in a car accident 24 years ago, hit head-on by a passenger van. I was a controller and a acting CFO for a Raytheon company. And my life as I knew it, it ended on that day, and it's taken me a long, long time to get over the grief of losing myself. And I'm certainly opposed to Bill SB 30, not so much for myself because I'm in the past, and thank God I had a good attorney and a good settlement, but it's for the person that's like me out there that's this bill will greatly impact negatively down the road. Other than my job, I lost all the confidence in myself as a husband and a father and a friend and a business professional. I lost my spouse of 25 plus years. She couldn't handle what had happened to me, so she moved on. My relationship with my youngest son was greatly damaged, and it took probably 10 plus years to try and mend that relationship. PTSD consumes me. Between January and April, it's at its peak because I was injured in the month of March. I know if someone was sitting in my shoes that this bill was passed and was applicable, things like I've been able to do, like being able to put my 2 youngest children through college, I wouldn't have been able to do. So they'd be stuck with debt for a long time. I would not be able to travel to visit my elderly father or visit my children or my grandchildren that live out of state on a regular basis. Nor would I be able to travel just to do the simple thing like watching my boys play baseball when they were growing up and play through college. So that's what I came to say. Thank you.
Thank you so much for sharing your story with us tonight and for making the trip and for waiting. You're the last witness that we have registered. I appreciate it. Members, are there any questions for these? All right, so there's like a dueling senator thing here. Senator Perry.
Thank you, Madam Chair. To the judge.
Yes, sir.
You're on the bench 16 years.
Yes, sir.
Set aside the nuclear verdict conversation.
Yes, sir.
That's not why our premiums are going up. Our premiums are going up because there's a $1,500 bumper damage. Clearly nothing wrong. And to the gentleman that was in that middle seat prior to you, it ends up, starts at $1 million, and then it ends up that the company wins, and somewhere along the line, the judge let that information into the courthouse that clearly was not, you couldn't support that. So I lay a lot of this at, and we've got some statutes proposed for judicial conduct to kind of look at the judges as they're going through these processes. But it's the property damages of $1,500 to $3,000 that end up in a multi-million-dollar lawsuit that companies are having their insurance settle for fear of what a jury might do, but it has no substantive fact in it at the end of the day. So how does a judge look at a plaintiff that's on the stands, clearly not a problem, said there was no problem at the wreck, but these $400,000 medical bills start showing up, and then ultimately there's no recourse when they figure out that all that was a lie. How does that work in the judicial system today?
I'm glad you asked that question. I would like to answer it, and the answer is a little bit involved, but if you would just give me a little bit of leeway, I would.
Well, we've been here, I don't know, another 30 minutes ain't gonna matter to me.
Very good, sir. Thank you. All right. So, as a judge, new lawsuit comes in, and it's set for trial. We set it for trial. We enter a docket control order. During the course of that docket control order, which is a series of tasks that the attorneys will complete in preparation for trial, they undertake discovery. Both sides get to learn. I don't mean to be pedantic. I know you know a lot of this, but this is my day-to-day for 16 years. Both sides engage in written discovery. They exchange documents. They ask each other questions. They gather medical records and bills. This bill would automatically allow the discovery of and admit into evidence 30 years, as I understand it, 30 years of past medical for a given plaintiff. Ordinarily, before this bill, one side or the other would ask for maybe 5 or 10 years of records for a plaintiff. The defendant would ask for 5 or 10 years of records. I would make a decision if there was a dispute. If it was brought to me as a discovery dispute, I would make a decision as to usually how far back from the date of the incident
I would allow the defendant to discover the plaintiff's medical records. I heard it said earlier today that they would allow that some judges would only allow for those body parts, medical records pertaining to those body parts. That's not how I did it. I would go back usually 5-7 years. I would allow them to discover all of those medical records. And then I would say, and this is routine, this is not an
Now,
onerous.
fast forward through the discovery and admission process.
Okay, so let's say, so they get whatever records that they get through the discovery process. If they come back and say, we found something in these 5 to 7 years, we want to go back further, we'll make that decision. Then they have all the records in front of me, and then they would offer them into evidence. They would offer certain things into evidence. I would make a ruling, and there's plenty of tools under Rule 401, relevance, Rule 403, whether the prejudicial value, excuse me, the probative value of the information substantially outweighed any prejudicial effect. Or, no, I have that backwards, I'm sorry, I'm tired. But anyway, I'd make a ruling under Rule 403 if there was an objection about 403. So the documents come into evidence. The witness testifies, all right? The witness and the jury, the 12 jurors that have been seated, assess the credibility of that witness. They look the witness in the eye. They determine whether that person was, they believe whether that person was hurt or not. Let me back up to 18001 because that's in this bill as well. You're talking about these $400,000 in bills. That's not realistic. They don't come into evidence like that. They're not unfettered. They're not untested. If a plaintiff comes to the trial and says they have $400,000 in bills, that's very unusual because what happens is they will have a records custodian or the doctor sign an affidavit or give a deposition and say these records and these bills are, the charges are reasonable and the services were necessary. All right? So then the defendant in every case, just about every case, brings their own doctor. Now the Texas Supreme Court has changed the law to make that easier for defendants. Now defendants can bring what we used to call a CPT code expert or a billing code expert, and they can fill out an affidavit, a counter affidavit, and say, no, those charges are not reasonable and necessary. And guess what happens? For the most part, they agree with the plaintiff's doctor and say, a lot of these charges are reasonable and a lot of these services were necessary. But let's say there's a disagreement, all right? And so they knock out a lot of the bills. That's fine, that's normal. That happens in Harris County, it happens in Grimes County, it happens in Amarillo, whatever county that is. It happens all over the state. And then once that counter affidavit is filed, the plaintiff must bring a doctor, not a records custodian, a doctor to the courthouse to testify about the reasonableness of the charges and the necessity of the bills in front of a jury. And that same jury gets to decide whether those charges are reasonable and the services were necessary. If the jury agrees that they were, 12 men and women from the community make this decision. And both sides get to voir dire that jury panel and decide whether a juror should be struck for cause, whether they would make a good juror or not. It's a fair system where both sides get access to all the information. And then the jury gets to decide whether those charges were reasonable and necessary. If they agree, they award them. If not, they don't. And I will tell you that in huge swaths of cases that were tried in front of me, a Democrat in Harris County, from 2008 to 2024, jurors awarded $0, or they awarded a few $100. They might award half the medical bills and $1,000 for past pain and suffering and $1,500 for future pain and suffering, and that's it. That's the norm. That's what really happens down at the courthouse.
Is there any how do attorneys? I'm not an attorney by choice.
My kids either.
So on that last case where they spent $600,000 in attorney's fees only to be vindicated that they were correct as a company.
Yes.
Do judges, my understanding, judges have the discretion to award attorney's fees?
No, not in a negligence case. Absolutely not. Now you can do that. You could make that law. But right now, no. In a car accident case, neither side gets to recover their attorney's fees. But I will tell you this, if you let me. There are plenty of mechanisms like Chapter 9 and Chapter 10, Rule 13, and other statutes which allow for people, defendants who are aggrieved in these situations to assert that a given lawsuit is frivolous, I have seen State Farm sue plaintiffs' lawyers for fraud regularly. I have seen sanctions motions for frivolous pleadings. There are myriad tools for defendants or insurers who are aggrieved to strike back at, and you know what else there is? There's criminal perjury laws. And if someone is lying on the stand, go file charges with the DA.
So it's not up to the judge if someone lied on the stands.
Say that again?
If I lie on the stands, I wasn't injured and I ultimately ended up lying on the stands, who brings that criminal charge for perjury?
A witness. A witness. Typically, a judge does not get involved because then they must recuse themselves from that case.
And then the last question, and I'll leave you alone.
No, please, I'll answer all you. I can do this all night.
I mean, it's my understanding judges are the only one that can refer an attorney for misconduct.
Oh, absolutely not. No. Anybody can file a grievance.
What's the judicial review that we just beefed up? Judicial conduct.
Judicial conduct?
Yes. So we just made some changes there where it should be more relevant. So if you have a guy in front of you that's springing $1,500 property chance, and that's been his payday. I used to have a PI client, and they called it dialing for dollars. Every day they would dial, and as long as they got $10,000 per settlement and didn't have to go to trial, they were good. And that seems to be, I think, and that's been in the 80s. So I think the 10,000 has moved to 100,000 now. I just think there's just too many people in this system that's doing this. It's not me, but it is me. And somewhere in here, it's going to bankrupt businesses. And really the impact of that is loss of jobs.
I agree, and I'm sympathetic to that. I just don't think this bill solves the problems that you're looking at.
Well, then provide some real alternatives that we can that will solve the issue, because it doesn't look like judges want to be engaged at the level they should be. It looks like attorneys can pretty much get anybody to say anything for any amount of money they want just to push the envelope, and there's no recourse.
But I just explained to you, Senator, that that's incorrect.
I hear you what the system is, but we're not seeing double digits, if not triple digit increases in insurance claims when the system is working. And we're not the #1 in the country for lawsuits that we can no longer afford in the premium base because the system's working. Something's not working.
A lot of what you've heard, with all due respect today, almost everything you've heard today, sir, is anecdotal.
So anecdotal proves that Texas is the #1 in those verdicts.
Is it per capita or is it #1?
Because
it's a very big state, Senator.
Yeah, I hear you.
Thank you, Senator Perry. All right, so we have Senator Schwartner, then the Dean, and then Senator Birdwell. So Senator Schwartner, you are recognized.
Thank you. Just a few questions. The pain specialist on the left there, sir.
Yes, sir.
Where do you practice?
Dallas-Fort Worth.
And do you have your own practice, your own ASC, your own pain center?
My own practice.
Okay.
I do not own an ASC.
Okay. And is your practice primarily letters of protection in the treatment of injured individuals that are?
I wouldn't say so. I mean, we do treat injured patients.
What percentage?
Some happen. I couldn't tell you. I don't know that percentage, actually.
When you do have a situation which you have a letter of protection, how do you set your fees?
The fees are the same, whether it be cash, if they're represented by attorney, if we bill their insurance, it's all the same.
How do you do that? How do you set your fees?
Based on, so I've done defense work, I've seen bills, I've seen my peers, what they bill, I've done a lot of consulting work in that sense. And so I've seen the range of what's billed. I know we're not near the top. So we're within the range of what's billed. And that's really what's the usual, reasonable, and customary charges in the DFWR's actual bills, not some bogus database.
What is have you seen reimbursement rates that you've received compensation from a letter of protection?
There's
You know
no
what you get
reimbursement
paid.
rates for letters of protection, sir. I mean, everything is on a case-by-case basis.
Do you
I can
know what
tell
you
you
get paid
that
for
if
certain
we,
procedures?
excuse me?
Do you know what you get paid for certain procedures when you have an injured patient and you do an ESI, for instance?
So we actually don't keep data based on CPT code, if that's your question.
You don't even do it by CPT code.
It's not based on CPT code.
So, well, what about procedure? Like an ESI?
That would be the same thing, sir, CPT code and procedure. So, I mean, I can tell you that if there is no attorney involved and there's a third-party liability, we usually get paid 100% of our bill from the insurance companies.
So how do you bill a patient then for services? You don't do procedure-related coding at all?
No, we do the coding and billing. I'm just telling you we don't keep the data in regards to the reimbursement you're talking about on the...
And so, do you know what 62323 is, obviously? It's probably the most common.
62323 is a...
ESI, lumbar with fluoroscopic imaging.
We do a 64483, but that's a transfemoral approach.
Do you know what your reimbursement rate is for that? What you
So once again, sir, I said we don't keep that data based on CPT code.
Okay. The average Medicare rate for an ESI for a physician performing one of those is nationwide is about $233.30. He's being very opaque. Every provider that's come up here has been very opaque about how they bill and how their relationships are from a financial standpoint in these letter of protections and methodologies for which they utilize when they set their rates. And they're very adverse to the setting it based upon a schedule, which is common practice for Medicare, for Medicaid, for workers' comp, for health insurances. We all know that you can look up a code and know what the standard rate is from a methodology. But as he was alluding to, you just said, y'all don't use that methodology because it would tie you to a code and you would not be able to bill based upon the methodology y'all think is most appropriate to bill when it comes to the care of these people that you're treating through a letter of protection. Am I right?
I respectfully disagree. I would say, like, if you wanted to use Medicare, and I'm not a Medicare provider, so I'm not bound by that fee schedule, but I would respectfully say that, as you know, as a former physician, or I mean a current physician still, but a senator, that 100% Medicare, no one could survive.
I'm not arguing Medicare and survival. I'm arguing how you bill and the opacity.
I told you based on what's billed within the DFW area.
The usual customary, right, is the term you use.
Actual bills, and I'm within that range.
Build,
yeah, actual bills.
How do you set your actual build, once again?
Based on bills, I have seen actual bills in the DFW area.
Which is the usual and customary for that geographic region.
That would be common sense definition.
So you look at someone else's and basically set your rate based upon someone else's.
Not just
rate.
one, many.
Yeah. And you use no database, no methodology. You just look at it and decide to go with it, right?
In regards to databases, if you actually look at the actual, it may talk about how many millions of claims, but they don't give you the breakdown. It's biased, and they don't give you the breakdown of what it is. It could be 90% Medicaid. You don't know that. And so it's very biased, and actually none of them will say, even the book that was brought up today, if you look at it, they do not know, and they will not disclose the breakdown of it.
Once again, members, I think my point's been made about how the opacity is there in at least this area of service for injured individuals.
Thank you, Senator. Dean, you're recognized.
Thank you, Madam Chair. Judge Engelhardt, given your 16 years of experience as a judge, do you have an opinion regarding how the proposed requirements regarding, number one, disclosures by plaintiffs, and number two, the admission of all medical bills, would impact the backlog of our court system?
I think it would exacerbate it. These are unnecessary requirements. The disclosure requirements of turning over 30 years of medical information is completely unnecessary, and I have never in that time seen a defendant ask for anything approximating that level of inquiry or that quantity of bills, or that amount of history. It would further exacerbate our backlog, the perceived backlog. And you know, I think it's important to point out that Harris County gets a bad rap, as I say, and people are always talking about a backlog, both in the criminal side and on the civil side. It's also, I think we should point out that Harris County actually has more board-certified attorneys sitting as judges than any other county in Texas. There are really high-quality judges serving now in Harris County, Texas, and they do a good job with these things, and they can make the decisions that they need to make and move their cases along without these additional requirements. If we had to fight about producing 30 years of records, and then those 30 years of records by this bill go into evidence for the jury, it's going to lengthen every single trial because both sides will feel the need to talk about 30 years of medical history of a given plaintiff instead of maybe 2 or 3 years or 5 years of medical history. And then the jury is going to want to pour through 30 years of medical history during their deliberations. I can easily see this on average adding a half a day to a day to each jury trial that we undertake in Harris County.
Thank you. Do you have an opinion regarding how caps on medical negligence cases have impacted litigation in Texas?
Yes, Senator. We have seen caps and I've been practicing over 29 years. So I was licensed in 1995. I'm a proud University of Houston Cougar. And I have seen tort reform both as an attorney and as a judge. And to be fair, it is anecdotal to me as well, but I have certainly heard about reports where the caps on damages have not served Texans. We've heard lots of testimony about folks who have been grievously injured, and that happens in medical negligence cases as well, and those people have lifelong injuries, and because they don't have big economic losses, perhaps they were stay-at-home spouses, their loss of a limb or other grievous injury is capped at $250,000, and that has not changed the rapid decline in the availability of medical services to folks all around Texas. We were told that $250,000 caps on damages would revitalize the medical field and bring back doctors to rural Texas and all over, and the opposite has happened in the lifetime of these caps, Senator. So I don't think additional caps are going to serve Texans any better or make a dent in insurance premiums. Insurance premiums will continue to go up as they have.
Thank you so much. Do you have an opinion regarding how the proposed requirements regarding medical billing affidavits would impact a civil jury trial?
Yes, Senator, although that was something that I thought about or when I got here at about 9 o'clock this morning or when I was preparing. I don't want to waste the committee's time. I kind of forgotten my best thoughts about that topic.
You've forgotten your best.
I just don't remember. I remember. It's been a long day.
Fair.
I can look at my notes if you would like, but I do think that the 1801 billing affidavit system as it is right now is more than sufficient. That's what I wanted to say. It serves its purpose right now. Plaintiff gets, as I said earlier, plaintiff gets to prove up their bills through 18001. If the defendant doesn't counter them, those are the bills that go to the jury. The paid or incurred number and the paid or incurred number is the only number that goes to the jury under the current regime. And so that it's not the gross amount of bills that the doctor has billed. It's a paid or incurred number. The other side gets to file a counter affidavit. Once that's filed, all those bills are off the table unless and until a doctor comes and testifies about the reasonableness and necessity of those bills. And now, given Supreme Court precedent, which we heard about, I think, in Ray Allstate, a CPT code witness can come testify about the reasonableness of those charges in front of the jury, or the defense doctor can come and testify about the reasonableness of those charges in front of the jury. And then the jury, which is when I ran in 2008, I said, I trust juries to make good decisions. And I still believe that. Jurors take all of that into account and make good decisions regularly. And often, those decisions are, like I said, zero or a de minimis recovery for the plaintiff, much more often than they are sizable verdicts.
Thank you. This morning, we heard several witnesses disparage plaintiff's lawyers. And basically, there were terms like cheating lawyers or every plaintiff's lawyer follows a certain playbook, et cetera. Based on your experience as a judge, do you know of any evidence, any data that there are regarding such allegations? And has your perspective been that most attorneys are very professional and there are a few bad apples? Or are those generalizations justified?
I think both sides engage in hyperbole when they're supporting or opposing a bill like this. I have certainly seen plaintiffs' lawyers that I'm ashamed of who come to court unprepared or try to use leverage to win their case, extract a settlement that they might not otherwise be entitled to. It is an adversarial system, though, and both sides use the leverage that they have to maximize the recovery or the lack of recovery for their clients. There are certainly some bad apples, but I've also, when I was a young lawyer, I ran across, I practiced with, on the other side of the case from several defense lawyers who I thought were very unscrupulous as well, because they took advantage of perhaps translation or language barriers. They took advantage of folks who would otherwise be entitled to recover but had citizenship issues. And they took advantage of certain levers of power that they had at their disposal that I thought were somewhat unethical. It happens on both sides of the bar, but you'll be happy to know that in my experience as a judge for 16 years, the great majority of the attorneys that I had the pleasure of presiding over were honorable and doing their very best ethically to represent and advocate for their clients.
And based on that experience, you wouldn't in any way differentiate plaintiffs' lawyers as a group from defense lawyers as a group in terms of standards of conduct?
No, with this caveat. We've been talking today about personal injury attorneys, both on the plaintiff side and on the defense side. But in the life of a Harris County Civil District judge, the car accidents and other catastrophic injuries are maybe about a third of what we see. And there's a lot of business litigation and real estate litigation and debt collections and things like that that we see all the time. And I think on the whole, the personal injury bar is as good or better than, in terms of ethics, than the other 2/3 of the bar that we get to see practicing.
Very good. Thank you, sir. Thank you, Madam Chair.
Thank you, Dean. Senator Birdwell, you're recognized.
Thank you, Madam Chair. I'll try to be quick. Judge, let me say thank you for being here till midnight. Kind of theming on a little bit of Senator Perry, and then of course what you just covered just moments ago with Senator or Dean Zaffirini. Is there a sanction that you as a bench judge would have liked to have had in your holster that, seeing the risk to a business, but you didn't use the word capricious, but what was there was a unscrupulous, maybe been the word you used just a moment ago, on the plaintiff's side, that you would have liked to have had that in your holster to provide a sanction from the bench on an unscrupulous attorney or an unscrupulous tactic on that side of the bench, in a similar way that the defendant may be at risk, but should the plaintiff be at risk, not for their injury, but if the pursuit of their case is unethical, is there such a sanction available to you? And if not,
sure,
what would you want that sanction to be?
Certainly there are tools that a judge can use in that regard.
You did mention some earlier that the defendant can use, like suing for perjury or other things, but is there something that a judge would want to use?
Yes, the judge has discretion under the Texas Rules of Civil Procedure as to how a trial is conducted, and if the judge sees that something unethical or what's the right word? Procedurally incorrect, or one side or the other is taking advantage of something. The judge, I have on many occasions sanctioned one side or the other, either monetarily, or I have eliminated witnesses if they don't follow the rules, and the rules of evidence are, more than anything else, the rules of evidence provide curbs and protections for parties who cannot establish a certain foundation to get certain things into evidence. So if the plaintiff doesn't have the goods, if the plaintiff, this is true for either side, but to answer your question directly, if a plaintiff cannot sufficiently prove the relevance or the other admissibility of a given, because it completely lacks all credibility, I have on more than one occasion prevented the plaintiff's attorney from using that piece of evidence or calling that witness. That is routine. That is well within the discretion that a trial court judge has, and as long as he or she is well versed in the rules of evidence and rules of procedure, he or she can run their courtroom in that way to make sure that the system is running in a fair manner. Okay. And I've done that.
You mentioned, or let me return back to Mr. Philippi of McCoy's. He said that the case, one of those two cases, was dismissed with prejudice. Does that finding give you some other opportunity for sanction? Is there a different sanction than what you've just described if you dismiss something with prejudice?
A dismissal with prejudice sounds worse than it is. A dismissal with prejudice.
Well, that's what I'm getting at. Maybe it ought to be worse than what it is.
Well, you can then you're talking about sanctions. You're talking about whether it's a monetary sanction. You could, creative judges have done lots of things like, if I entered an order of sanctions and I was particularly PO'd at someone, I could order them to file that order with all of the district courts in Texas or all of the district courts in Harris County, so that their reputation for being an unscrupulous, let's just use the word unscrupulous attorney, would precede them into whatever court they found themselves walking into.
Yeah.
But a dismissal with prejudice just means that the case is over and cannot be refiled. A dismissal without prejudice is the opposite. It means it's dismissed, but it could be refiled. So dismissal with prejudice is not some sort of guillotine. It's just a procedural name for the case is over and can't be refiled.
Yeah. You talked about it. You're correct. It's an adversarial position.
Yes, sir.
But it appears to be the adversarial risk for the defendant is enormous, and the adversarial risk for the plaintiff is minimal.
I respectfully
And that's what it seems to feel like.
May I push back a little on that, sir?
Anytime you want to push, Judge, you go ahead.
There are risks on both sides.
Right.
A plaintiff's attorney and a doctor, for example, as many times as they may win a large victory, either as a settlement or as a judgment and collect on that judgment, there are many cases where they also receive zero, and they are risking their own money in a contingency fee case to take a case and take it all the way either through mediation or through trial, and they end up eating a lot of that, right? Yeah. And so there are risks there for them. We have an outsized perception of the size of verdicts and the number of verdicts that are plaintiff's verdicts. And how much, and just because you have a lot of medical bills doesn't mean that the defendant writes you a check. Just because you get a big verdict doesn't mean that the defendant writes you a check. I have lots of big judgments in default judgments that, a default where the defendant doesn't show up and answer, and I win that way, and I go down to court and my client testifies about their injuries, and so I have lovely framed 6-7 figure judgments that are worth nothing because there's nobody on the other side to collect from. So just because you have a big verdict or a big judgment does not translate into money, or doesn't translate into money being paid by the defendant or their insurer. There's all sorts of avenues for appeal, and we know, I think, these days that pretty much all Republican 1st and 14th Courts of Appeals in Houston, and certainly our 9-member Texas Supreme Court, are likely to take away any real sizable judgments that a plaintiff is able to get in the first place.
Okay. Thank you, Judge. I appreciate it. I appreciate learning a bit from you, so thank you.
Thank you.
Thank you, Senator Birdwell. Senator Hinojosa, you're recognized.
Thank you, Madam Chair. And just a quick follow-up on what Senator Birdwell was asking. Isn't it true that you can also, as a judge, issue a summary judgment if you felt it was a frivolous lawsuit? You could just summary judgment and end it?
Yes, if one side or the other moves for a summary judgment, then it is not absolutely routine to dismiss parts of a case or the entire case if there's no merit to it. Summary judgments are very routine.
Could you also issue sanctions or penalties on the offending attorneys?
Yeah, yes, and so in injury cases, as I said, generally you don't get to award attorney's fees to one side or the other, although if one side moved under Chapter 9 or 10 of the Civil Practice and Remedies Code, which allows for sanctions, or Rule 13, or even Rule 215 of the Rules of Civil Procedure, contending that the discovery abuse, for example, was sanctionable, and not at all uncommon to award sanctions against one side or the other in a case.
So in your 16 years, you probably have presided over a number of these personal injury cases, I would imagine?
Hundreds.
Hundreds, okay. How many times have you issued a summary judgment or a sanction?
I would say many dozens of times in personal injury cases and lots more in non-personal injury cases. Personal injury cases are generally very fact-driven, and so if someone was in an accident, you're not likely to be poured out on liability when you have one side with an affidavit saying, I was hurt in this accident and they did this, that, and the other. Usually the police report you'll have a police report or you'll have an expert report talking about liability. So summary judgments on liability in a personal injury case are rare, but they are more common on different elements of damages. So for example, if you can't prove, you don't have any scarring, but you've pled for disfigurement. It's a simple chore to dismiss a disfigurement claim on summary judgment. If you don't have, you can't prove your future medical because you haven't been to the doctor in a long time, and you have no doctor who's given an opinion in a record or an affidavit that you're going to have future medical. You can dismiss the future medical and future.
So to be clear, you personally have issued numerous summary judgments in personal injury cases. It's just
I don't want to. Numerous is in personal injury cases, not as many as in other cases, but
how
certainly.
How many roughly would you say?
Let's say, I don't know, 10 a year, so 160.
10 a year, roughly. Okay. And then how many times have you utilized remittiture to reduce the excessive?
Oh, I'm so glad you asked that. Because the remitter that we're talking about in this bill, I agree with everyone else who said it's completely unlike the actual remitter that is in practice, but that's a really good point. I have been asked precisely 0 times in 16 years to remit a given jury verdict. I've been asked to grant a judgment notwithstanding the verdict, which is a different procedural device. But exactly 0 times have I been asked to remit a jury's verdict.
So the tool that other trial attorneys have testified is a tool to, prevent some of these excessive awards you've awarded 0 times.
It's not that
16 years.
I've not been asked by any lawyer to do so.
Interesting. Okay, thank you.
Thank you, Senator. Members, are there any other questions for these witnesses? All right. Thank you all for being here. Mr. Weaver, is that correct? If you'll come over here to the table so we can get you registered. Is there anyone else wishing to testify on, for, or against Senate Bill 30? Hearing none, public testimony is now closed, and the bill will be left pending.
I thank each one for their testimony. I thank each member for being here and your staff's work on this bill, the committee staff, and all the folks who are going to keep us going. And we did make it till after midnight tonight. And so if there's no other business before the committee stands in recess up to the call of the chair. Good morning.